Typographical error has been corrected in the judgment, my lord. Like
Yes.
that for correction. Paragraph 9, last line, my lord. That should be 2021.
Huh?
That should be 2021 instead of 2024.
31st January.
Yes, my lord.
It
January
is 21st.
Huh?
It should be
2021, my lord.
Which paragraph? Which
Nine-
line?
nine-
Which
paragraph-
page?
Paragraph 9,
page
my
number
lord.
5.
Paragraph 9.
Last
Page
line.
number 5, last line.
It should be 2021 instead of 2024. 31st January.
When the judgment was delivered.
That was delivered, my lord.
After 4 months, you have read the judgment.
My lord, my junior could not go through it, my lord.
Huh?
My junior did not see the judgment. my lord.
Or you are also not called for the what are the judgment.
So I am sorry, I did not.
Dismiss all. इसको to be mentioned मेरे को. Correction. The commercial or non-commercial?
Commercial, my lord.
Commercial then Friday. Who is senior? Yes.
Letters of administration, reading matter.
Okay.
There is no objection.
Which year? देखो टेस्टामेंट में डाल दो. हाँ.
One of listed for adducing the evidence of the attending witness.
Issuance of citation and one is for the witness.
I leave it to your lordship. Your lordship convenient dates, my lord.
Witness वाला को इधर non contentious. All
non-contentious.
वो जो नॉन कॉन्टेस्ट जिसमें विटनेस है ना जनवरी में कोई एक डेट डाल के दे दो और बाकी दो टेस्टामेंट्री में रखो. यस.
My lord, testament matter, my lord.
Who is senior?
I think this strategy is senior.
Maintain seniority mentioning. Yes.
My lord, may I be permitted to mention one matter? This is for filing of accounts in inventory. The letters of administration was granted on 28th of July 2022. I'm out of time. The time is otherwise 6 months and 1 year. So it's otherwise ready. If your lordship would grant me the leave, then it may be filed.
Grant leave.
Grateful.
Yes.
Lord, may I have a Lord's kind leave to mention a matter, my Lord. I'm praying for leave to short serve this application and come back, my Lord, if I can at 3 p.m. Subject to your Lord.
What is the urgency?
I'll indicate, my Lord. This is in connection with the matter already in the list. So there's a second direction. For peremptory directions for discovery and inspection, the defendants have not taken steps. This is the application for striking out of the defense, my Lord. The matter is already in the list. I sought to take leave yesterday, my Lord, but since
which for the other side?
Mr. Shah was appearing, my Lord.
Let the matter come first. Let the matter come first.
At least the short serve leave can be endorsed, my Lord. Thereafter, I leave it upon you, Lord.
Grand. Great. Yes, next.
My lord, may I be permitted to mention one probate application? There was a direction for citation. Everything has been completed. No favorite certificate has been issued. Matter is ready for hearing. I am only beseeching my lord, kindly takes up the matter. Any other subsequent is subject to your lordship's
Testamentary list.
I'm grateful.
My lord, may I have your leave? Yes.
May I be permitted to mention, my lord, a matter which is fixed day after tomorrow, 9. My lord, 5th December at 3 p.m. My lord, this is the order. My lord, I mean, led by Mr. Chaudhary in that matter, my lord, it's fixed for witness action. Due to some personal difficulty, my lord, he will not be in town on 5th. My lord, will kindly fix another date. I'm on notice, my lord.
Calcutta carpets.
At 3 p.m. on 5th, my lord, the matter is fixed.
Okay, you take note of it. Come on 5th.
Yes.
Okay, come on that I will fix again.
My lord, may I have your leave to mention a matter? This is a non-commercial suit for recovery of money as per the express terms of an agreement. There's also part admission. I have filed an application under Chapter 13A. My lord, may kindly take it up for hearing. Listing and hearing.
Chapter 13.
13A of the original side.
Sites.
I've put them on notice, but
Completed.
No, it's the motion stage.
New motion.
New motion. My lord, kindly.
Commercial.
Non-commercial, so that affidavits may be exchanged. My lord, kindly list this man. Grateful.
My lord, may I testamentary matter, my lord. Scrutiny is completed. No objection, my lord.
No objection. Testament is. Yes.
May I mention one matter?
PLA number 487 of 2023, scrutiny has been completed. The one of the legal heirs filed the petition, but other legal heirs not consented.
One legally are given consent,
Mm,
other have not given
Not
consent.
consent.
Citations issued,
Citation issue, kindly issue citation.
citations
on the-
issued. They are not.
No, 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 I am paying for issuance of citation.
Fixed, fixed.
May I be permitted to mention this matter, my lord, the commercial matter, the contempt matter, CC number 17. On 22nd November, rule has been issued, my lord, and the rule has duly been served. And we also went with the special officer, my lord. The matter is supposed to come up in the leaks this today, my lord, as per the last page of the order, page 4. But my lord, the matter has not come up. And there has been no compliance. I can show it to my lordship. Since the only receiver is there, there is a specific direction to remove the signboard, my lord, but they have not removed it. They have just merely covered it.
Just a minute.
May I hand up the copy? No compliance of the order, my lord. They also assured the Laniya special officer to remove it by 24 hours, but they didn't do that. They even didn't remove the tag from the products. In all the products, the name appears. Kindly keep
Why
this
it is not
matter if
disturbed today?
tomorrow, if subject to convenience, my lord. It's a grave urgency.
Supplement, first publish the supplement in the 6 matters है तब कौन 345 fix है then what will happen दो पंजे क्या matter है
They are running the business, my lord, under the same name, no compliance.
क्या 2 p.m.
Great.
Have your lordships kindly to mention three testamentary matters, my lord. My junior who was supposed to mention, well, I am mentioning on his behalf. Scrutiny complete non-consent. My lord, it will be listed. To your lordship's convenient schedule, my lord. I have not
which year matter
2021.
Four,
This year,
four, all four. All four. All 20.
testament put in the list of testament yes
The lordship's leave to mention a matter for extension of time to complete the commission. Well, it's an undefended suit. My learned friend appears for the defendant.
independent suit is upper to defendant
Undefended suit is appearing for he has a right of cross-examination. But the examination in chief is still going on. But I would need one more time.
what is the last date of filing report
On the 12th is the last date for filing. Yes, 12th December.
commercial matter
Commercial matter, my lord. Lordship has extended the time once.
give the number let it come on Friday
Grateful.
to be mentioned extension of time
Great.
My lord, may I be permitted to mention a matter? My lord, this is a testamentary matter. The application for grant of probate is ready and by way of paper publication. My lord, please grant me.
no caveat
No, my lord.
no caveat certificate is filed
Caveat is filed already, my lord.
caveat is filed so
So, my lord, I am paying for inclusion of this matter in the list.
if the caveat is filed then it is you have to take appropriate steps for the conversion into the testamentary suit any objection
No, 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 my lord.
caveat along with the affidavit in support
Yes,
of
yes,
caveat
my
is filed
Yes, yes.
so what can be done if the caveat is filed and affidavit in support of caveat is filed then the suit is to be the PLA application is to be converted into
Now,
the
no, my
testament
lord, caveat is not filed because the application for grant of probate is ready in all respect
Okay.
by way of
Keep
paper
in
publication.
the testamentary list yes
Lordship, may be permitted to mention item number 86 of today's list. Lordship, everything is complete. The evidence is
Commercial?
complete. Commercial.
Ah.
Evidence has been also complete. It has been fixed for arguments. Lordship, it will take me 15 to 20 minutes.
item number
Item number 86.
eighty five 86 86
86. Sai sulfonate.
trisulfate See, if the 2 p.m. matter is not taken, then I will take this matter.
Lordship.
Come at 2. If the 2 p.m. matter will not be taken, then I will
Lordship.
take. Otherwise, I will fix it.
Lordship.
May I be
And-
permitted to mention, Lordship, by an order dated 29 July, Justice Pattanaik had ordered for a special citation to be made to one of the legal heirs residing in Auckland. Now, we made the paper publication that is in East Bay Times, Lordship. But in Auckland, the East Bay Times is published under the edition of Auckland
You
Tribune.
mention, I think.
Yes, Lordship. Lordship wanted to see the portion of the newspaper where Auckland Tribune is mentioned, Lordship. It's in page 15. The last word.
East Bay time.
Yes, Lordship.
So now you want what you want?
Lordship, actually, department is not accepting the affidavit of service, Lordship. Kindly grants me a leave
For
filing the affidavit of service, Lordship.
what the court has allowed?
Lordship, the court has allowed for publication to be made in East Bay Times.
East Bay time.
Yes, Lordship. No,
You have published in?
Lordship, we have published in Auckland Tribune, which is an edition of East Bay Times only.
It is publishing. It is published where the petition resides.
Yes, yes, Lordship. The one of the legal heirs in
One
Auckland.
of the legal.
Yes,
heirs.
Lord.
What is the address?
Lordship, that's in Auckland, Lordship.
Auckland.
Yes, Lordship.
Address 6 Auckland.
Yes, Lordship. He's residing
What
in
is in the
Auckland.
Auckland?
Auckland. Lordship, East Bay Times in Auckland. It is published under the name of Auckland Tribune.
है to be mentioned में रखो कल है ना नहीं कल है ना उसमें टेस्टामेंट्री में टेस्टामेंट्री में ऊपर it will come tomorrow Dolly. Yes,
My lord. Kindly, my lord, have a look at the order of 26th of September. Now, this was fixed on the 25th and 26th of November, but but at the instance of the applicant, because of the personal difficulties of the counsel for the applicant, the matter was fixed on 9th and 10th. I have
not informed.
No. I said 9th and 10th, but I am in
Not
some
available.
personal difficulty. So I have spoken to the other side. They have given a few suggested dates subject to your lordship's convenience. But if it could be fixed on 15th and 16th of January, subject to your lordship's convenience.
May I please appear in this matter virtually? Yeah, I just speak to Mr. Mainak, but I suggested that since I am the one on my legs and I'll take those 2 dates, maybe his junior could be in court and I can argue. Of course, since he accommodated me last time, I also have to return the courtesy.
No,
So because he's
in a
keen that
normal
he-
matter, we would not have objected, but in a matter which is this complicated, my lord, we think that, my lord, it is just a matter of 2 weeks or 3 weeks.
What is so suggested? 14-15 January.
The suggestion, if
Will be convenient to you.
This is based on the dates, available dates given by.
Yeah, 15, 16 January is convenient. No, not a problem.
One of the dates suggested by him.
15 and 16.
Yes.
16, 17. 16, 17.
Very well. 16th, 17th.
17th, I mean, well, 17th, if it could be, then my lord, 14th, 15th, but my learned.
14th, I'm held up. That's what it says. Or 6th, 7th of January, would that be convenient? 6th and 7th of January, because 7th happens to be a holiday in Delhi.
6th, 7th already fixed.
Fixed.
Oh, I see.
Well, on the 16th, no time is possible on the 16th. 16th and 15th.
15 नहीं है 16 and फिर उसके बाद
22nd, 23rd, if that is convenient.
14 and no, 14 is having some difficulty. Mr. Ingorani is having some difficulty. 16 and 20.
No, he wants 2 consecutive dates because he's traveling. He will be traveling for this matter.
Then 2021.
So, well, may I just suggest this? Let the matter be there on the 15th, subject to lordship's convenience. We'll take it up. 15th and 16th.
If that'll be 14, 15. I'll accommodate 14, 15 if that's convenient.
Very well, 14, 15. Deeply obliged.
A fixed time. What time would be fixed?
15 fixed है 16 अच्छा continuous नहीं मिल रहा है 14 is my diary spec.
Oh, I see.
15 is my spec.
No, 16, 17, if that's okay, or 22nd, 23rd, 24th.
Mr. Bose is not available on 17.
22nd, 23rd, 24th, Any of those days?
23rd is a holiday in Calcutta.
Oh, I see.
Yeah, no problem.
That 28, 29, 30th, 31st?
21, 22?
I have no problem, man.
21, 22, Mr. Ingoran?
To 21, I'm in some difficulty. 22, 23, I'm here.
But 23rd is a holiday.
Could it be 28, 29th, if that's convenient?
Absolutely.
28,
29th.
28, 29.
Right, man.
Deeply obliged.
Lord, I have one for the indulgence, my lord. My lord, in your lordship's combined monthly list.
Just I record
My,
this one. As the matter is listed as to be mentioned on the prayer made by the counsel for the decree holder. It is submitted that by an order dated 26th of September 2024, this court has fixed the matter for hearing on 9th and 10th of December 2024. But the counsel for the award holder is having some personal difficulties and paid for fixing the matters to some other date. Considering the submission made by the counsel for the award holder, and with the consent of the learned advocate for the applicant, let the matter appear on 28th and 29th of January 2024 at 25 at 2 p.m.
Grateful, man.
Obliged. Deeply obliged.
Instead of 9th and 10th of December 2020.
My lord,
Yes.
My lord, one for the indulgence, my lord. Combined monthly list, my lord, under new motion. But item number 25 and 26. Well, this matter appeared before your lordship last Wednesday. Well, we were moving the injunction application without notice to the defendants. The defendants appeared and they sought for a copy. So your lordship said, give them a copy, matter will be taken up next day. Well, now, my lord, it is the last two matters in the new motion. Well, only difficult. I'll tell you, lordship, the only reason is that there is a another suit filed by the defendant. We are alleging collusion. So, my lord, there's some protective orders are necessary. So, my lord, any take subject to your lordship's convenience. Now, all I'm saying is that 25, 26 is the last two new motions. If it no, man, non-commercial. Non-commercial. Non-commercial.
New motion में?
But tomorrow your lordship takes some non-commercial.
26 में है.
It starts from
25, 20.
3, 4. So if you
Come.
tomorrow, great.
My lord, may I be permitted to mention non-contentious matter, my lord, for final disposal? All compliance have been complied with, my lord.
Put in the testament list.
Grateful, my lord.
Yes.
Madam, I am for the plaintiff. Madam, we have service to the.
You are for the?
I am for the plaintiff, my lord. Madam, we have service to the defendant last time, but nobody was appeared for the defendant.
But you are not appeared on 26. It was placed in the waiting list.
No, my lord, we have in the last date we have mentioned the matter will be listed on 3rd of December. So
No, 26 it was 19 August it was listed. Plaintiff is granted leave to add the prayer seeking to leave order census and so. Thereafter 26 November you not appeared. It was in the sign हो गया क्यों? Yes, where? So what is the stage of the suit?
So my lord, we have service but didn't appear. They did not appear for
Where is the report?
My
When
report
you
was
lodge
filed.
when you lodge the writ of summons.
My report was filed and it was in the record.
You have to obtain report. What is the report?
Actually, I do
Of
not
the
have-
Sarif? When the writ of summons was served?
My lord, in the last date of 28th.
28th of
November.
Bring the report, then court will take.
My lord, actually, now I do not have the report, so can it be keep on tomorrow?
So appearing for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff submit that the writ of summons was duly served upon the Defendant or defendants? Sole defendant?
Defendant, yes, my lord.
Upon the defendant, but in spite of receipt of the writ of summons, none appears on behalf of the defendant. The plaintiff has not filed any report to show that the writ of summons was served upon the defendant and the defendant has not entered appearance. Accordingly, counsel for the plaintiff prays for time to obtain report to ascertain whether the writ of summons is served upon the defendant or whether the defendant entered appearance or not. In view of the submission made by the counsel for the plaintiff, the case adjourned for within a week or 2 weeks?
A week, my lord.
Within a week. Let the matter adjourn for a week. Let the matter appear on 13th of December 2024. Next. Yes.
Your Lordship, I was a holder of a registered design since
Uh-huh.
2005. Lordship, if kindly takes up AID number 3 of 2017. Lordship, page number 39.
Give record. There's no paper.
Well, I am appearing on behalf of the respondents.
Yes.
I also don't have any
Lord-
documents, my lord. I will request my learned advocate to serve in 2 and 3 both, my lord.
Your Lordship, if you see the date of registered design, Your Lordship, from 2005 to 2020.
Till June 2020.
2020, Your Lordship. Maximum registered design life as per the law is 15 years. Your Lordship, it has expired on 2020. We seek to withdraw the matter.
The time has expired?
Time has expired. Yes, Your Lordship. My appeal has become infructuous.
So and so appearing for the is the appeal. Appellant. So and so appearing for the respondent. The matter is listed as to be mentioned on the prayer made by the counsel for the appellant. Counsel for the appellant submit that as per the certificate of registration of design dated issued by the Controller General of Patent and Design and Trademark dated 25th of July 2014 has expired on 20th June 2020 and thus the appeal preferred by the appellant has become infructuous. Thus the appellant did not want to proceed with the matter further. The counsel for the appellant prays for withdrawal of the appeal. In view of the submission made by the counsel for the appellant, IPDAID 18 of 2024 within bracket old number AID 2 of 2017 is dismissed as withdrawn.
Your Lordship,
Interim order, if any, stand vacated.
Your Lordship, the other item, there is one more, same
order, but what is the number? AID same.
AID 2 of 17.
On date same.
Date same, Your
Certificate.
Lordship. Date same.
So I am appearing in both the matters, my lord.
The name, it will.
My lord. Great.
Yes, next.
We are for the defendant, Your Lordship.
Yes.
They are for the petitioner and the defendant, my lord. We are
My
for the plaintiff and the respondent.
My lord, I am for the defendant, my lord. The witness of the plaintiff is complete, my lord. Now there will be the witness of the defendant, my lord. There will be 2 witnesses. We have taken out one application, my lord, for appointment of the same commissioner. If your lordship so pleases.
My lord, I am appearing for the plaintiff. My lord, our witness action is complete. I do not, my lord, object to this petition, my lord. Kindly permit the same learned commissioner, but only, my lord, one prayer. Since, my lord, in the course of our witness action, my lord, we bore all the expenses. So, my lord, my only prayer is, since it is their witness, they should arrange for the venue and all the expenses.
Yes.
Very great. That's all.
Where I have filed my report with copies and circulated.
so and so appearing for the plaintiff, so and so appearing for the defendant.
No, again,
The Advocate Commissioner is also present. Advocate Commissioner has filed report after serving the copy to the learned counsel for the respective parties. Let the report be kept with the record. Counsel for the plaintiff submitted that the learned commissioner has counsel for the plaintiff submitted the evidence on the side of the plaintiff has been completed and the evidence of the plaintiff is closed. Full stop. The counsel for the defendant submitted the defendant will adduce two witnesses.
Two witnesses.
And he also prayed for appointment of commissioner for examination of the defendant witness on commission. Full stop. In view of the submission made by the counsel for the defendant, the commissioner who was appointed earlier will continue as a commissioner in the present suit and will examine the defendant's witness on commission. Full stop. The remuneration assessed by this court on the earlier occasion shall be remuneration assessed by the court on the earlier occasion being the for the commissioner shall be paid by the defendant for examination of the defendant witness on commission. Full stop.
And all other venue charges and also that would be incurred by us.
Defendant shall also pay all the clerical charges and the other charges of the commissioner at the time of examination of the witness.
My lord, 2 weeks time may be granted, my lord, for filing the judge's brief of document and also
document.
defendant's judge's brief of document, my lord. They have.
What was the fee? 200 GM.
Lordship, that was in order dated 1st of February 2024, Lordship.
200 GM.
It was 15,000 for
15,000. Yeah, what?
Just
But
2
that
weeks.
is the judge's document not
No,
filed.
no, they have filed their judge's brief of document, but that does not include all the documents which we relied, my lord. So naturally, we need to file that judge's brief of documents.
It can't be. A plaintiff
Sir,
has to disclose all the documents in the judgment.
My lord, all right, my lord. Let
The plaintiff is directed to file the affidavit of evidence of the first witness. Plaintiff is directed to file the affidavit of his first witness within 2 weeks from date before the
Commissioner.
Advocate Commissioner. Full stop. After receipt of the affidavit of evidence of the defendant's witness number 1, comma, the commissioner shall fix the date for examination of the defendant witness on commission and to complete the evidence of the defendant defendant's witness on commission within 2 months.
my lord, let it be because two witnesses we will just put our examinations. It depends on my learned.
Within 3 months from date from the date of starting of the examination of
Yes,
the
my lord.
witness act.
Yes.
Full stop.
Deeply
The
obliged, sir.
commission is directed to file the report. File the report before this court on 25th of March 2020.
My lord.
The remuneration is due, Lordship, the plaintiff.
The commissioner submit that the plaintiff has not paid the remuneration, comma, the plaintiff is directed to pay the remuneration of the commission within 2 weeks.
If taken instruction, Lord, it will be cleared. Very deeply placed.
Look, this is the matter where I took the leave in the morning, my lord, to short serve the application. Maybe come back, my lord, on Friday with the application because, my lord, otherwise my application will be rendered in.
Why to be mentioned? Who
My
mentioned
lord, this is
Lordship.
this is
I'll
appearing.
tell you, Lordship. I will like. Yes.
My lord, after directions for discovery and inspection and filing of affidavit of documents, we have written to them on 2 occasions. We have reminded them they have not neither have they
Discovery
taken
has not-
inspection
not been done.
nor have they offered documents for inspection.
There is a
and
fault
nor have they
default.
filed the affidavit of documents. Our affidavit of documents have already been.
Today is fixed for framing of issues.
Yes, my lord. My lord, we have no inspection has been given. Lordship, may we please to frame the issues, my lord?
Lordship has a last chance. We missed it, Lordship. There is a default on our part. I know. Yes.
But we have taken out an
Just-
application, my lord.
Just 10 more days, Lordship, as a preemptory Lordship chance that we will do it, Lordship. It was a fault on our part. I do not have any other.
Affidavit document after serving to the
Yes, yes. Lordship had given us the leave.
complete the inspection down within 2 weeks after puja vacation.
We
This
could
was
not.
the second extension.
I do not, I have no excuse to say anything.
How soon you will
10
complete?
days maximum, Lordship.
Well, let us come. Well, let us come back on Friday. Lordship considers my application. Thereafter,
10
if
days,
your Lordship
Lordship.
feels
Only
it
10
can,
days,
otherwise my
Lordship, as a
application will be rendered infructuous.
peremptory chance, 10 days, Lordship.
Both the defendants.
How many defendants?
2 defendants.
One Milord is the state, and the other Milord is the West Bengal interstate law.
It was highly contested, but we somehow missed it.
Huge claim, not more than 200 crores. Milord.
But that does not mean that they'll seek an extension as per their desires.
Just very
Only till Friday.
WBDIC is very precarious.
Well, their office has already been attached by a coordinate bench. I'm only praying this, Milord. May come back on Friday. They can have a look at the application. Thereafter, your Lordship grants us.
Correct, Mr. Ghosh. Today we are on 3rd.
Yes,
3rd
Milord.
December, correct.
Friday is 6th.
Friday is 6th. I am fixing on 13th. Let it come on 13th. Your application also come. If they will not complete your application,
Yes.
it will
But my application will be rendered
allow. That's why if they will not complete by that time, your application will be
He has
taken. Otherwise,
drafted,
it
he
will
has
be
moved,
taken up.
his professional fees have been taken care of.
Son suffering for the plaintiff, son suffering for the defendant. The matter is fixed today for framing of issues, but the learned counsel for the defendant submit that due to some difficulties, the discovery and inspection of the document could not be completed in terms of the order passed by this court on the earlier occasion. Police counsel for the defendant prays for 10 days time to complete the discovery and inspection of the document as a last chance. Counsel for the plaintiff raised objection and submitted that the plaintiff has already taken out an application for closing the opportunity of the defendant for discovery and inspection of the document, and it will be listed shortly. Consider the submission made by the counsel for the respective parties for the interest of justice and as a matter of last chance, time to complete the discovery and inspection of the document by the defendant is extended by 12th of December 2020, by 11th of December 2024. Full stop. Affidavit of admission and denial be filed by 13th of December 2024. Let the matter appear on 13th of December 2024 for framing of issues. In the meantime, the parties are also directed to exchange their suggested issues.
Well, we give the number of the application. Let the application also appear along with this.
The plaintiff has filed an application being GA number.
Well, we'll get the number today.
GA number
We'll provide your Lordship's
The
officer.
same may be listed on 13th along with CS number 70.
Great.
And I told him today's advocates day, happy advocates day.
Yes,
because
well,
I
happy
didn't
Advocates
understand
Day,
what he
well,
was doing. Still, he was not agreeable.
Mr. Raj would take us out for a dinner.
That I will, but after this, he made it so
I don't think-
adversarial.
Then you have to ask for.
Grateful, my lord.
Yes.
Your Lordship, I'm appearing on behalf of the plaintiff. While last order, Your Lordship, we sought leave of this court for filing the non-starter report, which inadvertently I missed it, Your Lordship. So the same has been filed within time.
You filed?
Yes, Your Lordship, we have filed it. We filed it on 28th of November, Your Lordship. A week time was given.
Yes.
4th July, Your Lordship.
So,
Your Lordship, this is
what
my
you prayed for? What is
Yes.
the leave for?
leave, Your Lordship. Order to Rule 2 leave has already been granted on the last date of hearing, Your Lordship. There's no leave, any other leave, Your Lordship.
Leave granted?
Yes, Your Lordship. On the last date of hearing, it was granted. Your Lordship, the last paragraph.
Order dated?
Your Lordship, the matter was last listed on 25th of November, and we sought leave for order to Rule 2, and it was granted, Your Lordship. I think it is not recorded over here. I sought for leave for order to Rule 2,
No,
Your
no,
Lordship.
that was not on record. That's why the leave is not granted.
I understand, Your Lordship. The prayer page is at page 31.
Leave grant.
Obliged, Your Lordship.
Plaints admitted, subject to scrutiny.
Chief, I'm hearing for the plaintiff.
Yes.
Not I appear for the plaintiff. Somehow my video has been disabled. There's no separate charm in seeing me, but it would have helped if the video was on. This is Shuddhashatta Banerjee. I think your lordship's officers have now it's been allowed. Yes. Lord, just clause 12, leave Lord, contract for sale of goods.
I think you have not gone to the SOP. You have not deposited a fee for bring your photo on the screen. Fee for that.
They should definitely charge me. If I look like this, they must charge.
Yes.
Lord, clause 12, leave, suit for price, contract for sale of goods, defendant outside, agreement within, purchase orders received within, the paragraph 3, paragraph 4, payments within paragraph 24, defendant outside, goods supplied outside. That is paragraph 6, 9 and 12. Mediation has been resorted to, failed.
When the final payment was made?
Final payment, the cause of action repeated is paragraph 20, February 2022 is when they've refused payment to us. That your lordship will find. I'll just indicate the paragraph. Paragraph 31. And thereafter, mediation failure report is at page 77.
Leave under clause 12A, 12 of the letter patent. Print is admitted, subject to scrutiny.
Grateful. 13, my lord, I am for Ashika.
I'm for the respondent, my lord.
Yes. Where is for the print? Where is?
My lord, kindly dismiss. Mr. Kanodia was here. I think Mr. Shah is not available. They were saying that they were going to take some instructions. I'm not too sure, my lord.
Lord, in that case, even I would like to pray for an accommodation for the day.
The board was showing a 7, my lords. The board was showing a 7 items. Mr. Shah had indicated, my lord, he will not be here today, tomorrow. So if my lord could
Friday.
fix 5th of
Friday.
5th.
And he has some problems. If it could be
Thursday,
Thursday, my lord.
if it's possible, Thursday, my lord.
Thursday non-commercial.
কোথায় থাকবে?
But I'm not.
Monday? On Monday?
Asking for time, my lord, I can't stand.
Mr. Banerjee, I don't think he's going to come back before Monday.
No, no.
The prayer made by the counsel for the plaintiff.
Petitioner.
Petitioner. The case is adjourned. Let the matter appear on
9th, my lord.
9th December under the same heading.
Both the matters, my lord. I think, my lord, we'll reach a consensus. I
Come.
think so, my lord.
That's why the
Registered trust deed will come by Monday, my lord. I think.
Yes, he's not a
Grateful, my lord.
But I am for the plaintiff, my lord, in this matter. My lord, the matter was fixed yesterday for witness examination, my lord.
item number
15, my lord.
Yes.
My witness was in the box, my lord. But my lord,
Not
today,
examined.
my lord, it was partly examined. The documents were to be identified because I've already filed my affidavit of evidence, my lord. But then today, since the matter has been called out, the witness is not present in court, my lord. If my lord is pleased to fix it on any other date, my lord, we shall come
Why
back.
your witness is not present today?
My lord, I did not anticipate that the matter will be called on so quickly.
Who is for the other side?
My lord, Mr. Anubhav Sinha was appearing for the other side and Mr. Tiwari.
I'm led by my
You're led.
senior, yes. But Mr. Anubhav Sinha's father demised recently, so he won't be able to come.
And my lord, there is one more, I should indicate this, there is one more application GA2 taken out by the respondents with regard to challenging the jurisdiction. It is in the nature of rejection of a plaint, my lord.
The time had evidence.
Yes, my lord, it was taken out at the time of evidence. My lord would recollect that my lord had imposed cost in respect of the first application where they had sought for recall of the order and asked for referring the matter to mediation. My lord, I am not even certain if that
amount of cost has been paid. But however, my lord, GA2 has been appearing in the list. My lord has directed the matter to come back on 16th of December. So, and my lord may fix this matter anytime after that 17th or 18th.
एविडेंस के लिए क्या डेट देखो दिसंबर में नहीं नहीं 345 मत रखो 3rd January so and so appearing for the plaintiff so and so appearing for the defendant counsel on the matter is fixed for witness action on behalf of the plaintiff. Let the matter appear on 3rd January at 2 p.m.
Much obliged.
For witness action. Next.
My lord, in this matter, I am appearing for the defendant number 1. This is my extension petition for filing written statement. My lord, it is ready, affirmed and presented before the master, but kindly leave me given to taken on record, lordship. My lord,
when you receive the writ of summon?
My lord, writ of summon received on 3rd of August, lordship.
3rd of August?
Yes, lordship. My
It
lord,
expired on 1st of December.
my lord,
120 days.
my lord, we made an application prior to that, my lord. It could not be done due to.
I got
my
the
lord,
copy
my lord,
yesterday
it is,
only.
my lord, it is
After
already.
the matter was
written
No,
statement.
that's correct. That's correct. But you not filed the written statement. The court has granted leave.
Well,
I
that
mean,
it is affirmed, lordship.
when the
Well, on 28th.
why you are not filing the department?
My lord, they are not taking.
What?
Subject
It
to-
is written it.
My lord, since there was a direction, short service leave was given. My lord, there is a indication in the leave. My lord, it has already been filed on 28th. 28th.
I have no
yes,
notice
lordship.
of this.
My lord, kindly see on
I have no-
28th. My lord,
Where is the original written statement? Where is
well,
the
it is already filed in the
That's why I'm
department.
asking. When you
Yes.
file the written
On
statement? in the
28th November. 28th November, lordship.
28 number you filed?
Yes, lordship. Kindly see. In both the matters, lordship, I have filed, lordship. My lord, since there was a leave is granted to file the extension petition with short service outcome of the application. And the written statement is filed within 120 days. My lord, it was within 120 days. Accordingly, immediately after getting the leave, we filed it. And since it is appearing in the lordship's list, lordship, they are not accepting it. They are waiting for the order.
When these applications were moved
Yes.
without notice to us, that
No,
is
no,
the
no.
only thing. No, there was no notice to us. Only yesterday did we get a copy of this application. বিল্ডিং এ তাকিয়ে এইগুলো যখন করেছেন না আমাদের আর 27 তারিখে 28 তারিখে
Do you file the written statement?
Lordship.
Have you received the copy?
No.
Why you not serving the copy?
Well, it is
Not only
been
the
affirmed,
copy of this
lordship.
application also was
Application
not.
short
Application
service-
copy has been served, lord.
It
Application
was,
service,
It
lordship.
was not. We are in the same building.
27
My lord, my lord.
November,
My
short service was ordered.
lord, this is my affidavit of service, lordship. Kindly
He
see,
has
lordship.
sent it by post.
My lord, I have sent it. My lord, since
And
time
which
was
I
short, my lord, I
received
sent.
yesterday in the afternoon.
If it
I will not come in the way.
My lord, as
But
directed by
this-
lordship, we
this is-
henceforth I will not grant any short leave. What is the short leave? Short service.
well, since the time.
Short service is the for the advocate on record, not sent by the speed post. It is recorded short service.
Yes, lordship.
So short service is a speed post.
And we are in the same building. He's on the top floor. I'm on the first floor.
That is on my part, maybe lordship, and this.
Not on my part. The court has recorded something else.
Yes, lordship, my lord.
Leave granted to file extension petition with the short service.
Yes, lordship. Well, I'm giving here and now, lordship.
So and so appearing for the plaintiff, so and so appearing for the sole defendant. Only one defendant.
I'm for the plaintiff.
No, only one defendant.
No, there are 4 defendants.
You are appearing for all.
No, I'm for the defendant number 1.
And what about the other defendant?
And I've already served I have already served copy.
What?
Copy of the application, lordship.
No. What about the nobody's appearing for the other defendants? Someone was served.
Yes.
Yes.
Have you filed a report? You obtained report.
I applied for it. I've not yet got it.
So and so appearing for the plaintiff, and you are appearing for the defendant
Defendant number 1.
So appearing for the defendant number 1. Defendant number 1 has filed an application being GA Com 2 of 2024, praying for extension of time to file return statement on behalf of the defendant number 1. Full list. Counsel for the defendant submit that on 27th of November 2024, the defendant has taken leave from this court to file the application for extension of time, as well as on 28th of November and accordingly on the same day, the defendant number 1 has filed an application for grant of extension of time. Subsequently, on 28th of November 2024, the defendant number 1 has affirmed the return statement and has filed the same in the department. Full stop. Counsel for the defendant submit that the application as well as the return statement have been affirmed and filed in the department within the outer time limit of 120 days and praise for extension or praise for allowing the praise for acceptance of the return statement. Counsel for the plaintiff raised objection and submitted that though this court by an order dated 27/11/2024 had granted leave to the petitioner to file application with the sought service, but the defendant number 1 has served the copy of the application only yesterday.
It was served, because it was served by speed post, which I received in the afternoon yesterday.
It was received only yesterday afternoon through speed post, through postal services. Full stop. Counsel for the defendant number 1 prays for apologize for not serve the copy of the application by way of sorts and by way of hand service instead of sending the same to the postal service. Full stop. Heard the learned counsel for the respective parties. This court find that the writ of summons was served upon the defendant number 1 of 3rd August 2024. And after the receipt of the writ of summons, the defendant number 1 has misplaced the same, and subsequently they have recovered the said writ of summons and duly instructed the learned advocate on record of the defendant number 1 for preparing the written statement and supplied the document, but by that time the time period of 30 days was over, due to which the defendant number 1 could not file the written statement within the period of 31 days, but have prepared the written statement and affirmed the written statement within the outer period of 120 days. Consider the submission made by the counsel for the defendant number 1 for use the record. This court find that on 27/11/2024, the defendant number 1 has prayed for leave to file an application for extension of time and also prayed for leave to file written statement subject to outcome of the application of GA Com 2 of 2024, and accordingly the defendant number 1 has filed the application on 27/11/2024 and filed the written statement after affirmation on 28th of November 2024, that is within the outer period of 120 days. Accordingly, this court find that one opportunity should be given to the defendant to file the written statement, but subject to condition for payment of cost of rupees 5,000. Full stop. The defendant is directed to pay rupees 5,000 to the plaintiff within a week from date. The defendant and the department is directed to accept the written statement subject to his scrutiny. Full stop. The defendant number 1 is directed to serve the copy of the written statement in course of the day. Stated in course of the day. Directed to serve the copy of the written statement to the plaintiff in course of the day. G comes to dispose of. That's all?
Lordship.
Yes.
The next matter is the same.
Well, similar prayer.
And that
Lordship.
is
My lord,
on 9th. They received it on 9th, so it is otherwise the same order.
Same.
my client came to me after 90 days. What can be done, Lordship? It was
What?
Government is
Lordship,
fighting.
Lordship.
Commercial, see the law.
Lordship, I know it. I know.
Then what can be?
Settle
That's why
Lordship,
5,000. I
Lordship,
not put the
Lordship.
30,000. That is also defend number 1.
Yes.
देख लो. Extension time 27 है ना. Next.
For the defendant, my lord, this application, my lord, is for, my lord, time to file written statement, my lord. Now, my lord, this is a transferred suit, my lord, from, my lord, the non-commercial to commercial. Now, my lord, prior to that, my lord,
Non-commercial to
from
commercial.
commercial, my lord, this matter. My lord, we have not been, after being transferred, my lord, we have not been served with a writ of summons, my lord, or, my lord, if you have not been handed over the amended plaint, my lord. So, my lord, the time has not yet started, my lord, we say, my lord. Until unless I have been served, my lord, my time does not start, my lord.
You have filed the application.
But I had filed the application, my lord.
GA3.
GA3. But prior to that, there's also GA1, my lord, which is pending, which is not there in the list today. That application also we have asked for recalling of, my lord, some orders.
What is the GA3?
The GA3 is, my lord, the written statement, my lord,
22nd
extension, my lord.
26 pass order date of 22nd June 2022 passed by the set aside. What is the date of 22nd June? What is the order?
Well, that is the order, my lord, where my lord has ordered, my lord, to beat ex parte, my lord. Take the call.
And not enclosed the order. Where is the order?
Lord, I'm also a little handicapped today, my lord. Because my another GA has come up, my lord.
Page 30 is the order, ma'am.
Page
30 of GA3.
Yes. So when the matter was transferred to this court?
My lord,
By which order? 19 December.
19 December 2023, my lord, was the order, my lord, the commissioner was fixed, my lord. The transfer happened recently, my lord. Transfer to February 2024, my lord.
That order you are not enclosed.
No, my lord, not enclosed, my lord.
So?
Briefটা কোথায়? পুলিশ কি ভাই? অর্ডার কপি তো রাখ এখানে, অর্ডার কপি তো রাখিস নি। অর্ডার কপিতে একটা ফাইল বানা। ওদেরকে বলতে মামলাটা করতে। My lord, on 22nd February 2024, my lord, the order, my lord.
Where is the order?
Let me assist, my lord. The order of transfer is of 5th April 2024.
First
Let I have a
application they had made, 5th April was order. একটা ভাই না ব্রিফ আছে না কিছু আছে তোরা কাজ করতে এরকম করে মামলা করে যায় ঠিক আছে আমি খুঁজে খুঁজে বার করি আমি করি বুঝছে না না তোরা করে যা তোরা অনেক তোরা বিজি লোক করতে হবে তোরা যা সব যায় এখান থেকে বিজি লোক তোরা ওই টাইম নেই তোদের কাছে আমার ব্রিফ নিয়ে চলে যাবে আমার ব্রিফ নিয়ে রাখবে না নিজেদের ব্রিফে তো কিছু নেই
Yes, then?
My lord, thereafter, my lord, the summons required to be served, my lord. And after the transfer, my lord.
You had appeared.
I had appeared, my lord.
Then?
My lord, the suit was required to be a copy of the plaint, my lord. Amended plaint, rather, my lord, required to be served, my lord, not served, my lord. And that is also, my lord, an issue, my lord. But we have taken an application within the time period, my lord, within the 120 days time period, 90 days time period, for an extension of time, my lord, to file the written statement, my lord. My lord, that is the ground, my lord.
Yes. You see?
My lord, I think it's a totally misconceived application, my lord. The suit, writ of summons was served. The defendant appeared, did not file the written statement. Then, my lord, I took a certificate from the department, and on a day when the suit had appeared, I had shown that despite service, they have not filed the writ of the suit was transferred to undefended suit. Then, my lord, on my prayer, a commissioner was appointed for examination of the sole plaintiff witness. The commissioner had examined the witness, and then the witness was discharged. A report was filed. Then it transpired that the suit was commercial in nature, and the order, which my lord has just seen at page 30 of 22nd June 2022, the suit was transferred to undefended suit, and then the suit was transferred to commercial division on 5th of April, which my lord has seen. Now, my lord, at this stage, the defendant once again appeared, and my lord kindly comes to the order at page 33, annexure D. Here, my lord, the defendant once again appeared after when the matter was fixed for argument on that day. And a submission was made that they have a right to argue and a right to cross-examine, despite the fact there is no written statement filed, but they still have a right to argue. But so far as right to argue is concerned, well, I do not come in the way. But there is no right to cross-examination, particularly when they have not appeared on the day when the witness was examined, my lord. So, my lord, they cannot take advantage of their own wrong. They abandon the proceeding. They don't appear. The witness is examined and discharged, and then they belatedly appear and say that I have a right to cross-examine. Perhaps this is not correct. They also allege that the commissioner did not serve them a notice. The commissioner was not required to serve them a notice, my lord, because when the commissioner came into the picture, the suit was already transferred as an undefended suit. The commissioner was not required. Now, my lord, on the point of law that my lord friend has just stated, that after the suit was transferred to commercial division, it is submitted that it was an obligation for the court and the plaintiff to serve the defendant again. But I do not find any such provision, my lord, under the Commercial Courts Act. In fact, section 15(3) of the Act, my lord, is very clear. It says that, my lord, 15(3). Only those procedures which were not complete on the date of transfer shall, my lord. It kindly takes 15(3). Where any suit or application, including application in the Arbitration Conciliation Act relating to a commercial dispute or specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2, the provisions of this act shall apply to those procedures which were not complete at the time of transfer. So the matter does not get reverted back from the stage of summons. This submission perhaps has no legal basis, my lord. So after the suit was transferred, what remained? The argument remained. So they have a right to argue on the papers which are on records. Nothing more than that, my lord. Now, kindly takes the prayer, my lord. The prayer is that they want the order to be recalled, 22nd June to be recalled, and they want a time to file a written statement. This perhaps, my lord, at this belated stage cannot be allowed. Yes. For twin reasons. One, they appeared, they were served with writ of summons, they appeared and chose not to file a written statement. The suit was transferred as undefended suit. And secondly, after the matter has been transferred to commercial division, my lord, there is no provision in law to send a fresh writ of summons to the defendant. So therefore, my lord, in fact, they had also filed a GA2, my lord, which my lord has dismissed by a detailed order. GA2 has been dismissed where they, my lord, asked for rejection of plaint. This is just to, my lord, delay the inevitable, my lord. The matter is now ripe for final arguments, my lord. At this stage, these applications are being filed, my lord. Well, I humbly, my lord, submit this application has to be dismissed, my lord.
And here, my lord, only one thing, my lord. We had taken an application, my lord. There was a report of the commissioner, my lord, where, my lord, which was not served. That's GA1, my lord, where we have asked for, my lord, setting aside of the commissioner's report, my lord. My lord, GA1, my lord, says, my lord, that commissioner, my lord, supposed to give us a right, my lord, we have a right to cross-examine only, my lord. Cross-examine the plaintiff's case. I cannot make my own case. But the plaintiff's case, I have a right, my lord, because when I have entered appearance, it is not that I have not entered appearance, my lord. So, my lord, a notice was required to be served upon me, my lord.
That is different chapter.
No, that is what been submitted. That happened first, my lord. That application GA1, my lord, which has been taken out first, my lord. The GA1, my lord, we have asked for, my lord.
See, GA1 first or second. GA1, you are asking that the commissioner has not given the notice to you. That's why you are not aware of the date of the examination of the witness and commission, so that you could not get the chance to cross-examination of the witness, though you have not filed the written statement on the case of the plaintiff. You can as you are correct.
Yes,
Now, this application you have filed. In this application, you have prayed for extension of time to file written statement on the ground that after the transfer of the suit by an order dated 22nd of June 2022, you have not received the amended copy of the plaint. So your time arose only after the receipt of the amended plaint, and you are
my amended plaint is an extra issue which has been stating, my lord. But my lord, the case is that, my lord, after the suit has been transferred to the commercial court division, my lord. Thereafter, my lord, my rights arise within 120 days, my lord. I have a right to file.
Where from your
That is, my lord, can you, my lord, takes my pleadings, my lord?
Now, where from your pleadings where from you are getting the 120 days after that? You show me. Show me from the law. The court has to fix a fresh line time.
Chapter. ठीक है चलो नहीं
Can you come to 15:4?
No,
Take this.
No, I'm just taking a
15:3. First you read the 15:3, then come to 15:4.
Right. No, the commercial division court as the time may hold case management hearing in respect of such transferred suit or application in order to prescribe new timelines, my lord, or issues such further directions that
may be necessary for speedy disposal.
Right. Now, my lord, here, my lord. Here, my lord, my written statement not been filed late, my lord. Now, my lord, I have not yet the cross-examination, which or the witness action, which has already had completed, my lord. I have not been served, my lord. But I have not been served a notice, my lord. I could not.
What?
Lord, the commission, my lord, which has happened.
That is different. That, that is your challenge in the GA1. That the court will decide at the time of hearing of the GA1 whether you will get the chance to cross-examination for recalling the plaintiff witness. That is different thing. If you want to cross-examination of the plaintiff witness, as you are making an allegation that the commissioner has not given the notice, you could not get that will be decided separately. Correct. That cannot be, and this is not.
My lord, here, my lord, after the transfer had happened, my lord, from the normal to the commercial, my lord.
Correct.
Now, my lord, there is my lord, the commercial court as may be hold, my lord, a case management hearing is required to be held, my lord. Can you, my lord, takes the commercial division of the commercial court, as the case may be, may hold case management hearing in respect of such transferred suit or application in order to prescribe new timeline or issue such further directions as may be necessary for speedy and effectuous disposal of such suit or application in accordance with such and such, my lord. Now, my lord, with regard to that, when this application has been made, my lord, with regard to 15:4, my lord, that to give me a time, my lord, so that I can file a written statement, giving an opportunity, my lord, to file a written statement, my lord. And, my lord, this application has been taken out prior to 120 days being over, my lord. Now, paragraph 24, my lord. Because, my lord, I could not file it because that order was staring on me, my lord. That this already had been made ex parte. Undefended against me.
When the suit was transferred?
Well, the suit was transferred only, my lord, on 5th April 2024, my lord.
Where is that order?
The order was, my lord.
I handed up the order back.
Paragraph 22, my lord. Prior to that, prior to my suit getting transferred, my lord, was already put into the undefended lists, my lord. So I never had the chance to, the order was staring on me. I couldn't file a reinstatement at that point of time. So therefore, my lord, this application is, my lord, only to that purpose, my lord, to give me an opportunity to file a reinstatement, my lord. And thereafter, my lord, the suit, my lord, be heard, my lord.
That's all.
My lord, that is the reason, my lord, we are asking for recalling of the order, my lord, first, my lord, the prayer, my lord, of recalling of the order of setting it from the expiry, my lord, June 22nd, 2022. Kindly, my lord, take.
What was the GA2?
My lord, GA2 was order civil
Rejection of
11.
plaint, my lord.
My lord, for limitation.
On the ground, my lord, that this court does not have jurisdiction.
Yes, my lord.
Dismissed.
This court,
Yes.
commercial court.
Yes.
Commercial court, my lord, the High Court will not have jurisdiction, my lord. That's the issue, my lord.
Where is the order is there?
There's the order, my lord, has been dismissed, my lord. order আছে এখানে 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 নেই এখানে নেই No, kindly, my lord, takes my paragraph 22 and page 7, my lord, once, my lord.
Just a minute, let me see. You have challenged this?
No, my lord, that's not challenge, my lord. Commercial court কোথায় মানে কোথায়
Yes.
Now, my lord, kindly, my lord, takes my page 7, paragraph 22 of my application, my lord.
Page 7?
Paragraph 22, my lord. My application.
In reply, my lord, friend is re-arguing his application. In reply.
That she don't have to.
Yes.
No, I'm sorry that, my lord. But kindly, my lord, takes page 20, paragraph 21 and 22, my lord. But once,
that.
This 120 days was not yet over when my application is taken up. My lord. So, my lord, one opportunity now, my lord, and now I can file my written statement, my lord. And my lord, 15.4, my lord, it says that, my lord, an application in accordance with order 15 rule A, my lord. Now, my lord, with regard to management, my lord. My lord, here, my lord, it is not that the trial has completed here. What has been submitted, my learned friend, my lord, the trial has completed. Trial has not yet completed here. Because, my lord, I have not got an opportunity to cross-examine. If at all my written statement is not there, my lord. So, my lord, trial cannot be said to be completed because I have already taken on an application, my lord, which is pending, my lord. That, my lord, that grants me an opportunity to file for cross-examining the plaintiff's witness.
Correct.
So, my lord, the trial is not yet completed. The issue, my lord, goes back, my lord, where the suit has just been transferred to the commercial, my lord.
Okay.
My lord. Because my GF1 has been taken out much prior, my lord, to the transfer. Yes. No, GA1 has been taken out prior to the transfer has happened, my lord.
Relying upon the clause 4.
My lord.
Correct.
Yes, my lord.
Clause 4 is to be read with order 15.
Yes, my lord.
Capital
Order
A.
15 only, my lord.
Order 15 capital A.
Yes, my lord.
Order 15 capital A starts from the case management. Case management starts only after the return statement. So with regard to the discovery and inspection, and that will come in new guidelines.
Yes, my
Not
lord.
with regard to the return
Inspection,
statement.
discovery also, my lord, I was supposed to, my lord, get a notice, my lord.
That you not come in the suit when the suit was proceeded.
My lord,
Okay, anything further?
my lord, my lord, the question was, my right was closed at that time. I am coming thereafter. It was transferred to commercial court. Prior to transfer to commercial court, when I had taken on an application saying that I have not been served notice. GA1 is that, my lord, I have not been served notice. That has been filed prior to transfer, my lord. Prior to transfer, my lord, has been filed, my lord.
Prior to transfer, you filed, yes.
Yes, my lord. GA1, my lord, has been filed, my lord.
Yes.
Wait, oh, my lord, just my lord, after 1 day after transfer, my lord.
No,
No, my lord. After 1 day transfer, my lord. I shouldn't say that. Wrong statement, my lord. Fine, my lord.
That's all.
Yes, my lord. Only, my lord, kindly gives me an opportunity to file a written statement, my lord. Because my application prior to 120 days, my lord.
So appearing for the plaintiff. So appearing for the defendant. Defendant, sole defendant.
Sole defendant, my lord.
Defendant has filed the present application being GA Com 3 of 2024. Praying for setting aside / recalling of the order dated 22nd of June 2022 passed by this court and for extension of time to file return statement. Full statement. Counsel for the defendant submit that initially the plaintiff has filed the suit before the non-commercial division and non-commercial division, but the defendant non-commercial division and after receipt of writ of summons, the defendant could not appear before this court and by an order dated 22nd of June 2022, this court has placed the matter in the list of undefended suit. He submits that subsequent to placing the matter in the list of undefended suit, the plaintiff has filed an application, plaintiff has on the prayer of the plaintiff, this court has appointed the commissioner for appointment for appointment of commissioner for examination of the witness of the plaintiff on commission. And by an order dated 19th of December 2023, this court has appointed the commissioner for holding commission for examination of the plaintiff's witness. Counsel for the defendant submitted that the defendant has filed a separate application being GA1 of 2024. 2024 for challenging the report of the commissioner and allowing the defendant to cross-examination of the plaintiff witness. Counsel for the plaintiff submitted and defendant submitted. Subsequently, on 22nd of February 2024, the plaintiff has prayed before this court for transfer of the suit from non-commercial division to commercial division.
That's 5th April, my lord.
First, you prayed.
The prayer was on 22nd, thereafter, 5th.
Prayed for from non-commercial division to commercial division, and on the said date, the learned counsel appearing for the defendant raised objection that the suit cannot be transferred. And on the prayer made by the counsel for the defendant, the case was adjourned. On 5th April 2024, this court, in presence of both the parties, has transferred the suit being CS 120 of 2016 from non-commercial division to this court and directed the department to take appropriate steps for amendment in the cause title and also for assigning the number of commercial division in the suit. Assigning the number of commercial suit in the Full stop. The plaintiff was also directed to take appropriate steps within 2 weeks. Full stop. Subsequent to the order dated 25th 5th of April 2024, comma, the defendant has filed an application being GA-Com 2 of 2024, praying for rejection of plaint on the ground that the suit filed by the plaintiff is barred by limitation and there is no cause of action. And at the time of hearing of the said application, comma, the defendant has not pressed the ground of jurisdiction. Accordingly, by an order dated 6th of May 2024, this court has rejected the application filed by the defendant being GA-Com of 2024, GA-Com 2 of 2024, holding that the plaintiff has disclosed sufficient cause of action. It is fine from the record. The plaintiff witness have been examined on commission and the commissioner has also submitted the report. And the matter is fixed for argument. Now the defendant has filed the present application for allowing the defendant to file written statement. The main contention of the defendant is that after the transfer of the suit from the non-commercial division to the commercial division, comma, the plaintiff has to amend the plaint and to serve the copy of the amended plaint so as to enable the defendant to file written statement. But the plaintiff has not taken any steps for supply of the amended plaint, and as such, the defendant could not file written statement. Full stop. Counsel for the defendant further submit that this court has also not fixed any fresh timeline for filing written statement, and within the period of 120 days, outer period of 120 days, comma, the defendant has filed the present application for praying for extension of time to file written statement. Full stop. Counsel for the defendant relied upon subsection 3 of section 15 of the counsel for the plaintiff and defendant prays for extension of time to file written statement. Per contra, an advocate appearing for the plaintiff raised objection and submitted that the defendant had appeared in the suit before the non-commercial division, and the defendant had the knowledge the suit is proceeding as undefended suit. Police of defendant has also had the knowledge that this court has appointed the commissioner for examination of the witness of the plaintiff on commission. When the plaintiff has made submission before this court for transfer of the suit from non-commercial division to commercial division, on that day also the counsel for the defendant had appeared in the matter and raised objection for transfer of the suit. Accordingly, this court, for giving an opportunity to the defendant to argue the matter whether the suit is to be transferred from the non-commercial division to the commercial division, the case was adjourned. Subsequently, on 5th of April 2024, after hearing both the parties, comma, this court has transferred the suit from non-commercial division to commercial division. He submits that after transfer of the suit, comma, the plaintiff and the defendant has taken out an application for rejection of the plaint, but the defendant failed to succeed in the said application. Counsel for the plaintiff submit that there is no provision under the law for giving a fresh timeline after transfer of the suit for filing written statement. After transfer of the suit to the commercial division for filing written statement.
We have lost leave
Written statement. Full stop. Counsel for the plaintiff submit that the application filed by the defendant is misconceived and is liable to be rejected. Had the learned counsel for the respective parties peruse the application and the documents available on record. This court find that initially the plaintiff has filed the suit before the non-commercial division and the writ of summons was duly served upon the defendant, but the defendant choose not to appear in the suit. Accordingly, the case was placed in the list of undefended suit. Full list. Undefended suit. Subsequently, the plaintiff has made a prayer for transfer of the suit from the non-commercial division to this court in presence of the learned counsel for the defendant. Though the defendant has raised objections, subsequently in the presence of the learned advocate for both the parties, this court has transferred the suit from the non-commercial division to commercial division. The plaintiff and the defendant has the contention of the defendant that after the transfer of the suit from the non-commercial division to commercial division, no fresh timeline has been fixed, and as such, the fresh timeline is to be fixed, and the plaintiff and the defendant should get an opportunity to file written statement in the commercial division. Commercial division. Full stop. Section 15, subsection 3 of section 15 and subsection 4 of section 15 reads as follows. 3 and 4. Full stop. In the said provision, it reveals that if the case is transferred from non-commercial division to commercial division, the provisions of this act shall apply to those procedures that were not completed at the time of transfer. In the present suit, the procedure for issuance of writ of summons was duly completed, but the defendant has not entered appearance. Full stop.
Well, they had entered appearance but did not file written statement.
Though the defendant a writ of summons served and defendant had entered appearance but failed to file written statement, and accordingly this court has fixed the suit in the list of undefended. As the suit was for undefended, accordingly on the prayer made by the counsel for the plaintiff, a commissioner was appointed for examination of the plaintiff witness on commission. After completion of the evidence on commission, the plaintiff has made an application, made a prayer before this court for transfer of the suit to the commercial division in presence of the counsel for the defendant. Though initially the defendant has raised objection, subsequently in presence of the learned advocate for the defendant, the case was transferred from the non-commercial division to commercial division. Considering full stop. Subsection 4 of section 15 prescribed a new timeline to be issued for such further direction may be necessary for speedy and efficacious disposal of such suit. Speedy and efficacious disposal of such suit or application in accordance with Order 15 capital A of the Code of Civil Procedure. In the present case, the question of the procedure with respect to the Order 15 capital A does not arise, as the defendant has not filed written statement and has also not prayed for inspection of the document. Instead, the defendant has filed an application for rejection of the plaint, but subsequently the said application was also dismissed. Considering the above, this court did not find any merit in the application for allowing the defendant to for extending the time to file written statement. Accordingly, GA Com 3 of 2024 is dismissed. Yes, what is the dismissed?
Kindly fix a date for argument, Malad, now, because
counsel for the plaintiff submit that the suit is at the stage of argument. Let CS number No, argument full stop. It is fine from the counsel for the defendant submitted. The defendant has filed an application being GA Com 1 of 2024 for appropriate order. Let CS Form 665 2024 along with GA Form 1 of 2024 be listed on 17 December.
Very well.
इसका 120 of 16 अच्छा दो तो मेरा this is not determination 16 suit केटे दें बाकी कर खाली dismiss हो गया ना बस उसके बाद छोड़
Very well.
so how this the application can be recalling of the
Interlocutory and recalling my lord's order.
My application for extension of time to file WS within 120 days. And my lord, the actual delay from 30 days is about 38 days. It's affirmed and ready. I can file it today itself, my lord.
When you receive the writ of summons?
10th of September.
10 September.
10 September, the 30 days period expired on 10th of October within vacation.
To November, December, January.
I have in November filed the application taken out on 18th of November and affirmed written statement on 19th of November.
Yes.
My lord, not stand in the way. Just one thing, my lord. There is no cause that is attributed to the delay. That is all.
Records given to the advocate only in November.
Several conferences and perusal of the document.
That was required to be done. What else is required to be done?
This is exactly what happens. In fact, this is the most truthful petition.
For this page. So appearing for the plaintiff, so appearing for the defendant. Full stop. The defendant is sole defendant.
Sole defendant. Sole
defendant has filed the present application being GA Com 1 of 2024, praying for extension of time to file return statement. Full stop. Counsel for the defendant submit that the defendant has received the writ of summons on 27th of
10 September.
10th of September 2024 and to file return statement within 30 days expired on 10th of October 2024. Full stop. Counsel for the defendant submitted after receipt of the writ of summons, the defendant has contacted the learned advocate on record of the defendant and accordingly on 19th of September 2024 the learned advocate on record entered appearance, but due to the puja vacation, the defendant could not provide all instructions and the document to that could not produce the documents and give further instruction to prepare the written statement. Full stop. Counsel for the defendant submit that after the puja vacation, the advocate on record of the defendant has held conference with the defendant, and after going to the records, the defendant has prepared written statement and affirmed on.
Well, it was a written statement affirmed on 19th of November. This taken out on 18th of November, the application.
19th of November 2024. That is within the outer period of 120 days, and the defendant has filed this application on 21st of November 2024. Counsel for the defendant prays for extension of time to file written statement. Per contra, learned counsel for the plaintiff raised objection and submitted that no cause is shown in the application as to why the defendant has not filed the written statement. And as such, the application filed by the defendant is misconceived and is required to be rejected. Full stop. Heard the learned counsel for the respective parties peruse the application on record. Admittedly, the defendant has received the writ of summons on 9th of September 2024, but has not filed the written
10th of September, my lord.
8th of September.
10th September.
10th of September 2024. 10th of September. Within a period of 30 days. 30 days, but has affirmed the written statement within the outer period of 120 days, and this application was also filed within the outer period of 120 days. Consider the submission made by the consultant. Considering the above, this court find that the defendant has shown a sufficient cause and one opportunity should be given to the defendant to file written statement, but subject to payment of cost. Full stop. Written statement. You are not filed in the department.
My lord, I'm carrying, my lord, without leave I can't file. If your lordship directs, I can file by Monday.
Is directed to cost, na? The defendant is directed to pay the cost of rupees 5,000 to the plaintiff within a week from date. Full stop. The defendant is given liberty to file the written statement in the department by Friday, by 6th of December 2024, after serving the copy to the learned counsel for the plaintiff. The department is directed to accept the written statement after scrutiny by the department. GA-COM 1 of 2024 is disposed. There is no counterclaim.
There is no counterclaim, my lord. No counter. Grateful, my lord.
Next.
Thank you.
My lord, I'm appearing for respond number 1. I've been served with the opposition, but I apologize. My opposition has not come in the right format and I could not file it. I need one more week time to file my opposition to GA1. GA1 is their application.
What is the GA1?
GA1 is the
my
injunction.
application, my lord, for injunction, restraining them from interfering, and my lord was pleased to pass an interim order and extend it from time to time in their presence also.
What is the GA2?
It's a 5 and 8 application on
5 and 8.
arbitration.
It's an application filed by them to which we have filed our objection. Finally.
But you want
I just want 1 week more time to file my opposition to the injunction
in a
application.
proper
GA1.
format?
Yes.
Yes, Mr.
No, I leave it to lordship, my lord.
My lord, one more humble request. If the matter can be fixed, I have my counsel coming in also, other
Must
than
you
Mr.
come?
Kundale, for if 7th or 8th of January, if
Only
I'll-
predicament is this, my lord. I don't say there is any proposition in support of what they have done is they have filed a 5 and 8 asking for referring of this dispute to arbitration, and at the same time they are collaterally proceeding with an arbitration.
Collateral?
They are also proceeding with an arbitration. My lord, candidly
Against whom?
speaking-
You.
Yes, in respect of the same agreement, same dispute.
Arbitrator appointed.
Arbitrator, they had suggested a name, we did not agree, my lord, and we did not agree on 2 grounds. One is this issue is sub judice before this court, and the second thing is this, my lord, that there is no arbiter. That's that. Those are the 2 grounds we did not agree to an
They
arbitration.
filed 11-6.
They have not filed 11-6, they have filed a 5 and 8, to which, my lord,
my lord, the arbitration initiation was before the 5 and 8 was filed by
but
us.
that needs to, he can't avail both forums.
So you issued the notice for appointment.
Yes.
So what steps you are taking further?
My lord, it's before the Singapore International Arbitration Council, which
Doesn't
is the
matter. It's the client is there. I'm saying that either you proceed there and you can't.
Either you have to
then undertake before
stay your hand
Yes.
till the disposal of this.
My lord, let me just take instructions and come back in a week.
Because you cannot, you are proceeding there and coming here. So appearing for the plaintiff, so appearing for the defendant. The plaintiff has filed an application GA-COM 1 of 2024, praying for interim order. Defendant has filed an application GA-COM 2 of 2024 for referring the parties to the arbitration. Full list. Counsel for the defendant submit that. Defendant number 1. How many defendants are there?
4, my lord.
4.
You are called only for 1?
I'm for 1.
My lord, I am appearing for defendant number 4. What about the 2 and 3?
Sir, I am applying for defendant 2, Abhishek Chakravarti.
In person. And what about 3?
My lord, we are not aware.
Sir, all of them, sir.
Huh?
All of them served.
It
It is someone se pega, chita.
No, ऊपर so suffering for the plaintiff. ऊपर बोला नहीं है. So suffering for the plaintiff first. So suffering for the plaintiff. So suffering for the defendant number 1. So suffering for the defendant number 4. and the defendant number 2 is appearing in person. Then appears on behalf of the defendant number 3. Okay. Counsel for the defendant number 1. Submit that though they have affirmed the affidavit in connection GA1 of 2024, but it is not in a proper format and prayed for extension of 1 week time to file affidavit in opposition in proper form. Accordingly, time to file affidavit in opposition in connection with GA1 of 2024 is extended for a period of 1 week. Reply, if any, they are to be filed within a week thereafter. Full stop. As regards GA-Com 2 of 2024, the plaintiff has already filed affidavit in opposition after serving the copy to the London Counsel for the plaintiff and to the defendant. You have filed the affidavit reply?
No, my lord.
You have received?
Yes, I have received.
Counsel for the defendant number 1 prays for time to file affidavit in reply. Full stop. Let affidavit in full stop. Let affidavit in affidavit in reply be filed. How much? One week?
2 weeks, my lord.
2 weeks from date. List. So you are, if you are ready for complete the pleading, then I will fix the date for hearing.
My lord, that would be
Otherwise, I will fix, then your pleadings will not be completed. It will waste of time.
My lord, I believe I can finish it.
Let the matter appear. Give the date in the January.
My lord, just a humble request if it can be done on 7th or 8th of.
Let me see my diary. 7th at 3 p.m. 7th January 2025 at 3 p.m.
The interim order subsisting is expiring on 6th of December.
Counsel for the plaintiff submit that interim order granted earlier is going to be expired on 6th December.
6th of December.
6th of December 2024 and prayed for action of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 10th of January 2024 or until further order, 2025 or until further order, whichever.
Until further orders. And Miller, I believe my learned friends will get advice.
See, I am not recording anything. Please instruct your client.
I will.
सर मेरा प्रेजेंट जो है रिकॉर्ड कर लीजिए रेगुलेशन जो है
क्या हुआ
मेरा प्रेजेंट जो है डिफेंडर 2
हाँ
मैं जो आया हूँ उसका थोड़ा सा रिकॉर्ड के लिए
क्या बोलते हैं आप
मैं जो मतलब यहाँ पे रिकॉर्ड करने के लिए
हाँ रिकॉर्ड कर लिए इन पर्सन है ना आप
हाँ
आप इन पर्सन अपेयर कर रहे हैं मैंने रिकॉर्ड कर लिया
ओके मतलब मुझे रेजुलेशन जमा नहीं करना पड़ेगा रेजुलेशन जो लेके आए जमा नहीं करना पड़ेगा
क्या है वो
He has got a resolution authorizing him to appear, but
he has a resolution which he wants to.
Who are you?
Abhishek Chakravarti.
How is connection?
Defendant number 2, 3.
Number 2.
Jyoti International Food.
International.
Defendant number 2 बोला है ना? Defendant number 2 appeared to the representative Mr.
Abhishek Chakravarti.
Abhishek Chakravarti. The copy of the resolution and the identity card be kept with the record.
Copy. Well, a copy. Can we have a copy of that?
Copy है आपके पास? वकीलों को देना दे दो.
Lord, I am for the petitioner.
Yes.
Lord, your Lordship had originally passed an order of interim order on 10th May 2024. It has been extended from time to time. Last time, your Lordship has extended it on 24th of September 2024.
Till today.
Till today. My Lord kindly extends it.
Who is for the other side?
But we have served. This is our Bangladeshi bank, my Lord. Yeah, this seldom appear. Now, my Lord, but one thing very important, my Lord. Pursuant to the order that was passed by your Lordship, we are trying to attach the bank accounts, which we thought was through accounts. My Lord, nothing substantial is there. We have tried to find out, my Lord, certain other banks of the defendant banks. Lord, kindly allow.
In Bangladesh?
No, we are in Calcutta, Bangladesh. No
Nowadays it is very difficult.
No way of enforcing, especially now very difficult. Well, Lord, kindly allow us to file a supplementary also and fixes the matter, allows the matter to appear a week hence. Lord, I want to make some further prayers, my Lord.
For what?
for my lord, certain other banks to be, my lord, the bank accounts of certain other banks.
So you wanted to file the supplementary
Affidavit and keep it a week later and extend the interim order. My lord, this is the last order.
Yes, it is. Have you read up someone what is the
My lord, Bolo?
affidavit of service filed?
Yes, yes. In this matter, the injunction application affidavit of service was not filed long back. Writ of summons also we have lodged.
Yeah, affidavit service का है. No, affidavit service is not on record.
Affidavit of service it there. Affidavit of service यही matter है. Lord, it says copy था दिन. The injunction, my lord, immediately it has no.
No, nothing. Only extension of time.
Serve करो नहीं.
There is no recording of written.
Where is the affidavit? Huh? Recording नहीं? Recording नहीं हमने.
There is no recording and there is no document itself. Only notice of motion and application. So appearing for the plaintiff. None appears on behalf of the defendant. The counsel for the plaintiff submitted. The interim order granted earlier is going to be expired today and paid for extension of the interim order. Counsel for the plaintiff further submits that the plaintiff is in search of the other accounts of the defendant, and if the plaintiff will get the details of the other accounts of the other bank accounts of the defendant, the plaintiff may be given liberty to file supplementary affidavit disclosing the other bank accounts of the defendant. Consider the submission made by the counsel for the plaintiff. The interim order granted earlier is extended till 3rd of January 2025 or until further order, whichever is earlier. The plaintiff is granted liberty to file supplementary affidavit if the plaintiff finds any further bank account of the defendant in respect of the present suit. Full stop. It is fine from the record. No affidavit of service has been filed. The plaintiff is directed to file the affidavit of service on the next date fix.
But kindly fixes it a week hence, my lord.
No, I am fixed on 3rd. You mention it. If you get, then I will take the matter.
No, I have got the bank accounts.
Okay.
I've got the bank accounts. I'll
Supplementary affidavit.
produce it. I'll file the supplementary affidavit within a week. If it commences to not, it fixes it one day.
Present suit within a week from date. Within a week from date. Let the matter appear on. Let the matter appear on 11th December.
APF for the defendant. my lord.
Yes.
My lord, I was addressing your lordship.
Yes.
On my lord,
Revocation of leave.
revocation of leave.
12A.
Give me the party automation. Only give me one moment. My lord, your lordship, my lord, will recall, my lord, that this is, my lord, actually the third in a sequence of proceedings. My lord, I first filed, my lord, an application under section 17, under section 9, I'm so sorry, of the Arbitration Act. That was, my lord, dismissed, holding, my lord, that it is not maintainable. Then, my lord, I filed a suit, my lord, in the Alipur court. My lord, I ultimately decided, my lord, objections were raised, and I ultimately decided, my lord, that, my lord, it was filed in a court of wrong jurisdiction. My section 9 was over here. So, my lord, with the leave of that court, my lord, I withdrew that suit, my lord, and I have refiled over here. Now, my lord, while I will be relying very heavily on, my lord, on the first two proceedings also, let me, my lord, first, my lord, take, my lord, the proverbial bull by the horn and show to your lordship, my lord, why this entire objection with regard to revocation of leave in my case, my lord, the question does not arise. My lord, kindly have, my lord, the date of filing this suit, which is now, my lord, receiving your lordship's kind consideration. This suit was, my lord, filed on the 20th of May, 2022.
Yes. 20 May.
20th of May 2022. My lord, that is my recording.
ये सूट है क्या? CS है?
And the leave, my lord, was granted on 6th July 2022.
CS 136.
Yes.
Old CS 136.
CS
Yes,
136.
136. What is the date you are telling?
My lord, 20th May.
6th July.
Leave was granted on 6th July.
Yes.
Under 12A. Filing date is 20th May. My lord, your lordship can also take it, my lord, the date of granting of leave to be, my lord, presentation of the date. Yes, my lord. Very well, my lord, your lordship will take it, my lord, as 6th July. So, my lord, this is, my lord, the date of institution of the suit, 6th July. Now, my lord, kindly permit me to hand up partial automation. And, my lord, take your lordship, my lord, straight away, my lord. I am not trying to again, my lord.
It is there.
It's there, very well. Take your lordship, my lord, into what partial automation says, and, my lord, what is the principle laid down. My lord, kindly have paragraph 113.1. But I hope, my lord, your lordship has, my lord, the...
Yes.
My lord, 113.1, we declared that section 12A. My lord, your lord, that's the paragraph, my lord. We declare that section 12A of the Act is mandatory and hold that any suit instituted violating the mandate of 12A must be visited with rejection of the plaint under Order 7, Rule 11. This power can be exercised even suo moto by the court as explained earlier in the judgment. Now, my lord, kindly see. We, however, make this declaration effective from 20th August 2022. So that stakeholders concerned become sufficiently informed. So, my lord, with the utmost of respect, my lord, this mandatory nature, my lord, of, my lord, 12A has been declared by the Supreme Court, my lord, to be in effect and force, my lord, only from 22nd August 2022.
20 August.
So sorry, my lord, 20th August 2022, which is subsequent, my lord, to the filing, my lord, of the suit and the granting of the leave. So, my lord, my first submission for your lordship's kind consideration, my lord, is, my lord, we need not, my lord, delve so much into the law, my lord, what Patil said, my lord, then what, my lord, Yamini said, my lord, all that, my lord, is perhaps, my lord, pales into oblivion. Because, my lord, I am, my lord,
But that's why the 20th August 2022. So why this 20th August has been fixed? Because the prior to filing of the suit, prior to this date, the suit cannot be, party cannot be said that it should be non-suited.
I am so grateful. So, my lord, really speaking, my lord, there were, my lord, lot of conflicting judgments, my lord, before and after. So, my lord, really speaking, my lord, the Supreme Court, my lord, in this judgment says that, look here, violation of 12A, no contemplation of interim reliefs, suit must go. But this mandatory direction, this laying down of the law, my lord, the Supreme Court takes care to say it is going to come into effect from 20th August.
Correct.
So, my lord, the obvious, my lord, implication would be, my lord, that, my lord, before, my lord, this date, my lord, it is not that, my lord, even if there was, my lord, it wouldn't be, my lord, result, my lord, in the failure of the suit or in the rejection of the plaint. I am not abjuring my responsibility to show to your lordship that, my lord, the plaint, my lord, copiously contemplated, my lord, interim orders and, my lord, also, my lord, proceeded, my lord, on that basis. I am not abjuring my responsibility to show your lordship, my lord, the urgency. I am only saying, my lord, that, my lord, this objection taken in a suit filed, my lord, before the 20th of August, my lord, is misplaced. For, my lord, recalling of the leave. I had already, my lord, made my submissions to your lordship, my lord, that unless, my lord, so, my lord, this is a question, my lord, of recalling of the leave. So, my lord, in effect, my lord, your lordships are interfering with the discretion, my lord, exercised by one learned judge. And, my lord, my respectful submission also, my lord, on the previous occasion was that unless, my lord, that can be shown, my lord, it can be shown that that leave has been obtained, my lord, either by somehow misleading the court or suppression or the subsequent event to show, my lord, it was completely, my lord, OTOs, my lord. It, my lord, normally, my lord, the discretion of one learned judge, my lord, is not interfered with. Correct. So, my lord, my first submission for your lordship's kind consideration is that, my lord, suit having been instituted, my lord, before, my lord, 20th of August, my lord. Yes. There was, my lord, no clarity in the law. My lord, at that point of time, my lord, our practice directions had also not come in. And, my lord, the, my lord, basic guidelines, my lord, that Justice Arindam Mukherjee had laid down, my lord, in his judgment, my lord, was also not there. So, my lord, the binding mandatory nature, my lord, which would result in, my lord, failure of the suit or rejection of the plaint, my lord, commence, my lord, from a date, my lord, after, my lord, the filing of my suit. That is, my lord, the first constitution. And, my lord, it is only for this limited proposition, my lord, that I am, my lord, relying on, my lord, Patil. Now, my lord, kindly, my lord, have, although, my lord, I was not troubling your lordship at this juncture, my lord, with GA4, my lord, your lordship, my lord, will permit me to indicate that, my lord, there were two, my lord, urgent interim reliefs, my lord, which I was contemplating. One is, my lord, before that, my lord, I'll just, my lord, digress a little bit by way of background, my lord, in 1 minute. My lord, your lordship will see, my lord, that, my lord, the respondent number 1 is, my lord, RVNL, Rail Vikas Nigam. Respondent number 2 is Siemens. Respondent number 3 is, my lord, another company, and I am, my lord, the petitioner. So, my lord, RVNL had floated a tender in which, my lord, respondent number 2, respondent number 3, and, my lord, the petitioners had formed a consortium and had bid for the tender. And, my lord, our work was equally divided into 3 compartments. My lord, Siemens, my lord, was the leader of the consortium, lead member of the consortium, engaged, my lord, for the civil work and construction. Then, my lord, BPL, my lord, who is the respondent number 3, my lord, they were to do the electrical work. Subsequently, my lord, Siemens took over their part of the contract also. And, my lord, I was the signaling expert. My lord, actually, my lord, mine was the main expertise. But, my lord, so far as I am concerned, my lord, unless, my lord, the construction and the electrification is done, my lord, signaling, my lord, does not, my lord, come into the picture. So, my lord, even if I wanted to, I had the best intentions, I could not really perform. So, my lord, my failure, alleged failure, my lord, to perform my duties is, my lord, on the basis of this cascading effect, my lord, of non-compliance, my lord, by the other 2 contractors. But, my lord, I am not, my lord, taking lordship in the merits. Now, my lord, the reason why I'm mentioning a little bit of background is, my lord, as the leader of the consortium, Simplex, my lord, guaranteed this entire thing, my lord, with the RVNL. So, Simplex gave its own guarantees. And, my lord, we, my lord, as, my lord, joint consortium members, gave back-to-back guarantees to Simplex. Yes. Now, my lord, on the last day, my lord, therefore, my lord, what had happened is, my lord, for the alleged non-performance of the contract, my lord, there was termination. There was invocation of the bank guarantee. So, my lord, one of my principal, my lord, contentions or submissions for your lordship's kind consideration was that, my lord, my bank guarantee, my lord, was at stake. And therefore, my lord, that is, my lord, there can be no greater urgency, my lord, than that. At that juncture, my lord, a my lord, very pertinent question fell from your lordship, that if the bank guarantee is already invoked, then that urgency goes. My lord, twofold reply to that. Number one is, my lord, when I initially came to court by way of the section 9, one of the bank guarantees, my lord, was alive. And they were really clubbed together. So, my lord, in direct reply to what was perhaps troubling your lordship is, when I first came to court by the section 9, and my lord, the suits are really, my lord, because the section 9 was dismissed. So, my lord, I cannot change, my lord, my cause of action or my urgency, my lord.
When the section 9 was dismissed?
My lord, I'll give your lordship those dates, my lord. May I just formulate the point? I'll give your lordship the dates, my lord. I have a small list of
Continue.
So, my lord, my first point is that at the time, my lord, when I initially approached, my lord, the court, under section 9 of the Arbitration Act, out of the 2 bank guarantees, my lord, 1 bank guarantee had been invoked, the other bank guarantee had not been invoked. So, my lord, my urgency was very, very much alive.
So it was continuing.
It was continuing.
Correct.
Now, my lord, the dates in this regard, my lord, I'll just give your lordship. May I just formulate the
Yes,
second aspect of the matter? And, my lord, you have copies, huh? Copy the judge, copy the. Daro, second. My lord, may I other side ki copy the other side ki copy the. My lord, this is. My lord, your lordship will see, my lord, package 2 and package 3. This is, my lord, this is why there are 2 suits also. Now, my lord, termination, my lord, was on 9th November 2017 in respect of package 2. And, my lord, kindly come to serial number 4. Filing of section 9 was on 7th December 2017. Lordship has that, my lord?
Yes.
Now, my lord, at the time, my lord, when, my lord, this was filed, 7th December 2017, my lord, nothing had happened, my lord, in respect of package 3. Kindly see, my lord. Package 3, my lord, termination, my lord, was in 2018 March. Invocation was, my lord, on 31st March 2018, immediately upon termination. My lord, that is, my lord, the invocation of my lord, RVNL. Then, my lord, before that only, my lord, invocation by Simplex had taken place. So, my lord, long after I filed, my lord, the section 9, my lord, the invocations, my lord, in respect of package 3 happened. And, my lord, so far as package 2 is concerned, my lord, I come to court, my lord, after invocation. But, my lord, your lordship will see, my lord, my lord, I am always entitled, my lord, that should be kept in abeyance, money should be returned, and, my lord, points of equity and other things. Because the contract, my lord, is still alive, is yet to be decided, my lord. The rights and obligations of the parties under the contract are still to be decided. So, my lord, I am trying to demonstrate, my lord, from this, my lord, small list of dates, a copy of which, my lord, I have given to my friend, that, my lord, at the point of time when we first, my lord, came to court, package 3, my lord, was completely undisturbed. Neither termination nor invocation of BG. And so far as package 2 is concerned, there was termination and invocation of BG. Of course, my lord, we were fighting about it, my lord. We had immediately come to court in the section 9. It was, my lord, invoked on 9th November. And, my lord, I came on in 7th December, my lord, immediately thereafter.
Yes.
So, my lord, this is, my lord, insofar as my urgency is concerned. While, my lord, your lordship, my lord, has the list of dates, my lord.
Who is for the defendant? You are appearing. Just a minute, Mr. What is your contention?
My contention is, I did not go into the facts that it was 17, that because I only limited my question from the date of filing of the suit. Now, in view of that, 2017, the bank guarantee is invoked. The section 9
different thing. See,
yes,
party they filed the suit July 2020.
Yes, 6
July.
months thereafter. They
Whatever it
slept.
is, 6 July 2020.
Just a
Just
few. Very well. Sorry.
6 July 2020.
Yes.
Our court in the Lakshmi Poly 5 given the date of May 2022. 2020.
Yes.
Subsequently, the Supreme Court has said now it should be at 20th August 2022.
No, Lordship will kindly take 13.3. 113. Lord, may I just please sit? I was just going to place that. So therefore, my lord, may I just place paragraph 55 and thereafter 113(3) of party automation?
Yes, Mr. Shah, let
Yes.
me
That
clarify.
will clarify. I thought of clarifying, but my lord, Mr. Shah was
Paragraph?
arguing with that. I didn't want to.
Paragraph
55.
55.
Another learned judge of the, sorry, my lord, of the High Court of Calcutta in the judgment reported in Dredging and Distillation Co. Limited versus Macintosh took the view that there is a distinction between filing of a suit and institution of a suit under CPC. It was further found that the bar under section 12A is absolute with effect from 12/12/2020. This is the Jurisdictional High Court deciding that 12A is mandatory on and from 12/12/2020.
Correct.
The Lordship will kindly take 113. My senior friend has placed 113(1). Lordship will kindly take 113(3). Finally, if the plaint is filed violating 12A after the Jurisdictional High Court has declared 12A.
Where? Page, paragraph?
113(3.3). Finally, the 113(1) says we declare it to be mandatory from 28/2022.
If the plaint is filed
However,
violating
yes.
12 after Jurisdictional High Court has declared 12A mandatory also, the plaint will not be entitled to the. Okay. Yes.
So therefore, it is in as far as our High Court is concerned, 12/12/2020. 113(1) will not apply. This has been held in subsequent judgments by our Honorable High Court also. My lord, if you Lordship wants, my lord, I'm not carrying it today.
Yes.
Lordship.
Yes, ma'am.
113.3. That is a rider of.
Yes, Mr. Shah. Continue.
Yes. Now, my lord, I'll deal with 113(3). My lord, kindly let me just finish this portion. I'll come back to it. So, my lord, your lordship sees that, my lord, at the time of filing the section 9, my lord, package 3 was completely undisturbed, and, my lord, package 2, my lord, had just been invoked. Thereafter, my lord, I filed, my lord, after, my lord, the section 9 was dismissed on 8th December 2017. My lord, I filed, my lord, after some time, my lord, because, my lord, by that time, my lord, the invocations had already been made. I filed, my lord, on 20th September 2018, my lord, the suit before the Alipur court. That was, my lord, withdrawn with leave, my lord, granted. That is at serial number 9. And then, my lord, I instituted in this court. Now, my lord, your lordship, my lord, will kindly, my lord, therefore, my lord, see that, my lord, this suit is really a continuation of the proceedings, my lord, that I had started, my lord, by way of the section 9. And, my lord, my urgency or, my lord, the cause of action has already arisen, on the basis of which I have already, my lord, approached court. So, my lord, I am not pleading a fresh cause of action. I am not changing the nature and character of the suit. My lord, I am not, my lord, troubling your lordship with this branch of the law, but your lordship knows, my lord, that, my lord, if, my lord, a suit is not maintainable or, my lord, under Order 7, Rule 10, my lord, the plaint is rejected, then, my lord, it goes, my lord, to the other court, which is entitled to, my lord, entertain it. And, my lord, now, my lord, the law also is that, my lord, the date by which it has to be filed there is also has to be stipulated, my lord, by the court, my lord, which is releasing it. So, my lord, it is, my lord, in all respects, the subsequent suit, my lord, is really, my lord, a, my lord, continuation of the old suit, which could not be, my lord, entertained, my lord, at the section 9 stage by the High Court, because the High Court found, my lord, it to be, my lord, otherwise, my lord, jurisdictionally incompetent, my lord, to, my lord, entertain that suit. So, my lord, the point, my lord, that I am trying to urge for your lordship's kind consideration is that, my lord, my urgency, my lord, arose, my lord, first, my lord, on 7th November 2017, when, my lord, termination happened. Thereafter, my lord, on 9th November 2017, my lord, when package 2 was invoked, I immediately came to court. And by that time, my lord, package 3 was completely undisturbed. So, my lord, I was litigating with them. This is, my lord, the first, my lord, leg of my submission for your lordship's kind consideration. Now, my lord, kindly, my lord, permit me, my lord, to make this clear that, my lord, bank guarantee is not my only urgency. My lord, as I had told your lordship, my lord, my lead joint consortium partner was Simplex.
Yes.
And my lord, Simplex, my lord, was in complete doldrums, still is in complete doldrums, but my lord, they are managing to stay afloat. And so, my lord, in the plaint, I had, my lord, made out, my lord, an elaborate ground as to, my lord, if Simplex goes, my lord, into insolvency, and it was, my lord, facing a barrage of insolvency proceedings, then, my lord, if Simplex goes into insolvency, I have no way, my lord, of recovering my claim. So, my lord, I needed interim orders against Simplex. That is, my lord, my GA10, which came much later in point of time. Because, my lord, after, my lord, I filed the suit, my lord, Simplex started managing its affairs, my lord. It was bringing in investors and other things. It is still afloat, as a matter of fact. But, my lord, that is my apprehension. That, my lord, if Simplex, my lord, is admitted into insolvency, then, my lord, I have to stand in line with the creditors. And, my lord, I am an unsecured creditor, my lord, bottom of the list. I don't, my lord, even get my filing fees.
What was the prayer in the suit?
My lord, kindly now have, my lord, the suit, which is, my lord, annexed, my lord, the plaint is annexed to GA4, if I can show your lordship from there. Kindly, my lord, have, at my request, my lord, paragraph 75, which should be, my lord, at running page 57 of GA4.
GA4.
Yes, my lord, that is, my lord, yes. The plaint starts, my lord, from page
67.
Yes, I'm so grateful, my lord. Page 57, my lord, paragraph 75. In addition to the aforesaid 3 bank guarantees, there are a large number of other banks whose dues have not been paid by the respondent number 2, but who have not yet filed any. My lord, may I, my lord? Sorry, my lord, kindly permit me to start, my lord, from paragraph 74.
Mr. Shah.
Yes, my lord.
Actual other matters are there.
Testamentary matters are fixed.
Other
Testamentary
matters are
matters.
there.
Whenever, my lord, your lordship wants me to come back.
Fine. How much time you will take?
My lord, I'll take maximum another 25 minutes, my lord.
And how much you will take?
Half an hour
Half an
maximum.
hour, my lord. 25 minutes to half
कोई
an hour.
डेट है कोई देखो शॉर्ट में कितना कोई फिक्स डेट 1 PM में तो आधा घंटा है उनका हो जाएगा 2 दिन दे दो 1 PM का 2 डेट है कंटिन्यूअस कब है 13th and 16th 13th and 16th 3:45 I'm fixing.
Very well, my lord. 13th is
better.
out.
So and so offering for the plaintiff, so and so offering for the defendant. Counsel for the plaintiff has argued at length in connection with GA2 of 2023, but due to paucity of time, hearing could not be completed. Let the matter appear on 13th December 2024 and 16th December 2024 at 3:45 PM. Don't know, 22, 23. Same. Yes, next.
May it please your lordship. My lord, this is an application for amendment of a petition for letters of administration and the amendment of the affidavit of assets. My lord, a previous application was made by the petitioner, wherein, my lord, an order was passed with regard to allowing all the amendments that were sought for. My lord, the time we approached the department for the purpose of giving effect to the amendments, my lord, the department noticed that through inadvertence, the original paragraph numbers were not deleted and the new paragraph numbers were not inserted. As a result of which the department had suggested that we file a fresh amendment application. My lord, may I just indicate to your lordship, my lord, if your lordship kindly comes to page 16 of this petition.
Yes.
But at page 16 is the previous proposed amendment that we had sought for. My lord, this is page 16 and it is running up to page 31. My lord, the amendment was necessitated on account of the deceased, my lord, who is a Hindu childless widow, having left behind certain properties which she had got by way of a will given by a husband. My lord, your lordship knows under the Hindu law, sections 15 and 16 says that if a deceased widow dies without leaving any children of her own, then, my lord, the property will go back to the husband's heirs. So, my lord, here the husband's heirs are the sisters, 4 sisters of the husband. So, after the filing of this application, some of the children of the heirs, my lord, and the sisters all died. So, my lord, we had brought them on record. My lord, that would show from pages 22, my lord, if your lordship kindly comes. We had explained that previously, my lord, page 22, pages 22, 21, then 23, 24 onwards, my lord. All the legal heirs have been shown, my lord, as to what they are going to be, present heirs would be. As a result of which, my lord, the genealogical table was also.
So this was the earlier
Yes, my
proposed
lord.
amendment.
Yes, my lord.
Which was allowed by this court.
Yes, my lord. By this
order
court.
dated?
Yes, order dated 12th August 2024, pages 9 to 15. If your lordship kindly comes to.
12th August, yes.
Rather, my lord, it starts from page 13.
Violation of instructions in view of the aforesaid, the petition amendment made in paragraph.
Yes.
Yes, A to E.
Yes, my lord, A to E, and my lord, B was only the time within which we were to do the. So his lordship was pleased to give us more time, 4 weeks time. So, my lord, all this was allowed. In effect, my lord, the contents is exactly the same. The present proposed petition is at page 54, annexure D. If your lordship kindly comes, my lord, to page, I just show, my lord, the only difference is the paragraphs. Yes, if your lordship kindly comes to page 66, my lord, running page 66.
Yes.
My lord, through inadvertence, this original paragraph 7 was not struck off. So, my lord, this has to be shown. Paragraph 7, 8, 9, 10.
So that will be 1920.
Yes, my lord. And the following pages, 11, 12, and 13.
Only with regard to paragraph.
Only with regard to paragraphs. That is why the department said that we have to make a fresh application. And the same thing with regard to the affidavit of asset. The substance is all the same. But, my lord, the paragraphs, my lord, proposed affidavit of asset is at page 71. There, my lord, your lordship will also kindly see at page 78. Paragraph 6 was to be deleted and 7 was to be inserted, and 7 was to be deleted and 8 was to be inserted. And, my lord, 1 paragraph here and annexures. So, my lord, these are only the technical corrections for which this fresh amendment had to be made.
Page 77.
Yes, my lord.
E and F.
Yes, my lord.
That is to be deleted.
Yes.
And
78 also.
78.
All that has been given, my lord. EF, that has been given. Now the fresh amendment was required only for changing the paragraphs appearing at page. Yes.
Here only the paragraph.
Only the
not
paragraph.
with regard to the content.
Nothing, my lord. Nothing with regard to the contents. Because contents have already been dealt with, as I've shown in the previous order. Master summons is separate, my lord. I've sorted out the prayers there.
The plaintiff, petitioner. The petition has filed the present application being GA3 of 2024. Praying for leave to amend the petition for letters of administration as well as affidavit of assets as shown in the proposed amendment being annexed D collectively in the present application. Counsel for the petition submitted on the earlier occasion. The petitioner has filed an application being GA2 of 2024, praying for amendment of the application for grant of letters of administration and affidavit of assets, which were collectively marked with letter X and X1. And by an order dated 12th of August 2024, this court has allowed prayer A within bracket small, prayer small a small c rears, small a, comma, small c, comma, small d, and small e of the master summons. In compliance of the order dated 12th August 2024, comma, the plaintiff has taken appropriate steps for amendment of the letters of administration as well as an affidavit of assets, but at the time of amendment, inadvertently the paragraphs of the letters of administration, proposed amendment of the letters of administration has been marked incorrectly, and the department has noted the same, and to correct these paragraphs in the proposed amendment, comma, the petitioner has filed the present application. Consider the submission made by the counsel for the petitioner. This court find that from page 66 to 68, the paragraphs is to be corrected as paragraph 19, 20, 21, 22, 23, 24, 25, and 26 instead of paragraph 7 to 14.
Yes.
As well as, that's all.
And my lord, the affidavit of asset, page 78.
As well as in affidavit of assets, in page 78, the paragraph is to be added as 7 and 8 instead of paragraph 6 and 7.
And the annexures are to be, my lord, from F to A.
And the annexer is to be read as annexer A instead of annexer F.
Yes, ma'am.
Annexer F. Consider the submission made by the counsel for the petitioner, peruse the proposed amendment, and this court find that if the amendment is allowed, nature of character of the application for grant of letter of admission will not change accordingly. Prayer A to E of the master summon is allowed. The police department is directed to carry out the amendment already there.
Well, this, your lordship will kindly specify a date within which this will be done. Previous one was for 4 weeks.
This already B.
Yes, B. The 2 weeks your lordship is keeping, as your lordship please. Coordination. I'm deeply obliged, my lord.
Number 2.
Disposed of. GF4 disposed of. None appears on behalf of the petitioner. Let the matter go out of the list.
Item number 3.
My lord, in item number 3, I beg to appear on behalf of the petitioner.
Yes.
My lord, actually, the matter is in solemn form. All other formalities are complete. So I have mentioned the matter before your lordship on 21st of November. My lordship was pleased to fix the matter on 12th of December, but the matter came to list today. So my lord, kindly fix a date for the witness action. As
many witness?
One.
Only one witness?
One witness. Actually, he is the relative of the deceased.
Is that attesting witness or
attending witness? My lord, kindly fix a date as he resides outside Kolkata.
Counsel for the petitioner submitted that petitioner intend to prove the will in its solemn form by examining the witness. Counsel for the petitioner submitted the petitioner intend to examine one witness. And prayed for fixing the date for examination of the witness. In view of the submission made by the counsel for the petitioner, let the matter appear and give the date for examination witness on 2nd January at 2 p.m. Next.
Number 4.
Nobody is there. None appears on behalf of either. None appears on behalf of the petitioner. Let the matter go out of the list.
Number 5.
But I appear for the petitioner, my lord. But this is letters of administration of the will dated, my lord, 22nd November 2019.
Hmm.
My lord, why letters of administration, my lord? Because the named executor, my lord, died before the probate could be obtained. So the executor's wife now, my lord, has filed this application for obtaining the letters of administration, my lord. My lord, the special citation and general citation were issued, my lord. There are 3 legal heirs, my lord. We kindly take page 4 of my application, my lord. Para 7, my lord. The husband, the son, and the married daughter are the 3 legal heirs.
Husband of the
deceased, my lord, the testatrix.
Son of the testatrix.
And the married daughter of the testatrix, my lord.
Yes.
My lord, the general citation, special citation had been issued, my lord.
Hmm.
And the sheriff's report, my lord, says that the parcels were returned back with the endorsement unclaimed. My lord, and I have also obtained, my lord, a no caveat certificate, my lord.
It is come with the unclaimed, then how the.
But they have not claimed, but that is good service, my lord, in my humble submissions, my lord. And the no caveat certificate also says, my lord, there has been no caveat filed at least till 22nd of September, my lord, 2024.
Publication was made.
Made publication. But publication, my lord, possibly was not made, my lord.
No caveat has entered. Yes.
Yes.
Then.
And there is an affidavit, my lord, of one of the attesting witnesses, my lord, who is the nephew of the testatrix, my lord.
Nephew of the testatrix,
my lord, the son of the originally named executor. Shatodriyo Mukherjee, my lord. That affidavit is also on record, my lord.
When the testatrix died?
My lord, she died on.
What is the name of the testatrix?
Shampa Ganguly, my lord. Also known as Shampa Anujit Ganguly, my lord. The will is dated 22nd November 2019, my lord. She died on 3rd of January 2020.
3rd January?
2020, my lord. The death certificate is annexed, my lord.
Where is the will?
My lord, the will is at page 14, my lord.
Yes. Where is the executor name?
My lord, executor, my lord, will find in my lord, page 17, my lord, paragraph 5.
Brother.
Yes, my lord. My lord, the executor, my lord, died on 5th of May 2021, my lord. His death certificate is also annexed, my lord.
Executor died on
5th May 2021.
Where is the death certificate?
My lord, that is at page 32, my lord.
5th May.
5th May 21.
Yes. And who is the petitioner?
My lord, petitioner is the wife of the executor.
Wife of the
executor. And the son of the executor, my lord, is the one of the attesting witnesses, my lord, who has filed an affidavit.
Wife. Petitioner is the?
My lord, petitioner is the tested, my lord, the petitioner is the wife of the executor, my lord.
Executor?
Yes.
And testatrix died leaving behind 3?
3, my lord. 3 legal heirs.
And no caveat?
No caveat, my lord.
Where is the attesting witness?
My lord, the
in the will?
Declaration, my lord. My lord, the attesting witness at the will, my lord.
Usman Ujit Ganguly.
My lord, kindly takes up page 18, my lord. The second attesting witness, my lord, Shatorudriyo Mukherjee, my lord. He is the son of the originally named executor. He has filed an affidavit, my lord. His declaration is also, my lord, appended to my application. That is at page 11, my lord.
Yes. Census appearing for the petitioner. The petitioners. No, the petitioner.
One petitioner, my lord.
The petitioner has filed the present application for grant of probate and a grant of letters of administration of the last will and testament dated 22nd November 2019 of the testatrix, namely Shampa, SHAMP, Shampa Ganguly, GANGOLY, also known as Shampa Anujit Ganguly. Yeah, Ganguly. Police. Counsel for the petitioner submitted. During the lifetime, the testatrix has executed her last will and testament in presence of two witnesses by appointing one Mr. Rudraroop Mukherjee, RUDRAROOP, Rudraroop Mukherjee, as her sole executor of her last will and testament. Mr. Rudraroop Mukherjee was the husband of the petitioner herein. The testatrix died on 3rd January 2020 and the executor died on 5th of May 2021. The testatrix died leaving behind 3 legal heirs, namely Anujit Ganguly as husband, her husband, Usman Aujit Ganguly, AUSMAN, Usman Aujit Ganguly, son, and Srimati Urmila
Urmimala names are very
Mala Roy as daughter. Counsel for the petitioner submit that the citations were issued, but none has come forward for filing caveat or affidavit in support of it. The counsel for the petitioner submit that the department has submitted a report that no caveat has been entered against the grant of letters of administration of the last will and testament. Full stop. The counsel for the petitioner submitted one of the attesting witness, namely Satadrudriya, SATARUDRIYA Mukherjee, has also filed his affidavit stating that the testatrix has executed her last will and testament dated 22nd of November 2019 in his presence while possessing good health and fit state of mind by appointing the Rudraroop Mukherjee as her sole executor. Counsel for the petition submitted that as none has filed the caveat or affidavit in support of caveat, and one of the attesting witness of the will has categorically stated in his affidavit that the testatrix has executed her last will in his presence while possessing good health and fit state of mind, and as such the petitioner has proved the will and prayed for grant of letters of administration. Had the learned counsel for the petitioner perused the application, original will, death certificate of the testatrix, and death certificate of the executor. Full stop. This court has also considered the affidavit of the attesting witness of the last will and testament. The officer submitted the report no caveat has been entered against grant of letters of administration. Consider the above, this court find that the petitioner has proved the will and is entitled to get the letters of administration letters of administration of the last will and testament dated 22nd of November 2019. The department is directed to grant letters of administration to the petitioner subject to furnishing security of rupees 5 lakhs, 2 sureties.
2 sureties, whatever your lordship.
5 lakhs, 2 sureties. 2 sureties. Sureties upon completion of all formalities.
Great. Obliged.
All formalities. At the time of grant of letters of administration, the copy of the will be made as a part of the letters of administration.
Great.
PLA number 776 is disposed of.
But may I take back the original certificate issued by the registrar? The original certificate.
Next.
Is certificate.
Original private certificate. Yes.
Yes, my lord, I have filed a petition for probate, petition for allowing affidavit of assets. But in the asset, there is a property situated at Delhi. Okay. As per provision of section 200.
Where you are making the submission, okay, and all these things.
Pardon? No, sir. Sorry,
Before
sir.
whom you are making the submission,
No,
sir? You are the 8th person.
Take a pattern, sir.
Yes. What is your prayer?
Prayer is that to allow me to insert a portion that general citation to be issued at Delhi Circuit Court. That
Whether you mention the property
yes,
in the
yes, my lord.
affidavit of assets?
Yes.
Where?
Not in affidavit, in my prayer, in my amendment petition.
What is the application? What is the J1?
Q1 is, my lord.
What you have prayed for in the J1? Only the issuance of citation.
Citation, general citation to the Delhi court.
Correct.
Okay.
But Delhi court with regard to the property situated at Delhi.
Delhi, as
Within
per
the jurisdiction of the Saket.
Yes.
Correct.
Yes.
Whether that property is mentioned in the affidavit of assets.
Yes, my lord.
Where
Yes,
is
my lord.
that? In which serial number? Where is your affidavit of assets? Which serial number you mentioned?
Just a minute, my lord.
Only one bank account.
My lord.
State Bank of India. Nirman Bhavan, Maulana Azad Road, Bunch, New Delhi.
Property situated at Delhi.
Which property? You have mentioned what immovable property.
Immovable
that is the
property.
bank account.
Immovable
Bank
property.
account having 2,000 rupees.
Not bank account, my lord.
Where is that? Where the further property?
In the prior portion, I have not mentioned the general citation, issue of the general citation. I am praying for the inclusion of the affidavit is not with me. That.
So bring for the petitioner. Petitioner has filed the present application being GA1 of 2024, praying for issuance of citation through the office of the Sarif by sending a copy of the citation to the district judge of Saket district for affixation. File this application. Suffering for the petitioner. Petitioner has filed the present application being GA1 of 2024 on the ground that one immovable property being state bank account number 1056961794 at State Bank of India, Nirman Bhavan, Maulana Azad Road, branch, New Delhi, 110011 and premises / flat number 229C, pocket -C, Siddhartha extension, PO Jangpura, police station, Kilokari, New Delhi 110014, having more or less 750 square feet. Seven 50 square feet. Yeah.
My lord, immovable property is there, my lord. That has to be included in the.
But these are the two. One is a bank account, another is the premises plot number.
Yes, my lord.
Another all property is there.
No, only Delhi property.
Delhi property, there is a premises number 229.
Yes, my lord.
Kindly, you are having the affidavit of assets.
Yes, my lord.
Kindly come to the page number 2.
Page number, Delhi property, page number
2, serial number 2. State Bank of India,
Yes.
New Delhi.
Yes, one number 2 Delhi property is here.
And kindly come to the immovable 11. Premises plate number 229.
Shodhpur property.
Consider the submission made by the counsel for
Third
the
Lake property.
Prayer A of the master summon is allowed. GA number 2026. Petition is direct. ठीक है. नहीं छोड़. Next. Prayer A. Prayer A. Yes. None appears on behalf of either none appears on behalf of the petition. Let the matter go out of the list.
I beg to appear on behalf of the executor. There is an application for amendment.
Yes.
My lord, what happened
What
is,
amendment you afraid for?
my lord, the name of the testator has gone down as Saraswati Devi instead of Saraswati Paul. At the time of
PL,
her
where is the
death,
application?
my lord, GA1 is the application. Act I copy. Acha. Your lordship will take my copy. It's an unmarked copy, my lord. But I only have this one GA1, my lord. The death certificate records the name.
What is
as
it in the GA1, sir?
It's amendment of the name of the testator. It should go down as Saraswati Paul.
Where is the PLM in GA1?
I'm sorry, my lord. I handed up the probate petition. My lord. I'm so sorry. Lordship takes the death certificate.
What is the prayer?
My lord, the name of the testator should be Saraswati Paul.
You will going to re-verify even. Proposed amendment indicated red ink. Where is the proposed amendment?
May I just tell your lordship, my lord, that was
Page
the
number?
My lord, that is, I think GA is not here with your lordship, but my lord, the only thing is the name of the
GA
testator is Saraswati Paul. She has signed the will as Saraswati
But I
Paul.
have to see where is the proposed amendment.
I understand.
Which page number? अरे GA नहीं आएगा तो लिस्ट मत करो. जब तक रिकॉर्ड कंप्लीट नहीं आएगा you not to list.
My lord, page 7. The annexure X is page 7. I only have the photocopy, my lord, hence.
Where is the amendment? Only first line?
The cause title, my lord.
Cause title and the paragraph?
Yes, my lord.
These are the portion?
No, this is...
yes, what is the name of the deceased?
Saraswati Paul.
Saraswati Paul. In the will?
Yes, my lord.
Saraswati Paul. Then?
In the will, in the paragraphs of the probate petition and the cause title, my lord.
Saraswati Paul is the name in the will.
Will. The confusion is, my lord, that at the time of her death, the death certificate says Saraswati Devi. That is the only confusion, my lord.
So you have mentioned the Saraswati Devi.
Yes, my lord.
Saraswati,
This is why we had to file it that way, because the death certificate said so.
So appearing for the petitioner. Petitioner has filed the present application being GA1 of 2020 GA1 of 2020, 2023, 2023, praying for amendment in the PLA application with regard to the name of the deceased. Will counsel for the plaintiff petitioner submit that in the will, the name of the testatrix mentioned as Saraswati, S-A-R-S-A-T-I, Saraswati Paul, P-A-U-L, Paul, alias S-A-R-A-S-W-A-T-I, Saraswati Paul. But in the death certificate, the name of the testatrix is recorded as Saraswati, S-A-R-S-A-T-I, Saraswati Devi. And as such, the petitioner has filed the PLA application in the name of Saraswati Devi, alias Saraswati Devi, without mentioning the name alias as Saraswati Paul, alias Saraswati Paul. Accordingly, the petitioner intend to add the name of the testatrix in the PLA application as mentioned in the proposed amendment.
The probate petition.
Consider the submission made by the counsel for the petitioner, peruse the will and the death certificate. Where is the master summon? Where A, B, and C of the master summon is allowed. GS and substantial discord.
I'm grateful, my lord.
Next. None appears. Go out of the list. Next. Yes.
My lord, the testator was the owner of various properties, my lord, situated in West Bengal as well as in outside West Bengal, my lord. My lord, during his lifetime, my lord, he executed a will, my lord, on 26th August 2003, and that was registered, my lord, in Calcutta, my lord. My lord, he bequeathed, my lord, all his properties outside West Bengal in favor of his nephew. And my lord, his brother and brother's wife were the two executors and executors. He appointed brother and brother's wife as the executor and executress. My lord, why he excluded the legal heirs, his legal heirs, my lord, that is written in the will, my lord. That is given in the will. Now, my lord,
whether the citations were issued.
Citations have not yet, my lord. I have.
What you praying for?
My lord, I served notice upon the legal heirs, my lord. His son has expired, predeceased him, and his wife also predeceased him. He left behind, my lord, 4 married daughters and legal heirs of his son, my lord. My lord, all were, my lord, served, my lord. My notice, I served with the notice, my lord. But my lord, thereafter none appeared, my lord. No caveat has been filed, my lord. So, my lord, I am praying for.
That's why I am asking, where is the no caveat certificate?
No caveat certificate, my lord. It is annexed, my lord. My page 51, my lord.
No caveat certificate in page 51.
And no intimation has been received.
Your amendment was allowed?
Yes, my lord. That was allowed on 22nd November 2022, my lord.
But there is no caveat certificate is not here.
It is with the original PL, my lord.
Yes.
I have annexed, my lord. Page 51.
Page 51.
Yes, my lord.
Hmm.
But no intimation.
No intimation has been received by this court from any other court. That is intimation.
Yes, my lord.
Thereafter, this is at the time of filing.
Yes, my lord. At
Then-
the time of filing, my lord.
After filing of the suit, citations were issued. Where
My
is the
lord,
citation?
Citations were not issued, my lord.
Then, if
Citations
the
were not.
citation not, how the now caveat certificate will receive?
Citations were not.
What is your prayer in the main PLA application?
General citation and special citation, my lord.
It was not issued.
No, my lord. And the will is with regard to the properties outside West Bengal. But my lord, it is registered in West Bengal.
Outside of West Bengal. So how the will be here? How you file the suit here?
Well, since it is registered in West Bengal, my lord.
So how the court
And
will
my
grant the will
And my lord,
probate? Yeah, there was a direction prayer in terms of prayer A and B. Where is the citation? You are not ready with the brief. No order.
no, my lord, thereafter no order, my lord.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 26th of August 2023 of the executor Shiv Pratap Singh. Full stop. Let citation be issued in terms of prayer A and B of the application. Okay. Petition is directed to take appropriate steps. Yes, next.
I'm getting.
Item? Yes, none appears. Go out of the list. Take note of it. If this all the if anybody will mention, not to take any mentioning of this and not to list it. If it is going out of the list. Yes, next. Yes.
This is an application for probate of a will, Your Lordship, which has been executed by the deceased in her lifetime on 14th of February 2019, which is at page 11. And
Who are you?
I am the executor.
You are the executor. What is your relation? No relation?
No relation, Your Lordship.
Okay. How many legal heirs left behind?
2 legal heirs, 2 daughters. They have
daughters.
given their consent.
They have given the consent. Where is the consent? Tanuka Sanjeev
And Monica.
Monica Ketchuk. Kitchulu.
Yes.
Yes. Then attesting witness.
And one attesting witness.
Yes.
Champa Mojumdar.
Affidavit of assets. Where is the will?
Will is at page 11, Your Lordship. The
What is the name of the executors?
Debashish Mollik.
Page number? Yes. When the executor died?
No.
Executrix?
Yes.
Testatrix died.
8th of April 2020.
8th April.
Yes.
Leaving behind 2 daughters.
Yes, sir.
What about her wife?
No. She's
What about her husband?
husband is predeceased. Your
Where is the
Lordship.
death certificate?
No death certificate, Your Lordship, with
Where
that
you mention predeceased?
the application. Yes. Paragraph 5, Your Lordship.
5.
5, page 3.
Okay. So appearing for the petitioner. Full stop. The petitioner has filed the present application for grant of probate of the last will and testament dated 14th February 2019 executed by the deceased Manjushri, Manjusri, Manjushri Paul, full stop, by appointing the petitioner as sole executor of her last will and testament in presence of the attesting witnesses. Full stop. Counsel for the petitioner submit that the testatrix died on 8th April 2020, leaving behind two daughters, namely Mrs. Tanuka Sanjeev Joglekar and Mrs. Monica Kichlu. Full stop. Counsel for the petitioner submits that the husband of the petitioner and the executrix was predeceased to the executrix. Full stop. Both the daughters have filed their affidavit of consent stating that they have no objection for grant of probate of the will to the petitioner. One of the attesting witness, namely Shampa Mazumdar, has also filed her affidavit stating that the testatrix has executed her last will and testament in her presence by appointing the petitioner as executor of her last will and testament while possessing good health and fit state of mind. Counsel for the petitioner submit that the petitioner has proved the will and is entitled to get the probate of the last will and testament dated 14th February 2019. Had the learned counsel for the petitioner peruse the application, original will, death certificate, affidavit of consent of both the daughters, and affidavit of the attesting witness. It is found from the record the testatrix has executed her last will and testament by appointing the petitioner as the sole executor of her last will in presence of the witnesses. In presence of witness, one of the attesting witnesses also filed. One of the attesting witness of the will has also filed affidavit stating that the testatrix has executed her last will in her presence while possessing good health and fit state of mind by appointing the petitioner as sole executor. Full stop. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to grant probate to the petitioner after compliance of all formalities. At the time of grant of probate, the copy of the will be made as a part of the probate. PLA number so and so disposal.
Grateful, Your Worship.
Yes.
I can't go and mention now. So you have to do it now in your matters. Milord, Lordship was kind enough. There was an order. Adi Mohini Mohan
Milord, I beg to appear for the alleged contempt.
Milord, there was an order. Milord, order of court has to be complied with. Lordship has passed an order on 22nd November 2024 asking with a direction to comply with the order.
Yes.
Now, Milord, what has happened, Milord? Lordship, this was shown to you, Lordship, in the morning. Lordship, to remove, Milord, the glow sign. That was the part of the order. They have, Milord, basically, Milord, covered it. Now, Milord, this has to be then continuously, whether it's covered, it has to be, Milord, taken away by the court's order. That is not done. Point number 1. Point number 2. Milord, the hoardings are still, Milord, there in the, Milord, the station in question, Milord. This is the hoarding, Milord. Point number 3. There's a specific injunction on the, Milord, trademark also. Tags have to be removed. They say they will take till, Milord, 30th of 7th of December to comply with the order. Now, court's order are to be complied with. For non-compliance, I am before the court, Milord. Milord, they cannot now turn down and impose condition. I'll do in such and such day, and I'll do in such and such day. I have a registered word mark. And he is not, he is someone else. He is not connected with Mohini Mohan Kanjilan.
Yes.
So this, Milord, I
You're
say,
appearing?
Milord.
Yes, Milord.
Yes. What is your
I was the special officer appointed in this matter. And may I serve the copy of the report to the party?
Milord, first of all, Milord, this is the first appearance before your Lordship, Milord, in this matter. Now, Milord, your Lordship has been pleased, Milord, to issue a rule of contempt against us. Now, Milord, the contempt rule has been issued on the premises that there has been a continuous violation of the order. And that is perhaps on the basis of, Milord, the report of the special officer.
Correct.
Now, Milord, may I just draw your Lordship's kind attention, Milord, while issuing a rule of contempt, Milord, the contemptor has to be given an opportunity, Milord, to, Milord, show cause as to why such rule should be issued. Milord, with the deepest of respect, Milord, I submit, Milord, till date, the contempt application has not been served upon us. Milord, without the contempt application being served upon us, Milord, without knowing.
First of all, you tell me whether your client has received the order copy of the injunction or not. Subsequently, I will come to the
Yes, Milord, that
whether
is.
the rule was issued.
Yes, that was, Milord, received.
Second, whether your client has complied with the order or not.
Milord, I would say, Milord, we have partially complied.
Okay, then I am calling your client tomorrow at 10:30 with an affidavit that he has complied with, and immediately I will restrain your client here till the special officer go and inspect and will come say yes, he has complied.
Milord, may I only indicate
No,
one
no,
thing?
tell
Milord,
me.
no, Milord,
You indicate, you stated that it complied it partially. That's why
no, Milord, my learned friend says that, Milord, it has only
I
been
am
covered.
not within. Now it is the you and the
Yes,
court.
yes. But, Milord, without,
Not
Milord,
landed
kindly
by-
appreciates one thing.
Now,
Milord,
first person-
without having a look at what is there in the
Not
contempt
look,
application.
you have looked the order. You have not challenged the order. Order is still there. And the special officer had been there. The special officer report is with the court.
Milord,
That's
special
why the
officer
court
has
has
been-
not issued the rule to be present before this court. Correct. The court has only issued the so-called. But you
Milord,
have.
kindly grants me a week's time to, Milord,
That's
reply.
why I will grant the time, but your client should come first here and file
He
an
may
affidavit.
come, Milord, if
And
your
file an
Lordship.
affidavit he has complied with, then I will
Milord,
give
he
you
should come because
whatever.
that's the rule.
That's let he
Milord,
come
he is,
tomorrow.
I believe, Milord, he is coming today. If your Lordship wants,
Where he is?
Milord, he's on the way. If your Lordship takes it up 3 o'clock, Milord, he'll be there with your Lordship.
And Milord, Lordship knows this is a matter. He opens the email, he sees the order, and he does not come to court. This is,
And
Milord,
that's what I'm
as an
telling. That's
advocate,
why
Milord, will
There
write,
are
Milord.
submissions, Milord, I will make. Whether this is a valid email or not, Milord.
It's a valid email, you have seen it.
The court will look into that. Court will look into that. Because, see, might be other courts is having some other, but this court is having some other rule with regard to the contempt. You go and challenge whatever it is.
No, it's
But
not a
once
question
this
of.
court finds any order, either interim order or the confirm order is violated, then this court is the last court to
Milord,
leave the
I'll
person. And
leave it
you,
to your
I
Lordship's.
don't think you are having any experience with this court with regard to the contempt. Other advocates who are appearing in this court regularly, they are having a good experience
leave
with
it to your
regard to the
Lordship's,
contempt
Milord.
application before this court. The court is not a bazaar passing an order and you violate it. Court has passed an order giving a time. You received the letter, you received the order, you received the mail. Man, the court has fixed. You have not come to the court. No, my lord, this is not the correct order. You have not challenged the order. When the court has issued the rule, then you are showing the rule to this court.
No, my lord, it's not that case, my lord.
Then
Look,
I am asking one thing. Let your client come, say all the thing. Let 3 p.m. I will send. Might be 6 p.m. I will again send my local officer. That cost is to be bear by you. Mind it. You are telling that your client is coming. I am waiting the 3 p.m. 3 p.m.
Only one difficulty, my lord, I will say to your lordship.
No difficulty.
Kindly
no.
appreciate me.
You are-
Kindly hear me
just
for a
you
moment, my
are
lord.
in open court, your junior stated that he is on the way. And you are asked for the 3 p.m. I am fixing at 3 p.m. No problem.
No, my lord, that is a separate issue, my lord. Your lordship is on the issue that, my lord, we did not appear. My lord, what your
Yes,
lordship...
why you are not up
Yes,
here?
my lord, lordship will kindly see the last order which your lordship has passed. No, the matter was returnable on 19th, but the matter came up on 18th.
Okay.
So it came a day before, my lord. That is why my lord missed. Thereafter, my lord, this order was issued, my lord, the contempt rule was issued.
Okay.
But we did not have a sufficient opportunity, my lord.
Today, if on that day rule was issued, today morning you could have been mentioned the matter, my lord, the wrong order has been issued.
I would never say that the court has passed a wrong order. My lord, until and unless, my lord, I fully ascertain, my lord, I am being told that he is...
was returnable. He is incorrectly, my lord, instructed. Matter was returnable since jurisdiction before Justice Kapoor. He was not there. It was extended. He continued to violate. Then I came to this court. My learned friend should take up proper instruction before making this submission, my lord. No vacating. He could have applied for vacating.
The client is coming. Let come. I'll see how the this court know how the court how the order is to be implemented.
My lord, I leave it to your lordship. If there is a violation, my lord, he should be taken to task.
Normally, first day,
My lord,
people
to the
come and
extent,
ask.
my lord, I have to ascertain, my lord, when he says, my lord, he had partially complied with and perhaps...
Partially, why partially?
My lord,
Court
to
has
what
given the
extent he has
partially.
not complied and why he
When
could
the
not
order was
comply.
passed, sir, when the order was passed.
But I have to ascertain to what extent he has
30th
not complied
September.
with.
Let it come.
Before puja, I was told to move this. I said, don't do it. It's
Mr.
puja.
Devnath, I am the court is still looking into the matter.
I'm sorry, my lord.
What time he will be here?
He'll be there, my lord, by 3.
What time?
By 3, my lord.
Okay, when you come, please mention.
Yes,
I
ma'am.
will take it. Pass over.
Lordship, I am appearing for the petitioner, my lord.
Item number?
8, my lord.
Yes.
My lord, this was heard by your lordship at length. My lord, though it's an IP matter, my lord, I had beseeched before your lordship on the last day, if like since the other side was also not appearing for the last 2 days, if your lordship can, my lord, by consent and can treat it as parted as on days
No,
basis.
no.
And
it is not mentioned as a parted.
no, it's
How
not.
could the
It's
court-
not. It's not.
Then I am releasing it.
My lord, only one thing, 2 things, my lord, before releasing, if your lordship can record. My lord, one, the interim order is expiring today.
That I will.
That is one. Secondly, my lord, Justice Kapoor has come down very heavily on the writ of summons not being served. Now, that is sometimes, my lord, that's not in the
That
hand. My lord,
I am not
my lord,
commenting on the
I'm
other
not saying.
court.
I'm not saying anything. My lord, the records are lying in court for a long time. If you the plaint, the scrutiny cannot be done because the records are lying in court. To that extent, if it is mentioned, that the records are lying, it has to be sent back to the department for scrutiny purpose. That is sufficient. That's more than that, I'm not saying.
Though the matter is fixed today as a special fixed matter before this court, but this is the intellectual property matter, intellectual property matter, and filed in the year 2023, and as such, this court is not having the determination to hear the present suit. Accordingly, present suit full stop. Counsel for the plaintiff submit that the interim order granted earlier by this court is going to be expired today.
Today, my lord.
Today, and prayed for extension of the interim order. Fully, counsel for the plaintiff further submit that as at the time of filing of the suit, the plaintiff has filed the interlocutory application, and this court has taken the interlocutory application for hearing, and thus the record of the suit along with the interlocutory application remain with this court, due to which the department could not.
Well, the plaint also is
along with the plaint. Along with the suit means the plaint.
brief.
Suit within bracket कर दो, plaint कर दो.
Grateful.
This, due to which the department could not able to scrutinize the plaint. In view of the above, the interim order granted earlier is extended till 20 December 2024 or until further order, whichever earlier. Full stop. The suit along with the interlocutory
Maybe till the first week of January.
Other courts, so with more than 2 weeks, it is not good for this court to extend. At application released from the list of this court to be placed before the appropriate bench having determination. Grateful. Next.
Lordship, in the morning I had mentioned, your Lordship,
which one?
Indicated item number 86.
Yes. 80?
86.
86, yes.
Up to date.
For the 86.
Lordship, before I start with my submissions, I have prepared one skeleton notes for your Lordship's ease. This matter has been proceeding ex parte.
What is the suit for?
The suit is for sale of goods, and we have delivered goods.
By which order the suit was undependent?
At the last page of the judge's brief of document, the order has been annexed. Order dated July 5, 2024.
55? Page 55?
Page 55.
Yes.
Lordship.
So this for recovery of money?
This is for recovery of money.
Yes.
We have raised invoices. And they have produced purchase orders. We have done the delivery. The delivery is complete. It was not objected to. And thereafter, they have made part payments, issued checks, but they have failed to make any payment. Before I indicate with the documents, Lordship, this is the deposition, copy of the deposition. I'm providing with a copy because there are two small typographical errors. So, with pencil, I've corrected those two. Lordship, this suit was filed by virtue of the resolution, which is Exhibit A. Exhibit A. The page number is not page number 1. The page number starts 1 starts from the next page.
Yes.
The resolution in Exhibit A.
Yes.
The purchase orders starts from page 1 to page 3. And in correspondence with the purchase orders, I would refer question 5 of the deposition, which says that the question goes, kindly have a look at these documents and tell the Honorable Court what are these documents.
Yes.
And the witness replies, these are the purchase orders.
Okay, whatever it is a purchase order.
I am not going to go
Even
through
to
yes.
P3.
1 to 3 purchase orders.
That's the purchase order.
Yes.
Yes.
Thereafter, there was agreed consideration.
Yeah, issued by?
issued by the defendant.
Defendant has issued to you.
Yes.
For supply of material.
For supply of HED barrels.
Correct.
Thereafter, the delivery challans are there. Now, she page 4 to 9 of the judge's brief of documents.
This is the bill.
Challenge, delivery challenge. These evidences that we have made the delivery from page 4 to 9. These are also with the typed copies.
Page to 9.
Yes, 4 to 9.
4 to 9.
4 to 9.
Yes. The delivery challan.
Delivery challenge.
Delivered to the defendant.
Delivered to the defendants.
Yes.
Thereafter, we have raised tax invoices regarding the payments.
Yes.
The tax invoices starts from page 10 to 12.
Page 10 to 12.
Yes. One thing I need to indicate it. Lordship kindly takes up page 10. Along with it, if your Lordship also takes up page 4 and 5, it will be indicated that the invoice number.
Page 4 and 5.
Yes. 10 in correspondence with 4 and 5. 5 is the typed copy.
Yes. Invoice.
Yes. Invoice number at the top right. It is written and it tallies with the invoice number in the middle portion of the typed copy as well as the original evidence.
4768.
Yes.
Where it is mentioned?
Not 6744, Lordship. WB 22-23-120495.
Where it is? Page number 5?
Page number 5, this part. This part.
Achha. Invoice.
Yes. And the motor vehicle number is also mentioned. And in regard of this particular tax invoice, it was agreed that the terms of payment would be made within 15 days. That is in beside the invoice, right side. Mode / terms of payment 15 days. And if your Lordship comes to
where it is 15 days?
15 days.
Where
This
it
part.
is mentioned?
Mode terms of payment. Right side.
Page 10?
Page 10. I'm referring to page 10.
Page 10?
Page 10.
Mode of terms 15 days.
Yes.
Yes.
In regard of this challan again, if your Lordship kindly comes to a little down part of the portion, the terms of the delivery is mentioned. Please make payments strictly by NEFT or other electronic modes as prescribed. Interest at 18% per annum will be charged if payments are received beyond due date. I would refer to this term.
18%.
18%.
Interest 18% will be charged if the payment are received beyond the due date. Beyond the due date means after 15 days.
After 15 days.
Yes.
Lordship, page 11 and 12 are also tax invoices, but the terms of the payment, it's the due starts after 30 days. In respect of that invoice, only 15. In respect
First
of
is the 15 days, second are the 30 days.
30 days.
Yes. Then
And this also tallies with the delivery challenge.
yes.
Next point. I've also indicated the interest part of it. That is also that has been also agreed upon. Now, the total amount in regard to the 3 tax invoices came to around 11,65,368. However, there was 12,447 rupees excessively paid for a different transaction that was adjusted, and thereafter 11,52,920 was due.
Total 11 lakh?
11,52,920 was due. Thereafter, the defendant on March 23rd, 2023 made a payment of 1,50,000. If you lost 1,50,000.
50.
Yes.
Yes. Then
Lordship, I will indicate the bank statement. If your Lordship comes to page 35, the folded portion of the statement of accounts.
yes.
This indicates that the defendant
35.
Sixth line of the statements, March 31st.
31st March 2023.
Yes.
5 lakhs.
Lordship, sixth portion. Sixth line, March 31st.
Yes, 6th portion.
Yes.
31st of March 2023.
Yes. 1,50,000. They've made a payment. And it is indicated that Sai Sulfonates Private Limited has made the payment.
1,50,000.
Yes. It is there. And thereafter, in page 51, there is
So
another
1,50,000 has been credited.
credited.
So remaining 1,19,000.
Another 50,000 was also paid by them. That is in page 51.
51.
Seventh line. On September 27, 2023.
Page number?
51.
51.
Yes.
Yes.
Seventh line, 50,000.
50,000.
They have made payment.
Yes. So 11 lakh. What was the remaining?
The remaining amount would be 9,52,000. And clubbed with the interest component, the total due comes around 12,24,444.
Okay.
Thereafter, the defendants has issued checks.
So as per your case, the total amount was 1 lakh 11 lakh 52.
11 lakh
52 5,920.
Yes.
Correct. He has paid 1,50,000. 2 lakh he has paid.
2 lakh. Yes.
If he has paid the 2 lakhs, so 9,52 remains.
52 remaining and clubbed with the
And
interest
then you have
component, that is
concluded
that.
the interest.
Yes. I will also indicate
So
that
September, 27 September.
yes, 2023.
Yes.
This is the first admission. Next admission, Lordship, they have issued checks on August 20, 2022. That is, that starts from page 13 of my speech.
Yes.
Page 13. It is indicated that they have issued checks. The signatures are there. Corresponding question would be
So this is prior to the payment.
yes, prior to the payment. There. The
So this all checks has been dishonored.
everything
Funds
has been
insufficient.
dishonored.
Okay.
Corresponding questions would be question 12 of the deposition. The return memo is also there. It starts from 13 to 20. Page number 13 to 20. Thereafter, on July 17, 2023, before the second part payment was made, we had the advocate for the plaintiffs had issued a demand notice that starts from page 21
Yes.
to 25. However, the amount, if your lordship looks at page 25, the final amount was 10,02,920. That is because the part payment was not yet made. However, they have failed to make any payment of the rest of the amount. This was also delivered.
No, see, he has issued 1,98,000, 19 lakh. What is the check amount?
1,98,000 two checks and another 2 checks for 2 lakhs.
Okay. Okay. Yes.
Yes.
Both are dishonored. Then
Four
you issued the
checks.
notice. At
They
that
were-
time, the principal amount was 10 lakh.
At that time, the principal amount was 10 lakhs.
10 lakh.
10 lakhs.
So how the principal amount increased 11 lakh?
Lordship, it did not increase to 11 lakhs.
Why you have given the 10 lakh notice?
Lordship, the initial principal amount was 11,52,000. Thereafter, they paid 1,50,000.
No, 1,50,000 they paid in March 23.
Yes.
But you had, July 20. Okay.
Yes, July.
Yes.
And with the interest, it's 11,89,000. Thereafter, that notice was received by them. At page number 27 is the track report, which shows that the item was delivered to the addressee. Thereafter, at page number 54, we had initiated mediation as per the statutory mandate. That mediation non-starter report is there at page number 54.
Then you file the suit.
I have filed the suit. Lordship, there is one reported judgment of your Lordship. I am relying on that. I am not reading that. Lordship, it was reported in 2023 SCC Online Cal 1883, Mita Surana versus Surendra Singh Bengani, in its paragraph number 23 to 32. I'm not going to bother your Lordship by reading that. That is annexed with the skeleton notes.
That's all.
That's all.
Census and suffering for the plaintiff. This case is fixed today for argument. The plaintiff has filed the suit for recovery of an amount of rupees 12 lakh. Just a minute. 70. Lakh 24,444.55 along with interest. At the rate of 18% per annum till the realization of the setup. It is fine from the report. After filing of the suit, the plaintiff has taken appropriate steps for issuance of writ of summons. After issuance of writ of summons, on receipt of writ of summons, defendant entered appearance, but has not filed return statement and not filed return statement. The defendant has filed an application being GA-Com 1 of 2024, praying for extension of time to file return statement. But when the matter was taken up for hearing on 5th of July 2024, none has moved the said application. Accordingly, the same was rejected on the ground that the defendant, beyond the period of 1 even the defendant failed to file the written statement even within the extended period of 120 days, and the suit was proceeded as undefended against undefended suit. The plaintiff has examined one witness in his favor. Plaintiff has examined one witness in support of the case of the plaintiff. During his examination, altogether, exhibit A, B, C, D, E, F, G, H. Altogether, 7. 7 documents were marked as exhibit A to H. As per the case of the plaintiff, the defendant has placed as per the case of the plaintiff, during the course of the business between the plaintiff and the defendant, the defendant has placed the purchase order to the plaintiff for supply of what are the goods?
HDE barrels.
HDPE barrel. And accordingly, as per the purchase order issued by the defendant, comma, the plaintiff has supplied the materials to the defendant, and the defendant has, without any objection, has received received the materials supplied by the plaintiff. Full stop. The plaintiff has supplied the material for a total sum of rupees
11,65,000.
11 lakh
65,368.
11,65,200 and
368.
eleven lakh 50,920.
Lordship, that was after the initial the purchase orders amount to 11,65,368 after adjustment of 12,000.
Where you mention?
Lordship, that has been mentioned in paragraph 8 and 9 of the plaint.
No.
Paragraph 6. I apologize.
11 lakh.
After adjustment of 12,447.
Kindly come to the paragraph 6.
Yes, paragraph 6.
Yes, what is the amount?
The amount is 11,52,920,
Correct.
but it is written after adjustment of 12,447 for previous excess amount, rupees 11,52,920. If all the three purchase orders are calculated, it comes around 11,65,368.
There was the plaintiff had adjusted an amount of rupees 12,447.25 from the previous excess amount of rupees 11,52,920.
Yes.
Full stop. The on in the month of March 2023, comma, the plaintiff has paid an amount of rupees 1,50,000 out of the total amount of rupees 11,52,920. 920. And thereafter the defendant has issued 3 checks. 3 or 2?
4 checks.
4 checks of rupees 1,98,240. 4 checks.
2 checks of 1,98,000.
Had issued 2 checks of rupees 1,98,240 dated 20 August 2022 and 25th of August 2022, and 2 checks of rupees 2 lakhs dated 3rd October 2022 and 2 lakhs each, and 17th September 2022. But when the plaintiff has presented the said check for encashment, all the 4 checks have been dishonored with the endorsement funds is insufficient. After the dishonor of the check, comma, the plaintiff had issued a legal notice dated 17th of July 2023 to the defendant, calling upon the defendant to pay the amount along with the interest, pay the principal amount of rupees 10 lakh, 02, 920.75 along with interest at the rate of 18%, total amounting to rupees 11,89,515.64. The notice was duly delivered to the defendant, but the defendant has not paid any amount. In the month of September 2020, on 27th of September 2023, the defendant has lastly paid an amount of rupees 50,000. 50,000. Thereafter, the defendant has not paid any amount. The plaintiff has initiated pre-institution mediation process, but in spite of receipt of the notice, the plaintiff has not and the defendant has not come forward to settle the dispute, and accordingly, non-starter report was issued, and the plaintiff has filed the present suit. To prove the case, the plaintiff has exhibited purchase orders being annexer B collectively, delivery challan being annexer C, what are the tax invoices being annexer D, the details of the statement account maintained by the plaintiff in the State Yes Bank being annexer E, 4 checks and the check return memos being annexer F collectively, the legal notice issued by the plaintiff to the defendant being annexer G, and the track report being D collectively, and the non-starter report being annexer H. From the document H, full stop. From the document produced by the plaintiff during his evidence, which were duly exhibited before this court, duly proved that the defendant has issued the purchase orders, and as per the purchase orders, the plaintiff has supplied the materials which was duly received by the defendant. After receipt of the materials, initially the defendant has paid only 1,50,000 out of the total amount of rupees 11,50,000. Subsequently, the defendant has issued 4 checks. The checks were dishonored, and the plaintiff has issued notice. And after issuance of the notice, the defendant has paid further amount of rupees 50 lakhs, leaving 50,000, leaving aside the further amount. As the defendant has not paid the total amount, the plaintiff has filed the present suit. From the document, it is found that the defendant has proved the case that the defendant plaintiff has supplied the materials, but the defendant has not paid the total amount of the bill raised by the plaintiff. From the tax invoices, it is categorical. One of the tax invoices, it is mentioned that the payment is to be made within 15 days from the date of receipt of the materials, and other tax invoices, it is mentioned that the payment is to be made within 30 days from the date of receipt of the materials. It is also mentioned in the tax invoices that if the defendant failed to pay the amount within the prescribed time, defendant is liable to pay 18% interest at the rate of 18% per annum. Consider the above, this court find that the defendant has duly received the materials and the tax invoices, but the defendant has not paid the amount, and as such, the defendant is also liable to pay the interest. Considering the above, this court find that the plaintiff has proved the case and is entitled to get the amount of rupees 12,24,444.45 as on 27th of as on 10th of January 2024. 10th of January 2024. Full stop. This court finds that the plaintiff has filed the suit. The defendant has also, for considering the 10th क्या बोला? The plaintiff is also entitled to get interest at the rate of 18% per annum in the aforesaid amount till the realization of settlement. Till CS number so and so is disposed of, decree withdrawn.
Actually, only one thing. The part where your lordship was dictated adjusted with the amount. That amount was said as 11,52,000. That would be 65. I'm grateful.
Next.
Number 24 on the commercial.
Yes.
24.
None appears on behalf of either of the parties. No accommodation is prayed for. Let the matter go out of the list. Next.
The contemporaries.
Contemporaries get
Told me, Millard.
But I'm sorry, Millard. I only took half information, Millard. But he has complied. Only thing which is left to be complied. But he is before your lordship, Millard. I'll file an affidavit to that extent. Millard, there are more than 14 to 15,000 tags. Millard, majority have been removed. Only thing, Millard, the board is there. Millard, it is also there in the report. This is covered, Millard. It is there in the report itself. Millard, the board will take 3 to 4 persons from Calcutta to go and then Millard take it off. So, Millard, by this week, Millard will comply everything and Millard will file an affidavit of compliance to your lordship.
And Millard, only one thing, there is other hoardings in the Millard Shingut station, Millard.
All, Millard, all.
If that is there, Millard, he should have told it.
I'm very sorry.
I was
I'm very sorry, Millard. I'm very
I
sorry.
was doing a matter with, I told him, Millard, that junior to me, that I was doing a matter not very, just 1.5 years ago before Justice Saraf, and I was arguing a contempt, defending Millard, the managing director of Millard West Bengal Tourism Corporation. I was going full haste like I do, Millard, in matters. He was about to go to jail. Then Mr. Shaha came and salvaged the situation on the next day. And he
I'm
told
sorry,
me,
Millard. Kindly, Millard.
not a contempt.
Millard, I tender my unconditional apology, Millard. I'm very sorry.
Rule defective, that defective. As
See, court has nothing to do with the parties. Court has to see the order has to be complied.
That's all.
If the court will not restrict, if the order is not complied, what is
it has to be?
Yes,
Everyone today he will be.
What is the weight of the order passed by the court? That is the
Yes, Millard.
it is wrong. It is
I completely,
right,
Millard,
that is
understand.
If you are aggrieved, you file a vacating, you go.
I
ahead.
completely
Just
understand.
now,
My lordship will
kindly,
only record that, Millard, kindly 7 days time may be given, Millard, to remove all the hoardings as well as, Millard, the price tags.
Let him do it, Millard, by this Sunday, Millard.
Yes, this Sunday. That's what. And keeps it on next Tuesday so that, Millard, I can affirm the affidavit on Monday.
The matter is listed in the supplementary list as in terms of the order dated 22nd of November 2022. The matter is supposed to be listed today, but it was not appeared. And on the prayer made, and the same was brought to the notice of this court by the learned counsel for the plaintiff. Accordingly, a supplementary list was published for listing the matter today. So and so appearing for the plaintiff, so and so appearing for the alleged contender. Alleged contender is present in person. Counsel for the alleged contender in person submits that he has taken the instruction that he has mostly complied with the order passed by this court, and some of the hoardings is required to be
in the station. Let him.
Some of the hoarding is required to be
showroom and Singhu station and various places in the
some of the hoardings are required to be removed, and he will remove all the hoardings by this week and will file affidavit by Monday next. In foolish counsel for the plaintiff has handed over the photographs showing that the hoardings is still lying in the Singur station and other places. Hence, the learned advocate appearing for the alleged contempt undertakes before this court that the defendant will remove all the hoardings and will comply with the order and will file the affidavit in compliance by 9th of December 2024. Accordingly, the case is adjourned by 9th of December 2024. Accordingly, the case is adjourned with the direction to the alleged contender to file an affidavit stating the fact that he has complied with the order on the date fixed.
Lordship is keeping it on, my lord.
Let the matter appear on 10th of December 2024.
Grateful. Lordship is fixing any time, lord.
No, this is come.
As per the inventory report, my lord, there are 1451 materials having the tags. He should also remove it also.
Yes, that, my lord, we have agreed.
The report you have received?
My lord, report?
You have received the report?
I have given a report.
My lord, only one difficulty, my lord, I've been told 10th of December, my lord, the advocate on record is on some difficulty. Any other? No, 11th, my lord.
9th?
9th, my lord, we'll affirm the affidavit.
Come on, 9th.
Lord, affirmation, then your lord keeps it on 11th, my lord. He has some personal difficulty.
Second half, ninth, second half, no difficulty.
No, she is not there. That's the only thing. 11th, my lord, anytime, your lordship pleases.
On 11th, I specially fixed matter at the time.
And my lord, lordship has not recorded the tags and the labels
Special
have to
officer
be.
has filed the report after serving the copy to the learned counsel for the respective parties. Let the same be kept with the record. The counsel for the alleged contender is also directed to comply and to see the report. If yes, which portion?
Lord, the tags in respect of the materials.
Materials, my lord, he should also remove
Yes,
it by Sunday. Page 4.
Most of them has been removed, my lord.
As per the report of the commissioner, the alleged contender has not removed the tag. In the meantime, the contender is also directed to remove the tag and to file the affidavit to that effect also.
Grateful, your lordship. I must, my lord, indicate thankful to Mr. Ghosh, my lord, for guiding me. As a senior member of the bar, my lord, he took me out, and my lord, blessings from seniors always help, my lord.
Always.
Grateful. Much obliged.
Thank you.
Item number 25 on the commercial list.
My application.
Yes.
But on the previous occasion, we had moved upon service. But your lordship was pleased to pass an order dated 12th of November 2024. Kindly seize that last order where your lordship records that we have the affidavit of service is filed, and in spite of service, they did not appear. Your lordship gave them a chance to, my lord, file a show cause within 2 weeks as to why the interim orders as prayed for should not be granted. But we have served that. My lord, all the there are 4 defendants. May I file the affidavit of service? Your lordship will, my lord, I am carrying the originals of the envelopes. In each and every address, the envelopes have written with endorsement refused. And
Why you
on
not
this
enclosed
address,
there?
I'm sorry.
Why you not included?
Yes, I have. Well, the photocopies I have, the originals I am keeping with me.
Okay.
But and in this address, your lordship will see the affidavit of service filed on the previous day when the petition was served. They have received.
Refuse is good service.
Refused is
Refusal
good
is
service.
good
Yes.
Yes. Then
In the same address, my lord, that I'm just pointing out. But the claim in the suit is, my lord, on account of unpaid price of goods sold and delivered. My lord, there are, my lord, total invoices which exceeds, my lord, 10 crore 95 lakhs. Total transactions between the parties. My lord, covering 46 invoices. That, my lord, will find at paragraph 9 at page 5 of my application.
10 crore.
10 crore 95 lakhs.
Correct.
Out of that, my lord, they had made payment of an amount of rupees 10 crore 48 lakhs. That, my lord, I've pleaded in paragraph 11, and my lord, I have also annexed a schedule.
48 page.
Yes. Well, I have also annexed a schedule showing all the payments which I have received in my bank account. But out of these payments, my lord, after giving adjustment, my lord, out of the total invoices, rupees 46,95,731 was
due.
Was due and payable.
Correct.
My lord, this amount, my lord, we had claimed, my lord, from the defendant. The defendant issued a check. My lord, that is, my lord, at page 135, if my lord is pleased to turn to.
Note 135 is a check which the defendant issued covering this amount. Your lordship will see the exact amount.
46.
Yes. My lord, thereafter, my lord will kindly turn to page 136. The next page. My lord, this is a check return memo where your lordship will find it's not insufficient funds, but payment stopped by drawer. My lord, thereafter, my lord, we had my lord,
notice.
yes, we had issued a demand notice. My lord, I should be pointing out
You do one thing, give to Mr. Vasu, he will argue.
My lord, 6th of September, my lord will kindly see page 137. 6th of September 2024, we issued the letter demanding this money. But on the same day, they had remitted an amount of around 15 lakhs. But my demand letter still contained 46 lakhs because we were yet to receive that information from the client, because this before they got the SMS, my lord, that the money has come to the bank account. This letter was dispatched by Mr. Basu. I'm sorry. That is the letter at page 140. This what I'm saying is
First dishonor is page 136.
136. Thereafter, the demand letter at 137 goes.
Yes.
137, to that, they say that you please deposit the check once again.
Again you deposited.
I again deposited and again it got dishonored.
Correct.
Thereafter, what I had indicated, this is the 21st September 2024 letter, which also has an amount of 46,95,731.
Correct.
But on the same day, they had remitted 15 lakhs.
15 lakhs they have remitted to you.
They remitted on the same day.
Correct.
But that is not reflected in the letter because before we could, this letter was sent before.
When the amount was remitted to you?
21st of September, on the same day.
Same day, okay.
But if my lord kindly takes a look at paragraph 17 and 18, my lord, I have explained this situation, my lord, at page 8.
Remitted, yes.
Yes, my lord, paragraph 17, I have indicated that this letter, but before that was intimated to Mr. Basu, this letter was dispatched. This is 15,84,000 was what was dispatched, what was remitted. But this leaves us with a balance of 31,11,000 odd. So, my lord, this is my claim for that. It's an application for judgment upon admission.
31,11,730.
My lord, it's and the interest, my lord, on that amount. That figure your lordship will find at page 9, paragraph 20. Interested loss.
Page 9.
Page 9, paragraph 20, my lord, I have pleaded that.
31 interest 46.
Yes.
45.
Yes.
That's all.
Yes. My lord, this is my app. Yeah, now your lordship will kindly see my prayers.
What you have prayed for?
I have prayed for a judgment upon admission because the check is there, admittedly payment given, part payment still made out of that amount. And my lord, they have not issued any letter either contemporaneously or my lord later on complaining of the quality of the goods. That has never been done. So my lord, this is my application. And my lord, in aid of prayer B, your lordship had been pleased to permit them to file a show cause. On the first day, your lordship said, no, I'm not inclined to grant any interim order. Let them give a show cause. Now, my lord, so far as interest is concerned, if my lord is pleased to, my lord, turn to page 19, my lord will find that the invoices which they had accepted without any demur or protest mentions interest at the rate of 18%. May I show, my lord? Page 19, your lordship will see there's a box at the bottom, my lord, where the second entry is the interest, my lord. 18%.
Where it?
On the left hand side, my lord. There's a QR code on the towards the middle of the page at the bottom, towards the left of that, my lord. 18% interest.
Right. Delayed payments.
Delayed payment shall attract interest at the rate of 18%. So these are my claims.
So deposit.
Deposit, but I'm if your lordship is, I'm wanting a decree on the admission because of the check is there, my lord.
So and so appearing for the plaintiff. In terms of the order passed by this court dated 12th of November 2024, the plaintiff has sent a notice to the defendants by speed post, but
The same was returned unserved to the plaintiff with the endorsement refused. Accordingly, the plaintiff has filed the affidavit of service. Let the same be kept with the report.
All the 4 defendants. All.
Let the same be kept with the report. Police. The plaintiff has filed the suit praying for there is a prayer in praying for a decree for a sum of rupees 35,29,3632 along with interest at the rate of 18% per annum. Full stop. The plaintiff has also filed an application being GA Form 1 of 2024, praying for judgment and decree upon admission, or in the alternative, an injunction, or in the alternative to an injunction directing the defendants to furnish security for a sum of rupees 35,29,632. The plaintiff has pressed for hearing of GA1, GA-Com 1 of 2024, but this court was not satisfied to pass any interim or ad interim order. Accordingly, had issued show cause upon the defendant so as to enable the defendant to explain as to why the order shall not, as to why an order for security deposit shall not be passed. Police. In terms of the order passed by this court, the plaintiff has issued the notice, has sent a notice by speed post, but the defendants refused to accept the same and returned to the plaintiff. Thus, the refusal is the proper service, and as such, this court has taken up a hearing of the GA1 of 2024. Police. The plaintiff has delivered as per the district of the purchase order issued.
Yes, no purchase orders.
The plaintiff, as per the transaction between the plaintiff and the defendant, the plaintiff has delivered the materials to the defendant for a total sum of rupees 10 crore, 95 lakhs, 35, 949. Full stop. Out of which the defendant has paid an amount of rupees 10, 48, 40, 218, leaving aside an amount of rupees 46, 95, 731, as that full stop. As the defendant failed to pay the balance amount of rupees 46 lakh 95,000. The defendant had issued, defendants have issued a check dated 12th of July 2024 for a total sum of rupees 46, 95, 731 of the IndusInd Bank in favor of the plaintiff. The plaintiff has presented the said check for encashment, but on 24th of July 2024, the same was returned to the plaintiff. 24th July 2024, the same was returned to the plaintiff. The check was returned to the plaintiff with the endorsement, payment is stopped by drawer. After dishonor of the check, on 6th of September 2024, the plaintiff had issued a demand notice calling upon the defendant to pay the amount of rupees 46 lakhs 95,730 along with the interest at the rate of 18%, Full stop. After receipt of the said notice, comma, the defendant has instructed the plaintiff to present the said check again for encashment. Accordingly, as per the instruction of the defendants, comma, the plaintiff has presented the said check on 19th of September 2024, on 18th of September. But the same was again dishonored with the endorsement, payment stopped by the drawer. Full stop. After the dishonor of the said check, on 21st of September 2024, comma, the plaintiff had again issued a demand notice calling upon the defendant to pay the said check amount along with the interest. In the meantime, comma, the defendant has paid an amount of rupees 15 lakh.
15,
15 lakh 84,000 in the account of the petitioner on the same day, that is on 21st of September 2024, leaving aside the further amount of rupees 31,11,730. Full stop. As the balance.
Only one thing I should be pointing out to your lordship. Kindly do not pass a decree today. Though I am praying for that. The reason being, the plaint, it's still being scrutinized. It's not yet scrutinized. The summons have not yet been served. So kindly protect us and we shall come back.
Full stop. Full stop. As the defendant has not paid the balance amount of rupees 31,11,730, comma, the plaintiff had sent a demand notices to the defendants, but in spite of the receipt of the notice, the defendant failed to pay the said amount. Accordingly, the plaintiff has initiated the present suit. It is fine from the record that the total transaction between the plaintiff and the defendant was rupees 10 crore 95,35,949, out of which the defendants have paid 10,48,40,218, leaving aside 46,95,731, and for the balance amount, comma, the defendants have issued the check, but unfortunately the check was dishonored on twice, and in the meantime the defendant has paid further amount of rupees 15 lakhs, leaving aside the balance amount of rupees 31,11,730. From the averment and considering the document, this court find that the defendant has admitted the amount due and payable to the plaintiff, but has not paid the balance amount of rupees 31,11,730. In spite of receipt, full stop. This court, before passing an order, has given an opportunity to the defendant to show cause as to why the order cannot, interim order cannot be passed, but the defendants refused to accept the notice. Accordingly, this court found that this is a fit case wherein an interim order can be passed by directing the defendants to deposit an amount of rupees 35,29,632 before the registrar of this court. In view of the above, comma, the defendants are directed to deposit an amount of rupees 35 is the total interest. I am giving the principal 31.
Because the interest is there in the invoice they had. They have admitted that by issuing the check. They have admitted that.
नहीं उससे पहले नोटिस नोट ऑफ notices. ठीक है. This court also find बीच में आ जाएगा. This court also find in the invoice it is categorically mentioned that if the defendant failed to pay the amount in due date, comma, the defendant is liable to pay interest at the rate of 18% per annum. Accordingly, the defendants are directed to deposit an amount of rupees 35,29,632 with the registrar of the original side of this court within a week from within 2 weeks from date if the amount is received by the registrar original side of this court, the registrar original side of this court is directed to invest the said amount in the interest bearing fixed deposit receipt in any of the nationalized bank until further order.
But one other,
with the auto renewal facilities.
but one other prayer I'm praying for, if your lordship kindly takes a look at prayer D, which is injunction on their bank accounts. My lord, that, my lord, I'm praying for from today. My lord, subject to them depositing, this order should continue. The bank account be injuncted, subject, if they deposit, then that order be.
It is made clear that if the defendants fail to deposit the said amount,
But I'm praying for it today. My lord,
it
from
is made clear till the deposit of the said amount by the defendants, the defendants defendants are restrained from operating with the account. What is the account?
No, the bank account. My lord,
The bank account connected with permanent account number AAOFC 3600L by keeping apart a sum of rupees 35,29,632 till the deposit of the said.
I'm grateful. And my lord, would your lordship's pleasure be to give them chance to file an affidavit?
Full stop.
Then I'll press for the
As
decree
none
later.
appears on behalf of the defendants, the defendants are directed to file affidavit in opposition within 2 weeks. Reply, if any, they are to be filed within a week thereafter. Please the matter. One 24th of December 2020. That's because the injunction is there.
Yes. And my lord, should I give the number of the bank account which we have apart from the PAN number?
PAN card account.
I shall give the.
Yes, next.
Lord, maybe your lordship takes up the next matter, my lord. Item number 24, my lord. I was running, my lord.
Yes.
Item number 24, my lord. I was running. My lord, I missed. I'm for the plaintiff, my lord. I'm ready to do the matter, my lord. I was running, my lord. It's called on, my lord. Your lordship, I don't go out of list, my lord. If your lordship kindly retain in the list, my lord, I'm ready. Otherwise,
Why you not appeared?
My lord, I was running from that building, my lord. So I missed.
Yeah, Scott, not today.
Great.
Yes, next call.
Item number 9 to item number 11 on the commercial.
My lord, these 3 items, my lord, it's for examination of the witness. These are undefended suits. My lord, the witness is present, but my lord, I'm still requesting if this could be deferred by a couple of weeks. My lord, I have seen in the affidavit of evidence, the main evidence is my lord, the bank statement, because we've paid money which we want to claim back. But under the Bankers Books Evidence Act, it has to be my lord,
seal and signature
that is awaited, my lord, which is why, my lord, if your lordship can kindly defer it, my lord, we will come back with that document and then we can complete it. My lord, connected matters, same defendant. In one of the 3 suits, my lord, the plaintiff is the person himself, and in the other 2 suits is the companies which are owned by his family.
Item number
10, my lord, it's the person deposing himself, and he's the patriarch who my lord.
All are connected matters.
Yes, my lord. My lord, same person, same defendant, and same, my lord, family. And 9 and 11 are, my lord, companies are the plaintiffs, and 10 the person is the plaintiff who controls these companies, the head of the family.
So in all cases, the separate evidence will be recorded.
My lord, it has to be done because there are 3 different.
In none of the cases, parties are present.
My lord, same person will depose, my lord, one after the other in all 3 matters. But my lord, same problem will arise in all 3 matters because we need the certificate of the bank. From downloading it from the web net banking is one thing, my lord, but just to be foolproof.
No, downloading on the web bank, you file the 65p.
My lord,
that's enough.
My lord, but the certificate.
Not necessary if you file the 65p.
No, my lord, but my lord, we could have, my lord, but based on my advice, my lord, the affidavit wasn't affirmed.
Yeah, not affirmed.
Yes, it's ready. It's ready, my lord. It wasn't affirmed. My lord, we'll come with the certificate, my lord. Or 65B, now that my lord has mentioned, my lord, we can do it that way also.
Correct. Because
And then I prove, then my solicitors scold me, I'm wrong now. I said, no, it's an undefended suit. You must go with the banker's book.
65B. Now all the electronics document, either banker's book, earlier it was.
Yes.
Now the after the IT Act,
my lord, we
and
were just trying to
65B, all the document, electronics document, 65B, if you have taken out.
very well. My lord, we'll come back with the 65B then.
Because the bank statement you cannot. How you can say that it is not wrong? So 65B,
Yes,
you are the best person to
65B.
say.
And it's an old suit, so it'll be the old Act 65B.
65B.
Not the new vernacular evidence act. Yes. Well, let maybe come back, please. Kindly give us 2 weeks, my lord.
Now it will go January. I don't know January which date, second
Subject to my lord's convenience, my lord. If it's possible before Christmas, my lord.
No. There is no date.
We will have a better Christmas then, my lord.
So you have missed the opportunity today.
I know.
Sense appearing for the plaintiff. The matter is fixed today for a witness action, but the counsel for the plaintiff submitted due to some unavoidable circumstances. It is not possible for the plaintiff to proceed with the evidence today and prayed for adjournment. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on. Give the date. 17th of.
Lord, may I just consult the witness, my lord, for a minute? On 17th January, is it okay for you? 17th January. My lord, 17th January.
17th January at 3 p.m. 2 p.m.
2 p.m.
Come ready on that day. Otherwise, tell your client to impose the cost.
Yes, my lord. He is
17th. तीनों एक साथ करके करें. Yes, next.
Grateful, my lord.
26.
My lord, I beg to appear on behalf of the petitioner. Lord, similar matter as the earlier matter, my lord. My lord, goods sold and delivered.
Take a chance the first, then come with the second.
My lord, smaller claim, my lord.
Much smaller claim.
Much smaller claim. Your lordship had, my lord, directed the defendant to show cause on the last occasion.
Where is the so-called?
My lord, we have served.
Should.
Yes, my lord, we have served. It's been delivered, my lord.
Delivered?
Yes. My lord, at one address it was delivered, and on the others, my lord, it was not claimed. Lordship sees at page 6 of the, my lord, affidavit we have served.
What is the address?
Yes. My lord, address is my lord, Howrah, 103, 104, Noshkorpada Road. My lord, Bakery. My lord, sees page 6, my lord. My lord, it has been served on 19th November from the, my lord, Bakery office, post office.
Another one returned.
No, your lordship. The other one is, my lord, unclaimed. If your lordship kindly please, page 8, my lord, door closed on 19th and 20th, and on 21st, my lord, unclaimed.
Yes.
Lord, we have
Yes. Then?
Yes.
What is the case about?
Yes, may I indicate, my lord?
Same thing.
My lord, more or less same.
What was the total amount?
My lord, the total claim is, my lord, my principal is a sum of rupees 12,05,869. My lord, which has been, my lord, acknowledged. My lord, my claim in the suit is a sum of rupees 18,70,121.
Where?
My lord, kindly takes page 61. That is my plaint.
Plaint?
Yes, your lordship.
61.
Lordship.
Yes.
Internal page 8 of the plaint at paragraph 20, my lord. I have tabulated my claims. Lord, principal sum and interest.
No. What was the total initially?
Yes, your
26 lakhs.
Yes, your lordship. 26 lakhs.
67,000.
Yes, lordship kindly takes, my lord, page 18 for once. My lord, there were in total 31 invoices. My lord, they paid for 29. My lord, 2 remained unpaid. My lord, page 18, are my details of the invoices that we have raised.
Yes.
My lord, page 19 are the details of payments that we have received.
2 crore 98 lakh 13,236. This was the total invoices.
Lordship.
Total material supplied.
Lordship.
And you received the 2 crore 80 lakhs.
Lordship.
Leaving aside 18 lakhs.
Yes, your lordship.
18 lakhs.
Your lordship, there is a schedule at page 20,
Hmm.
which we have also indicated the outstanding, my lord, sum.
26 lakhs.
Yes, your lordship. Thereafter, what has happened, your lordship?
How it has come 26 lakhs? Because as per this 18 and 19,
lordship,
18 and 19, 2 crore 98 minus 2 crore 80. So it will be a 12 lakhs. What is this invoices?
Page 3, para 5.
Man.
Page 3, para 5.
My lord, at page 3, para 5 of my application, my lord, I have explained. My lord, on request of the respondent, the petitioner has sold and delivered crash barriers of a total value of rupees 26,67,319 between 3rd September 2021 and 25th September 2021.
Hmm.
And thereafter, at paragraph 6, my lord, I have stated that total of 31 invoices were raised. Thereafter, my lord, I have indicated the schedule and payment was made for 29 invoices. My lord, at paragraph 7.
How it can be? Kindly come to the
Yes, your lordship.
page 18 and 19. Page 18 and 19 starts from 29th August 2019 till 21st of August 2023. Correct?
Lordship.
And the same thing has happened here in page 19. Payment. Correct. Payment received. Now come to the page 20, which you relied upon.
Lordship.
Page 20. You are telling that 3rd September 2021 and 25th September 2021. This
yes.
Correct.
Lordship.
Now you come to the page 18. Page 18. 3rd September, where is 2021? 23 lakhs. Correct. And 3,38,000.
Yes, my lord. The
correct. This two.
Two.
This two includes the 20. So how you can say if this includes 2 crore 98 lakhs?
Lordship.
And you are telling that you have received the 2 crore 80 lakhs. So how you are telling that this amount is due? How you say? If you are relying upon the page 18.
Page 20.
Go, do homework.
My lord, may come back on Friday. Like perhaps the my lord, page 19, there is something, my lord, which is incorrect.
It is then what about the page 3? Paragraph 5.
Lordship, I shall come back on Friday, my lord.
If we ignore the page 19, then what 20, then what about the paragraph 5?
Actually, click the page 20.
You go through.
Yes.
As per the prayer made by the counsel for the plaintiff. So and so appearing for the plaintiff. Full stop. In terms of the order passed by this court, comma, the plaintiff has served a notice upon the defendant, which was duly served upon the defendant at the one address, and in the second address, the same was written to the plaintiff with the endorsement unclaimed. Plaintiff has filed the affidavit of service. Let the same be kept with the record. As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 6th of December 2024.
Great.
27.
My lord, may I pray for one indulgence? My lord will kindly take it up on Monday, my lord. 9th, my lord, if your lordship permits. Deeply obliged.
Next.
My lord, my application But I have served the bank. But the bank is the Lord, you would recall I had presented the plaint, but this was only because suit for initially filed for recovery of money, declaration, and other consequential reliefs. Because it was incorrectly declared as an NPA. I have served, my affidavit of service is here. We have served it by hand. The bank has received. Served yesterday. Yes. We also have the original letter.
Yes. What can be done?
Lordship keeps it on Friday.
Inform another, you should know another notice.
Yes, I'll issue one more notice. But if
so
Lordship kindly provides it in your Lordship's order, that in case they don't appear,
suffering for the plaintiff, none appears on behalf of the defendant. Suffering for the plaintiff, full stop. The plaintiff has filed the affidavit of service showing that the plaintiff has issued notice upon the defendant from a State Bank of India on 2nd December 2024, informing that the matter will be taken up for hearing on 3rd of December 2024. But in spite of receipt of the notice, none appears on behalf of the defendant. Full stop. For the interest of justice, this court directs the plaintiff to again issue the notice to the defendant, informing the next date of hearing, and to file affidavit service on the next date fix. It is made clear that on the date fix, on the next date fix, if the defendant failed to appear in spite of the notice, the application will be taken up for hearing in the absence of the defendant.
Great.
List on 6th. Let the matter appear on 6th.
Item number 28, my lord.
Yes.
My application. My lord, Mr. Rai was addressing your lordship, my lord, the commercial court part. Whether the master could actually extend the writ of summons. My lord, in some difficulty.
New inductee, my lord.
This time around, my lord, it's the other way around. Mr. Shorkar's supporting the plaint.
Yes.
No, my lord, Mr. Rai is not there. He's in some difficulty, my lord. If it could be kept on.
In the morning.
My lord, he's left court right now. He's not there.
So,
Lord, if your lordship keeps it on Friday, my lord.
As per the prayer made, so and so appearing for the plaintiff, so and so appearing for the defendant. As per the prayer made by the counsel for the plaintiff.
My lord,
defendant. As per the prayer made by the counsel for the let the matter appear on 6th.
Grateful, my lord.
29.
Yes, my lord. And that Lordship was hearing two applications. But this is my suit for specific performance of two registered development agreements. My lord, written statement not filed. Now, my lord, the defendant comes and applies under Order 7, Rule 11, praying for rejection of the plaint. And the ground that has been argued is dissimilar to the ground that has been pleaded in the body of the petition. The argument made before your lordship is that the plaint should be rejected on the ground that it is not a commercial dispute. Now, that was my learned friend Mr. Dath's submission. But may I respond today?
Acha, that one.
Yes.
Where is Mr. Das? Who is for the defendant?
He was only appearing, my lord.
Okay.
May I continue? But I'll just briefly, my lord, indicate to your lordships the points that he has argued. Briefly, just summarize his arguments. My lord, he has argued that disputes are not commercial in nature. That's number one. The subject agreement or the agreements is not a joint venture agreement. And a development agreement is not a joint venture agreement. Now, my lord, if it's an agreement in respect of an immovable property, then I have to show your lordship in terms of the dictum of Ambalal Sarabhai that is exclusively being used as for commercial purposes. Now, my lord, he has shown your lordship two judgments to point out the characteristics of a joint venture agreement which is absent in the agreements of 25th of October 2017. Now, my lord, 5 to 6 points. Number one is, this is not a case of rejection of plaint. At best, it can be a case of return of plaint. Number two, my lord, the arguments that have been advanced before lordship does not have any foundation in the pleadings. If lordship sees, my lord, the application that has been filed, GA2, my lord, the application does not contain any ground under order 7. If it's not a dispute under the Commercial Courts Act, then at best it can be argued that it is barred by the Commercial Courts Act. It at best can come under Order 7, Rule 11D. But Commercial Courts Act does not bar the jurisdiction of civil courts, like Section 34 of the Securitization Act or Section 430 of the Companies Act. So what he has argued is on a different, the pleadings is of a different context. Pleadings say that plaintiff does not disclose any cause of action, no foundation in the pleading, so reliefs cannot be granted. There has been no invasion or infringement of my rights, and I am not in possession of the suit premises, so no interest has been created in my favor. Now, my lord, next submission is, my lord, if lordship will kindly takes the application, my application, my application, which is the order of application for interim relief, that is GA1, but perhaps these arguments are no longer relevant because of the order passed by this honorable court on, my lord, 31st of March 2023. Lordship sees page 253 of my application GA1, volume 2.
Yes.
Yes. My lord, 2023 March, my lord, we made an attempt to present the plaint, the self-same plaint. We made an attempt to present the plaint. My lord, the Section 12 capital A leave under the Commercial Courts Act was not granted to us. The learned judge, my lord, directed us to exhaust pre-institution mediation, and hence, my lord, the plaint was not admitted, and accordingly the order was passed. Now, lordship will kindly see, my lord, page 257 onwards. My lord, I have exhausted the pre-institution mediation.
Yes.
And my lord, lordship will find page 257. This is the non-starter report.
Yes. Yes.
So my humble submission, my lord, by the order of 31st of March 2023, which still binds the parties, and in terms whereof I have exhausted pre-institution mediation, the disputes between the parties have been treated to be commercial in nature.
Why?
Not because I have already, pursuant to an order of court, the order, in terms of this order, it has been said that this is a commercial dispute, because only if it is a commercial dispute, then only I will be sent for mediation. If it's a non-commercial dispute, I need not exhaust pre-institution mediation.
Correct, but at that point of time, if you go by this, but at that point of time, no defendant.
No, defendant was not there.
And you filed. The court has found that no. Find that this is not a fit case to grant leave and granted. The court has not considered whether the case is of the commercial in nature or whether this is non-commercial in. Only the court has found that the leave cannot be granted and directed you to go and initiate the pre-institution mediation process. And now the defendant has come forward and is stating that it is not. So how it can be helped? It will help to you.
Yes, I will just trying to, my lord, make one point, is that when the court has applied its mind and, my lord, has directed me to take recourse to a particular statute, and that statute is only taken recourse to when the disputes are commercial in nature, in my humble submission, the issue whether it is commercial or not is no longer res integra, so far as both of us are concerned. Because there is an order of court, he is aware of the order, he could have applied for review of the order, that it is not a commercial dispute. because it was passed at a point of time he was not there. He could have applied for review, he could have applied for recalling, but the application that has been filed is for rejection of plaint. So, my lord, when the court has already directed me to exhaust the pre-institution mediation, the court, my lord, impliedly applied its mind and decided the issue that it is a commercial dispute. Because only in case of a commercial dispute, I am directed to exhaust pre-institution mediation, not otherwise.
Correct. That is correct.
Now, my lord, the judgments, should go to judgment act? Yes, but the judgment cited by my learned friend, that three judgments he had cited. The first one was Fakir Chand Gulati, then was Bunga Daniel Babu. My lord, the first citation is 2008 volume 10 Supreme Court cases 345, and my lord, 2016 8 SCC 429.
Because he had relied upon the Gulati, because other two judgments are followed the judgment of Gulati.
Yes. 16.8 SCC 429 has followed, my lord,
Correct.
the Fakir Chand Gulati.
Correct.
Another judgment that my learned friend has cited is a coordinate bench. My lord, I'll first deal with the coordinate bench. In fact, Lordship has a copy. But what I'll do is, my lord, an appeal was preferred from the, yes, an appeal was preferred from this. This is the judgment that my learned friend had handed over. My lordship will see this was a judgment and order of 16th. This is the single bench judgment. 16th of May 2024. But kindly see, but the appeal code has set aside the judgment and order of 16th of May 2024. Now I'll hand up the division bench judgment. This is dated, my lord, 8th of November 2024. Yes, my lord, kindly see the first paragraph of the.
Whether this judgment was relied upon?
Yes.
I indicated.
Yes, yes.
I indicated.
It's a Manupatra printout.
It are not commercial dispute.
Yes, it was held that yes, here also if lordship sees the Manupatra printout that your lordship has, but kindly comes to internal page 4 of the Manupatra printout.
Page 4.
Internal page 4. Lordship will find the page numbers at the bottom inside the bracket.
Yes.
Kindly see 4 lines above. Kindly see paragraph 12 itself.
Yes.
It is no longer res integra that a court should trudge with 4 corners of the plaint while considering an application for rejection of plaint. There is no scope of digression from the peripheries of the plaint. A plain reading of the plaint provides certain basic facts. There was negotiation between the parties herein. The negotiation is related to construction/development of land. A term sheet was executed containing certain terms and conditions. It is the plaint itself that the defendant snubbed the term sheet as void. No development/joint venture agreement in whatever way it may be termed was executed between the parties. In these premises, what is admitted is negotiation between the parties. Execution of the term sheet is asserted by the plaintiff, denied by the defendant. Unless the existence or execution of the term sheet is established by trial by adducing evidence, the same cannot be dissected to understand the nature and character of it. Development agreement which was supposed to be executed was not executed and is not in existence. Trying to understand the nature of a non-existence documents of a future document which is only in sphere of contemplation is but not in writing on a. Except negotiation, there is no admission of existence of any agreement. It is nobody's case that there was an agreement. Well, because of this paragraph itself, the judgment can be distinguished. Because here there was no agreement at all. Here, Malad, there are 2 registered development agreements. But be that as it may, Malad, I would humbly beseech your lordship not to rely on this judgment because it has been set aside by the division bench. I'll just show your lordship the operative portion of the impugned judgment. Yes, kindly, my lord, comes to page 9 of the judgment, paragraph 16. The observation of the learned judge was set aside. Paragraph 16, page 9. In view of the discussion made here and above, we are not inclined to interfere with the order impugned in the present appeal. Now, however, the observation of the learned single judge in the concluding part of the order that the dispute involved in the suit are not commercial dispute for the reasons stated above is contrary to the observations made earlier in the part of the order. Accordingly, the said observation is set aside. Not Fakir Chand Gulati, all those judgments have been considered and it has been said that it is no longer a, the observation was that it is not a commercial dispute. That observation has not been undone. Now, dealing with Fakir Chand Gulati.
Is a dissent or?
I'm sorry, Malad?
Two judgment, two.
Yes, Malad, it has been conquered by the other judge. Malad, Lordship will kindly see page 21, paragraph 34. So Fakir Chand Gulati was in 2008 and the subsequent judgment was of 2016. But 2022-17 SCC page 1, but Supreme Court has doubted the law laid down in Fakir Chand Gulati.
Yes.
Yes. This is 2022, volume 17 SCC page 1. Paragraph 1. Yes, Lordship will kindly take paragraph 36 of the judgment at page 21 of the report. Kindly see the above judgment in Uppal Agency's case. Paragraph 36, page 21 of the report.
Yes.
Yes. Kindly see the above judgment in Uppal Agency's case. Lordship will see the footnote number 8. Fakir Chand Gulati versus Uppal Agencies, that is 2008-10 SCC 345. While clarifying the purpose of collaboration agreements falls short of delving into the legal effects of the transfer of such development rights. Parting with rights which are fundamental to ownership for valuable consideration in cash or by handing over constructed units, leaving only the nominal title with the landowner is a common feature of such collaboration agreements. Given the evolution in complexity of real estate contracts and the absence of the definition of collaboration agreements in legislation, their interpretation by various high courts assumes significance. Now let's kindly see paragraph 37. I'll place the judgment of Ashok Kumar Jaiswal of the full bench of this honorable court to show your lordship, my lord, that what is a development agreement. My lord, there are two factors involved in a development agreement. It's the landowner who retains the land, who gives the land to a specialist person who is a developer to construct a building, and thereafter, my lord, the landowner has rights over his portion and the developer is given the developer's allocation. The developer enjoys the right to transfer the flats or the units from his allocation or from the developer's allocation. Now, my lord, in my humble submission, when there is a landowner's rights involved and developer's rights involved, and when the developer has been given to, my lord, alienate units in an immovable property, it's an agreement relating to land coupled with a transfer of interest in the land. But that which has been held. So, my lord, even now, and my lord, Ashok Kumar Jaiswal has also recognized that a developer acts as the agent of the landowner. So, my lord, the doctrine of section 202 of the Indian Contract Act will come into the picture. Because I am acting as the agent of my landlord. Because it is, lordship will see, my lord, in practical scenario, my lord, it is apart from a development agreement, my lord, a power of attorney is also executed. Because, my lord, it is not possible for the landowner, my lord, to rush to every authority and obtain necessary permission and clearance.
That's why he has given the power and all
Yes.
these things.
So, my lord, if I am recognized as the agent of the landowner, then, my lord, if section 202 of the Indian Contract Act comes into the picture, then, my lord, I will be an agent, and disputes involving agency will also be a commercial dispute. Kindly see, my lord. Commercial code. Yes. My lord, I am on my lord, section 21C, Roman 21 of the Commercial Codes Act. 21.
21C.
My lord, Roman 21 XXI.
21. Contracts of agency.
Yes, my lord, kindly see contracts of agency relating to any of the above.
Correct.
Now, my lord, I can come under many heads of 21C.
Yes.
I can come under many heading. First, my lord,
Agency relating to any of the above.
any of the.
Correct.
My lord, there are 20 items before 21. If I can bring my case within serial number Roman 1 to 20, then my lord, I can my lord, fall under 21. If I fall under 21, then my lord, it's a commercial dispute.
Correct.
Now, my lord, kindly see. First, my lord, I would humbly beseech your lordship to kindly take, my lord, 6, Roman 6.
Construction
Infrastructure contracts including tenders. I have been given the right to construct on the land of the landowner. Now, though, my lord, in the plaint I have stated it to be a development agreement, but nomenclature of the development agreement, nomenclature of the agreement is irrelevant. The intention of the parties is to be governed. But this is only to bring, I'm not going into detail, but so far I can come under Roman 6. I can come under, my lord, Roman 7 also. Roman 7 especially, agreements relating to immovable property exclusively used in trade of commerce. Now, my lord, the reason, yes, this is very interesting. Ambalal Sarabhai, my lord, says that disputes in respect of an immovable property will only be commercial and it will come under 21C Roman 7, provided I use it at that point of time for a commercial purpose only. I have to be actually using it for commercial. Then only such disputes will be commercial. But Ambalal Sarabhai does not deal with this issue that if an agreement related...
different fact.
Yes, but I am only saying that for the time being, if I am not using as a... For the time being, if I am not using it as a commercial venture, I am not exploiting the property commercially, it might not come under 7 because of the dictum of Ambalal Sarabhai. But since I am an agent, it can come under Roman 21. If I am an agent conferred with a right or with an obligation in respect of an agreement relating to immovable property exclusively used in trade or commerce.
Correct. So what is your agreement?
My agreement is, my lord, that the owners have given me right to construct buildings. In terms of the dictum of Ashok Kumar Jaiswal, I am an agent. If I am an agent, my lord, I can come under 21. Now, my lord, I can also come under Roman 11, joint venture. Now, joint venture, if lordship sees, is akin to a collaboration agreement between the landowner and the developer. Because this is, I'll take your lordship through the agreement. If lordship will see the terms, my suit for specific performance as per the case made out in the Order 7, Rule 11 would not have been maintainable if no right would have been given to me to sell the developer's allocation. Because in terms of the Sushil Kumar Agarwal judgment, 2019, delivered by Justice Chandrachud, that has also been followed, has also been quoted in this judgment also, the 2022-17 SCC. If the developer, my lord, is only given a right to construct and thereafter receive construction costs, then, my lord, the developer does not get any right qua the immovable property. Because if I do not have any right, if I am only entitled to construction cost, then I can only file a suit for recovery of the construction cost. It will be a simpliciter suit for recovery of money. It's only since I have developed a right, my lord, in the agreement, hence, my lord, the suit for specific performance. And that is the reason why compensation in money will not be an adequate relief.
What is the prayer in the suit?
Specific performance of the registered development agreements. Kindly seize the plaint, my lord. For GA1, my lord, page 258. কি বাতা বলছো? I'm sorry, my lord. I think I had indicated.
258. Where is the prayer? Specific performance of
Yes.
development agreement.
কি ভুলভাল বলছো? Yes, my lord. Internal page 11 of the plaint, specific performance of the development agreement contained in the documents dated 25th October 2017. Specific performance. And my lord, other are the, my lord.
Where is that agreement?
Yes. My lord, kindly see if lordship takes my application, my lord, GA1, kindly takes page 20. আমার পেটের পেজ নাম্বার লেখা আছে। This is my lord, page 20. My lord, this is a registered development agreement.
Correct.
This is in respect of my lord 42C and 42D Serpentine Lane. My lord, I'll just only take your lordship through the relevant clauses. Yes.
So you are the construction.
Yes, I am the developer.
Page.
Yes, my lord, kindly first see, my lord, page 37, which is, my lord, a continuation of clause 17.
The sanction plan is for the commercial building or the other things?
No, we have not reached that stage because, my lord, it is the agreement between the parties that I have to, my lord, evict the tenants who are. It's a joint obligation to evict the tenants. Only after the tenants are evicted and vacant possession is obtained, my lord, then we'll go to the corporation, we'll apply for a sanction plan, and then, my lord, I'll work accordingly. Now, my lord, why I say, my lord, joint obligation, kindly see, my lord, few clauses. Yes. Kindly takes page 48 first. Yes. Page 48, my lord, kindly see clause L. Joint venture as in both of us will jointly proceed to achieve a common object. Now kindly see L, page 48. My lordship has page 48.
Yes, yes.
Yes, kindly see capital L.
Yes.
That the owners and the developer jointly shall take the responsibility for successfully negotiating with the existing tenants of the said premises for obtaining no objection, and also settle with the tenants and occupiers in the said property for shifting/vacating the said property, either by allotting floor area and or constructed space, or in terms of money from the owner's allocation. This is the joint obligation. Yes, kindly now comes to, my lord, page 47, K. This is also joint. K. Well, I'll just place K. The original deeds and documents and all other paper or papers in respect of the said property are in the custody and possession of the owners. And the said owner shall be should respond to furnish or produce the said original deeds or documents and all other paper or papers relating to the said property to the developer, or by its instruction before the appropriate authority or authorities, or intending purchaser or purchasers as and when required by the developer. Now, this is the reason is, unless and until, my lord, he gives his original papers to me, but I won't be able to go to the corporation and apply for necessary sanction plan.
Okay, this is the contract between both the parties.
Yes.
Correct. You are the owner. You are the developer.
Yes.
He is the owner. So the tenants are there. Tenants has to vacate it.
Yes.
And flat. So how it can be? You can say this is a commercial.
But because if I am recognized by the full bench decision as an agent of the landowner, then, my lord, it will be governed by the principles of agency, and coupled with this being a joint venture agreement. But there are joint obligations which the parties have to perform. my lord, construction of a building on a land which is owned by a person. My lord, the owner is not constructing the land. Owner is giving his land to me that I should construct the land because he purpose does not have the wherewithal to construct the building. It is on me. Now, my lord, what both of us has to do, what both of us have to do is, number one, my lord, in terms of this agreement, we have to evict the tenants. Now, number two, my lord, he has to give his original documents such that I go to the corporation. Now my lord, since here there is a power of attorney, if there would not have been any power of attorney, then the owner also had to go to the corporation, meet the assessor collector, participate in the hearing, and only thereafter the sanction plan would have been issued. And my lord, if power of attorney would not have been given in my favor, then owner was also required to put his signature on each and every document before the construction commences. So here, my lord, both of us are, my lord, achieving a common goal, that is to construct the building on his land. He has, my lord, it is not my individual obligation, it is our obligation. So it's a joint obligation where both of us are venturing to achieve a common goal or a common object, that is a complete residential or a commercial building, whatever may be the nature. Now, even if your lordship holds that it is not a joint venture, I will humbly beseech your lordship to take the full bench decision of this honorable court in Ashok Kumar Jaiswal. Yes. Yes, this is reported at AIR 2014, Calcutta 92.
Yes.
Yes. Kindly see. First, my lord, if lordship comes to my lord, internal page 3 of the judgment, paragraph 7. Few paragraphs are very important. I'll not place the entire judgment, it's a bit longish. Kindly see, my lord, paragraph 7. If we look to section 202 of the Indian Contract Act 1872, we would find when the agent had interest in the property under the agency agreement in absence of an express provision, the contract could not be terminated to the prejudice of such interest. Section 203 would permit the principal to revoke the authority of his agent, subject, however, when the agent partly exercised his authority, such revocation would not be permissible under section 204. If we read these three provisions together and try to answer the second query made to us by his lordship, we would find power of attorney so revoked by the owner should not be looked at in an isolated manner. The power of attorney generally issued to the developer was in continuation of the original agreement for development of the property, meaning thereby the developer who was entrusted to develop the property would be given authority to do further act as per the contract, including dealing with the property to the extent permissible under the contract. Hence, power of attorney was nothing but an agency agreement executed in furtherance of the original contract. Here, my lord, admittedly, there are two power of attorneys executed in my favor. So the power of attorney, since is a child to the development agreement, but since both of them cannot be segregated, because if it's a standalone development agreement, it's not possible, then the owner has to join. Then it makes my case further better. Then it's a more development agreement. But still, if it's in the power of attorney makes me the agent, so the doctrine of agency will come into the picture. Next, lordship will seize, my lord. Yes, now, my lord, very interestingly, my lord, this judgment has laid down as to what can be a development agreement. My lord, kindly comes to, my lord, page 15 of the judgment, paragraph 43.
Yes.
Yes. My lord, may I please paragraph 43? This leads to the unavoidable discussion as to what may be regarded as a development agreement, as referred to in the questions framed for the reference and the judgments of this court cited by the parties. I will not trouble your lordship with the balance. Kindly comes to paragraph 44. Here, my lord, this is very important. In such sense, a development agreement which envisages the party thereto, other than the owner being reason responsible for ensuring the construction of a building on the subject land and having a share therein, there is an inescapable contract to transfer immovable property. Well, that is the reason why I showed your lordship Roman 6, agreement relating to an immovable property. In form, a development agreement which envisages the developer to have a share in the building proposed to be constructed in terms of the agreement. The agreement may appear to be somewhat not resembling an agreement for transfer of an immovable property, and indeed, it is not an agreement simpliciter for sale of an immovable property. In law, however, a development agreement of the kind described herein entails transfer of immovable property in the sense that the developer or an assignee of the developer, at the instance of the developer, would be entitled not only to a part of the constructed area but the proportionate share of the land on which the construction is made. So this further improves my case that this is an agreement relating to an immovable property, because in a development agreement the rights that have been given pursuant to the development agreement envisages the developer to have a share in the building. So since I have a share in the building, I have a share in respect of an immovable property. I have a right in respect of an immovable property. So if I have a right in respect of an immovable property, act affecting my right culminates into a dispute. So the disputes will be in respect of an agreement relating to immovable property. Hence, my lord, Roman 6. And since 202 says, this judgment says I am an agent. So, my lord, if I go back to the Commercial Courts Act, my lord, Roman 7, if I read with Roman 21 of the Commercial Courts Act, agreements relating to immovable property used exclusively in trade or commerce, my lord, coupled with.
That is the problem. Agreement relating to immovable property, it's okay. Use exclusive in trade and commerce.
Yes.
That is.
Yes. That is because, my lord, that is because it says. But it says agreement relating to immovable property used exclusively in trade or commerce. Now, my lord, I'll tell your lordship, my lord, if the situation would have been that the building is completed or actually in commercial, or it is presently being exploited as a commercial purpose, then lordship knows, if I would have constructed a shopping mall, then perhaps
That's why.
Yes, my lord, I'll answer your lordship's query. I understood, my lord, that if the last limb of Roman 7 says exclusively used in trade or commerce, since it is presently not being used, how will I be able to invoke the first part of Roman 7? My lord, may I answer this? My lord, by the time the shopping mall or the commercial complex would have been developed, or it would have been completely over or complete in all respects, and it would have been ready for use, my lord, by that time, my lord, the disputes between the parties would not have fructified at all, because by that time the development agreement would have achieved its course.
No, but you take the otherwise, the agreement entered.
Yes.
There are conditions, but it is not that whatever the tenants will be evicted, or they will be given floor area, or they will monitor the transaction, whatever it may be. But the sanction plan is to be obtained, but it is not mentioned with regard to the nature of the building which the contractor you have to construct.
Yes, I follow.
It is not mentioned. Either it is a commercial building, or only it is mentioned it is the flat, construction of the flats, and some portion what are the conditions. So if it is not, so whether it can be exclusive for the trade and commerce, one thing. Now, then if we come to the agency.
Yes.
Rightly, wrongly, whatever it is, agency, it's okay.
Yes.
Entered into an agreement, given an agency, entered into a power of attorney, you are the agent.
Yes.
Of the defendant.
Yes.
You are the agent.
Yes.
But this agency is to be connected with some of the criteria mentioned in 1 to 20.
Yes.
Correct. 1 to 20, first contact. 6, construction and infrastructure, including agreement relating to immovable property, that is stop. Use exclusive, that is.
Yes, I follow. I follow.
It's not here. Now kindly come to the joint venture agreement.
Yes.
If it is a joint venture agreement, so how it can be treated as a joint venture agreement?
Because if we both act together to achieve a common goal.
So that is your.
Yes.
Correct.
Now even I can also come under construction and infrastructure contract, including tenders. if construction rights have been given to me, which is in fact has been, then if I am an agent who has been appointed to construct, that can also be a commercial dispute.
Construction and infrastructure contracts, infrastructure contracts including
tenders.
But it should be related to the commercial.
Yes, yes, absolutely.
It should be related to the commercial.
Yes, it cannot be a residential building.
Residential.
Yes.
So that you have to prove whether it is the commercial building or it is the commercial apartment.
Yes,
or is
I'm grateful.
If I may only add to what my lord has pointed, if it is only exclusively for commercial use building or
Exactly.
otherwise.
I join issues. Now kindly see my lord, page 11, paragraph 33 of the plaint. I have said paragraph 33, page 11.
Yes, and fixed matter. Both parties are there.
I believe so, my lord.
Ready? If ready, then I will defer this.
I'm ready, my lord, with my matter.
Who is for the other side?
They were there when the matter was fixed in their presence, my lord.
If lordship takes up, I can come back on. But just to finish, just I want to show paragraph 33.
Paragraph 33
of my plaint. Of my plaint. Kindly see.
Page.
My lordship is looking at GA.
GA1.
GA1. If it's GA1, 258. Yes. Internal page 11 of the plaint, which is at page 275.
Yes.
Kindly see paragraph 33. The suit, it should be relates. The suit relates to commercial disputes within the meaning appended to such term under the Commercial Codes Act. The plaintiff seeks specific performance of a joint venture agreement for a commercial project.
Correct. That's what I'm telling. Commercial, you have mentioned.
Yes.
I agree with you. You show me from the contract, this is the commercial contract.
Intention was to build a commercial project.
That is the only thing. If you show that, you satisfied that, then the defendant will be out.
Man, that day yes, I would bow down to that. Malad, I will not say anything which is not there on record. Malad, since Malad, the agreement is silent, then Malad, I will fall back on the joint venture agreement. Because if it's a joint venture agreement, joint venture is that both of us will work together to achieve a common goal. And Malad, the clauses or the obligations envisaged are such that without both of us joining hands, the building cannot be constructed.
That's correct.
So it's joint venture. If it's joint venture, then I'm in Roman 11. Then, and as per the Ashok Kumar Jaiswal, I'm also an agent. So I can come under two criteria. One is Roman 11 and one is Roman 21.
So as per your case, if leave aside with regard to the used exclusively for that is missing in the agreement, then you will come to the 11 joint venture agreement.
Yes.
That has to be read with the 21.
21.
You are the agency.
Yes.
If you are the agency.
Yes.
If you are the agency and it is as per the terms and conditions, there are the joint venture.
Yes.
What is to be completed by you, what is to be completed by them, and if it is old, the agreement is to be read together, so it will come as a joint venture.
It will come as a joint venture.
And it can be treated as an agency under the clause 21.
Yes. If Malad, we both were, Malad, kindly see, Malad, I'll just give a small example. The agency issue could have been pulled out if we both were one side and we both were litigating with a third party. Then, Malad, the contract of agency would not have come into the picture.
That's a different thing.
But here, since there is two registered power of attorneys, and since I am the power of attorney holder,
correct,
which makes me an agent.
With regard to 21, there is no quarrel.
Yes, I'm grateful.
No quarrel.
With regard to the, because agency, if you are the attorney has admitted that attorney,
Yes.
so you are become an agency.
Yes.
Now only the agency is covered under the 1 to 20 or no.
Yes.
Now you are coming
Under joint venture.
under joint
Joint
venture.
venture.
Now the
Yes.
joint venture, how far the joint venture is to be treated as a commercial.
Yes.
That is to be taken.
Yes.
Okay, come on the next day.
Yes, my lord.
So and so appearing for the plaintiff, so and so appearing for the defendant. Counsel for the plaintiff has argued at length in connection with GA1 of 2020. GA1, na? GA2.
Minus GA2.
GA2.
My one is
2023, 2024, but due to paucity of time, hearing could not be completed. Let the matter appear on. Give the date.
Any date, let it to appear on Friday or
Fix
Monday.
nahi hai na? Let the matter appear
But may it appear on Monday?
on 9th of December.
Grateful.
9th of December as parted.
Lordship kindly marks it parted. Grateful.
Not complete.
And I fix at 345.
Solid.
Number 12 for the commercial.
My other side is here, my lord. My lord, I have
Malad,
chapter 13A application, my lord. My lord, they have already exhausted their rights since the writ of summons was served upon them on January 2024, my lord. So the stands exhausted. The right of WS stands exhausted, my lord. My lord, may claim on account of, my lord, procurement of diesel from the plaintiff by the defendant, my lord. I had my own, my lord, service station named after Woodland Service Station, and they have procured diesel for their purpose from time to time, my lord. Defendant procured diesel, my lord. Time to time, my lord, diesel was supplied. Consequently, my invoice were raised. My lord. I'm just taking your lordship to the documents after giving a short gamut of the fact, my lord. Time to time, my lord, supply was made of diesel. Thereafter, invoice was raised, my lord. And thereafter, my lord, there was followed by a demand notice, my lord, since they were not making payment, my lord. Thereafter, what had come, my lord, there was a ledger confirmation, my lord, and a balance confirmation as well, my lord. These are the documents, my lord. My lord, if I take your lordship kindly, my lord, the invoices, lordship will find from page 13 to page 28. Collectively marked, my lord, all the invoices, lordship will find, and the relevant averment are there at page 4, my lord, paragraph 9, where the invoices, my lord, and there, my lord, in bottom of the invoices, lordship will find their acknowledgement, my lord, and my lord, lordship will find the ledger confirm. Also, will find, my lord, in addition to that, my lord, the ledger confirmation on their part, lordship will find it starts from page 34 and ends up at page 41. And the relevant paragraph, my lord, is at para 6 at page 14, page 6 at para 14, my lord. But kindly come to invoices, lordship, from page 13 to
J2.
Yes, my lord, 13 to 20, my lord, 28. Yes, my lord, J2.
J2 application. 13 to
28, my lord.
Tax invoices.
Yes, my lord.
These are the tax invoices.
Yes, my lord.
Raised by you.
Yes, my lord. And my lord, my lord, kindly see, but at the bottom of every document, my lord, lordship will find the acknowledgement on the part of the defendant, lordship, that they had received the invoices, my lord. At the bottom, my lord.
Yes.
Right hand side, it is myself, my lord, Woodland Service Station, as I have just said.
Yes.
And at the bottom, my lord, middle bottom, lordship will find the receiving of the invoices is shown, my lord, consequential to such receiving. My lord will find, my lord, at page, my lord, kindly come to page 35 to 34 to 41. The collective, my lord, 34 page, I am taking your lordship to page 34 once, my lord. All back to back, my lord. 34 is Annexes C, my lord. Lordship will find, my lord, at the right hand side bottom, my lord, kindly see the amount, my lord.
27
It
lakhs.
is, yes, my lord. This is our principal demand, my lord, followed by the interest that is charged along with, my lord. And my lord, this is their acknowledgement, my lord, and my lord, that if I can say, my lord, that evasive, so far the, and we lordship will find our demand, my lord, and demand notice at page 30, my lord, and no reply certainly to such demand notice. Thereafter, non-starter lordship will find at page 43. Now, my lord, in defense, my lord, they have filed their opposition in that, my lord, in my chapter 13 application. Lordship will find, my lord, if I can say so, my lord, there is evasive denial, my lord, without any substantiation. And very interestingly, my lord, so far this ledger and so far they have put their endorsement or their hand as well as seal on the document. There is a, my lord, there is neither, my lord, any denial to such endorsement or their signature. There is no dispute as to signature nor as to their rubber stamp or rubber seal.
What is their defense?
That is my defense. We have taken that abutment.
Yes, my lord. But kindly come
What
to.
is their defense?
Yes, my lord. I'm reading my what is the defense, my lord. But it is stated my what on that ledger that they have given, but it is what is the assertion? Kindly see. It is stated that a ledger account annexed to the said application are not genuine. Page lordship, page 5, para 8. Last 3 lines, para 8. It is stated that the ledger accounts annexed to the said application are not genuine and has not been issued by the defendant. It is stated that the entire suit filed by the plaintiff is frivolous and not maintainable. Allegation I can bring sky high, everything, whatever I wish to.
Yes.
But there is no substantiation. And my lord, most importantly, my lord.
Litigation in chapter 13.
13. But most importantly, my lord, there is, my lord, no denial or no dispute, neither to the signature nor to the rubber stamp that has been used on their behalf. And my lord, lordship will find another at paragraph 9. That is, my lord, also the mere denial, if I can say. It is stated in the last 4 lines, my lord, paragraph 9 of same page, page 5. It is stated that the defendants have compelling reasons to defending the claim of the plaintiff, and as such, it is not an apt case of pronouncing summary judgment without recording oral evidence. It is stated there is no admission on behalf of the defendant. Where is the substantiation? Admitting the claim of the plaintiff, therefore the present application is liable to be dismissed. This is all about that I have found their assertion on their part. And it is stated, my lord, again, another mere denial, my lord, defines the paragraph, page 4, my lord.
Yes.
Second, third, and fourth, fifth line. It is stated that from top. It is stated that no negotiation was held between the defendant and the plaintiff to procure diesel from the service station of the plaintiff. Therefore, no terms or conditions was ever contested or approved and accepted by the defendant to the plaintiff. This is plethora of denial without a single substantiation. This is their case.
That's all.
That is the document itself. But kindly see page 34 to 41 that I have tried to indicate. Yes, my lord. Every page lordship will find their endorsement.
Yes. What about the notice served?
Yes, my lord.
Where is the service?
My lord, may I show?
Item delivered. No reply.
No reply. That I have.
No reply.
No reply, my lord.
Yes, sir.
My lord. My lord, the plaint filed by the plaintiff is on the procurement of diesel by my trucks from the plaintiff service station. Now, my lord, kindly sees, my lord, the plaintiff alleges that my trucks, series of my trucks, went to the service station and they filled the tanks of the trucks and therefore discharged. My lord, the amount claimed as such is over 10 lakhs, or it shows that the plaintiff gave the diesel on credit to the defendant, my lord. My lord, for a sum of almost
27 lakh.
My lord, the summary judgment is claimed on rupees
31 lakh.
31 lakhs, my lord.
That is 17.
My lord, for such a big sum, the plaintiff, who is the proprietor of the Woodland Service Center, who claims that his service center is one of the top service centers of Hindustan Petroleum, wouldn't execute an agreement with the defendant before giving off so much amount of diesel over to the defendant trucks over a series period of time. That is my point 1, my lord. My lord, my second point is these endorsements in various ledgers, my lord, starting from page number
34 onward.
No, my lord, in the application, the first ledger that was issued, my lord, page number 14. My lord, kindly comes to page number 14, my lord, of the G8.
Yes.
My lord, the first ledger was issued
First tax invoice was issued on 27th October 2022. My lord, 27th October, my lord. Again,
To the page 14.
Page 14. My lord, beg my forgiveness. My lord, page number 13. The first bill was issued on October 26.
Correct.
My lord, the vehicle numbers are incomplete in the ledger. My lord, the vehicle number as per the registration has to be in full. These are the last four numbers, my lord. It cannot be verified by this tax invoice whether these vehicles belong to me or not, in absence of an agreement.
Where is your contention in that?
Just
Where is the contention that the page 13 annexure A, how you are dealt with in your
Well.
affidavit in opposition? Annexure A. Paragraph 9.
Well, paragraph page 5, paragraph 8, my lord.
Finally come to the paragraph, page 4, paragraph 7. You have dealt with the paragraph 9 to 11.
My lord.
Wherein the tax invoices has been recorded.
My lord.
Read it. Paragraph 7 of your affidavit.
It is denied and disputed that with a passage of time, an amount of rupees 26,83,361 fell due and payable. It is denied that the defendant, in spite of availing such services from the plaintiff, the defendant failed and or neglected to make over payments to the plaintiff. Furthermore, the amounts as stated under the respective invoices are denied and disputed. It is denied that the defendant availed any such service amounting to such amount from the plaintiff. My lord, we have categorically denied that we.
No, what you have made submission here.
My lord.
With regard to kindly come to the page 2413. You have made submission before this court. The vehicle number is not mentioned, so you cannot identify the vehicle. So it is very difficult. But that is not the defense you have taken in your affidavit in opposition, sir.
My lord.
Which you have not taken in affidavit in opposition through verbal argument. The court cannot that too under order 37 13 of the CPC.
My lord, even then, my lord, I have denied that there has been a transaction or an agreement in respect of procurement of diesel with the plaintiff, my lord, and such is a tribal issue, my lord.
What issue? Tell me, what is the tribal issue?
My lord, number one, my lord, whether there was an agreement or not.
No,
they
have not relied upon any agreement.
My lord, they have
stated that your vehicle, they are the petrol pump dealer, they are the dealer. You purchase the diesel from time to time. He has raised the invoices. You have not paid the amount.
My lord, in the plaint, my lord, they had in paragraph 3, they had stated that the defendant had negotiated for purpose of providing such services and the plaintiff agreed to provide such services in credit. It is that statement, my lord. But that statement needs to be substantiated by way of an agreement or by way of a letter which is issued by my company to the plaintiff substation stating that these are my vehicles, denoting in my letterhead, denoting that these are my vehicles and these vehicles will go to your service station and obtain diesel. But this is not the case by the plaintiff. The plaintiff states that there was a negotiation. Thereafter, there was an agreement where I agree to sell diesel on credit. That statement has to be substantiated by a letter at least, my lord. Number one, my lord. So at the threshold, the case of the plaintiff is doubtful whether the plaintiff issued these diesel to my vehicles or not.
Is there any case made out that there is no relationship between you and the plaintiff and the defendant with regard to the delivery or supply of the diesel? Where is the case made out? Show me.
My lord, in our affidavit of opposition, my lord,
show me.
In paragraph number 6, my lord, we have denied the negotiation. We have denied that the plaintiff send us WhatsApp messages as invoices. We have denied that. And in an event, the plaintiff who claims that he had sent us invoices via WhatsApp ought to have relied in their application. They have not also relied. They have made a bare statement stating that after 15 days, we had issued tax invoices.
Okay, do one thing. You try the matter, no problem. You wanted to let the suit be come into trial. I will give, but you deposit the amount in the registry. No problem. I will allow. You prove the case, and it will be in the interest bearing. If you got the case, the suit will be dismissed. You will get the amount along with the interest, which will be deposited in that. This court can support you. If you say that, you take the instruction.
For that, I need to take instructions, my
Then,
lord.
if
I'll-
you're telling that you want this is the trial, you can press. Then on that score, in the court can send the trial subject to payment of the amount deposit in the court.
My lord, if my lord pleases to adjourn the matter for some later hearing, my lord, I shall come up with necessary instructions, my lord, and I shall show.
Not instruction. I am
Well-
telling how soon you will pay the amount.
My lord, I need to take instructions, my lord. for
What
that.
instruction? Court is passing an order.
My lord, now kindly gives me a time to obtain necessary instructions, my lord.
What
I shall
instructions,
come.
sir?
Whether the defendant would.
Because your case is that you will prove during the trial, though you have not made out any case.
My lord.
You have not made out any case. What you are making the argument?
My lord.
Suppose the court give but you have to deposit the amount as a security.
My lord, for that I need instructions, my lord. My lord, also, my lord, I may indicate, my lord, the suit itself is not maintainable, my lord.
Why?
My lord, kindly see, my lord. My address is outside the jurisdiction of this court.
Correct.
The defendant's address is outside the jurisdiction of this court.
Where is the defense you raised?
My lord,
Where is the defense
my
you
lord,
raised?
we have stated in the affidavit that the suit is not maintainable.
Show me. The court is not having jurisdiction.
My lord, there is a statement, my lord, that the suit is not maintainable, my lord.
Maintainable is different thing. Jurisdiction is different thing.
My lord. My lord, so my lord, this court doesn't have the jurisdiction because the cause of action.
Where is the pleading? Jurisdiction. And jurisdiction, not only simple jurisdiction, you have to explain.
My lord, that has been missing, my lord. My lord, kindly seize, my lord.
You granted. Clause 12.
My
Clause
lord.
12 was granted. You are not paid for a revocation of the leave. Then
My lord.
now this court in the coordinate jurisdiction can say that this court is not having the jurisdiction unless they have filed an application here.
My lord.
Should I give a very short reply if your lordship wants to?
My lord, let me come back with the necessary instructions, my lord.
Nothing.
My lord, kindly gives me, my lord, takes it up on Friday. I'll come back with necessary instructions, my lord.
For what?
My lord, whether the defendant would be agreeable to submit bank guarantee to the
Bank guarantee, cash.
cash.
Deposit the amount with the registrar. The
prayer
registrar will invest the same in the fixed deposit till the
interest-bearing
disposal of the suit. If the suit will be dismissed, you will take the amount. If the suit will be decreed, he will take the amount.
Whether they will give it to us or to the let this instruction let it be taken. Because this is our prayer.
My lord,
in this
my lord, kindly,
application.
with that respect, my lord, kindly let me take instructions, my lord.
The hearing is concluded, lordship.
My lord,
Suffering for the plaintiff, suffering for the defendant. Full stop. The plaintiff has filed an application being GA Form 2 of 2024 under Order 13 capital A of the Code of Civil Procedure for summary judgment. Full stop. Hearing concluded. Full stop. Counsel for the defendant press for time to take instruction whether what instruction you will take?
whether my lord, the defendant is agreeable to deposit monies with the registrar or agent side, my lord.
Not to us.
My lord,
Let the
my lord,
order.
But that is
My lord, we'll
voluntary lock up.
deposit it and this to the registrar original side. At least this is the
That doesn't avert any
Take
instruction.
instruction from the defendant. How much time, for what time the defendant will deposit the amount with the registrar of this court? By which time?
Or
the
to one of the
defendant
plaintiff.
will deposit the amount claimed by the plaintiff with the registrar of this court. Registrar or no certificate. Let the matter appear on
Yes, madam.
6th December 2024 at the top under the heading order part head. Under the heading order. Yes.
Under the heading parted, Lord?
Order.
Order. Yes.
Yes, next.
Grateful, madam.
Well, this is my application. There are two applications. One is a Section 5 application. The other one is an Order 9 Rule 13 application. Well,
I'm for the plaintiff, Lordship, where the decree was passed, Lordship, long back in 2022, Lordship.
well, the affidavit in opposition has been filed. Well, we have prepared the reply, but it couldn't be affirmed because, well, my client is based in Bangladesh. He'll need at least 30 days to come. He has applied for the visa.
Well, this is the
Suit of
instruction.
2018.
Yes, Lordship, and the
my lord.
decree was
Decrees
made on
of
22nd November 2022, Lordship.
No, this court is not 2018.
No, Lordship, this decree,
No,
Lordship.
this is a recalling, my lord.
Lordship's decree, Lordship, this
What
is,
can be?
Lordship will kindly consider the provision of Order 9, Rule 13. The same court should consider. Lordship will kindly allow me to submit on this then in that event,
What
Lordship.
for the?
I'm for the plaintiff, Lordship.
The decree holder as of date.
I'm the decree holder.
Ah.
Lordship will kindly consider the provision. May I place the provision, Lordship? It is clear that this court shall have, only this court can hear the matter. Order 9, Rule 13. I don't think my learned friend is opposing this submission.
No, I'm not.
We are both, Lordship, then that even kindly consider that
My
this
consent determination cannot be changed
Lordship, the
unless
determination arises, Lordship, this arises from the decree that was passed in 2022 when your Lordship was having jurisdiction, Lordship. Determination, rather.
no, there is no jurisdiction. Order 9 Rule
Well,
13.
because it is a recalling of your lordship's order, it's always before the same honorable judge. My lord.
Even section 151 and recalling. General recalling is always before the court having passing the order. He may apply to the court by which the decree was passed.
Yes. Yes. You will file affidavit.
Lordship, my affidavit is complete. Opposition. My learned friend needs to file reply if he intends to.
You will not file
We
reply.
have to. We have to, my lord. The defendant bank is based in, my lord, Bangladesh. As of the present condition, my lord, visas are not being issued in the normal usual course.
It is a good time to visit the Bangladesh.
For us, it is not at all good. For them to come, it's the best time.
In spite of that, his client is not coming down to a form.
The instruction from the deponent that he is having the visa issue.
They get a copy though.
Okay.
She will keep it in the new year. Yes.
Take it on.
Yes.
Order not challenged.
No, it was Lordship initially.
We challenged it. The Honorable Division Bench advised us to come back before your lordship.
Lordship, because the appeal was otherwise beyond time. Lord, even in this application is 616 days delayed.
Has to be.
Plaintiff. You are appearing for madam?
For defendants, madam.
Defend number 2, my lord. Yes.
Mr.
For the
Ghosh.
defendant number 2. Counsel for the defendant submitted due to the issues with regard to the visas in Bangladesh, the defendant number 2 is not in position to affirm the affidavit in reply to the affidavit in opposition filed by the plaintiff in connection with GA 3 of 2024 and prayed for extension of time to file affidavit in reply.
My lord, GA number 3 and 4.
3 and 4. What is the 4?
The 3 is section 5, 4 is the application.
GA 3 and GA 4 of 2024. Considering the submission made by the counsel for the defendant, time to file affidavit in reply in connection with GA3 and GA. Both you have filed affidavit?
Yes, oppositions are complete.
GA3 and GA4 of 2024 is extended for a further period of 2 weeks from date. Let the matter appear on.
Lordship, sometime in January or
3 weeks version. 3 weeks. Let the matter appear on 7th January 2020.
very
Grateful.